right. Co-defendant Devonte Dean. That is your case, Ms. Wood. Both of them. Okay. All right. Is here. Ms. Hall, I'll ask you first. Is there a reason to do Mr. Brown separately from Mr. Dean? And is there an order in which you'd like to go?
This is a case where I was referred to present here, I was referred to Brown. Oh, yes, Mr. Antonio Brown first, and once he gets this, then the state will waive the on the Dean.
Brown, then Dean.
Yes.
Got it. Okay. How about Rhonda Gore? All right. I know Mr. Whitenauer is on the call. We just can't hear anyone yet on the call. It's kind of exciting. They have to listen to me, but I don't have to listen to them. Keep that up. Position 6, Mr. O'Neill. Mr. O'Neill, we will bring out at the appropriate time to figure out what's happening with representation. Mr. Gaffney has been allowed to withdraw. I believe Mr. O'Neill's co-defendant already pled, Ms. Hall. This is the van that crashes and someone's got a broken leg and blood all over him, but claiming that I wasn't the one in the van, was ejected from the van. I think that's Mr. O'Neill. So we'll figure out if he's hiring someone. I don't think he is. If he's not, who represented the co-defendant? Ms. Patel did. Okay. So then Mr. Webb would likely inherit Mr. O'Neill's case. I don't expect you to know anything about it, Mr. Webb. Other than that, there's lots to learn, and from the little I've heard, it'll be a tricky one for you. But they are, well, some are trickier than others. But we'll find that out. We'll bring Mr. O'Neill out. Then we have Prince Charles, who I know from drug court. Great. And is Mr. Charles? Yes. Yes. Great. Thank you. Then Quentin McKenzie, who is 3 of the positions here and has some probation revocation matters that we'll deal with on Friday if today doesn't take care of everything. Okay, so you're close, but not overlapping. Is that? Okay. So we'll get him out here to do that. And we've got then Ms. Hubbard, who is on the call. I see her right there.
Hey, good morning.
I think that's Ms. Patel's case. So right now, I can't hear from Ms. Patel, but Ms. Hall, what's your understanding of what we're doing with Ms. Hubbard's case today? Negotiated plea. Great. Okay. Well, we've gotten through calling the calendar. Is hopefully someone from IT is okay. All right. So it sounds like people online can hear from here, but they can't hear each other, and we certainly can't hear.
I heard Miss Hubbard.
Yes. How about coming down?
Yes, good morning.
Okay. So what does she want? I don't know, but I should be able to add it. Why don't I remove it and add it again? See what happens. It won't let me launch the controller. It says Zoom Rooms is offline. They need to come down here. I think so. I think we'll start with Mr. Brown. He doesn't need to come out quite yet because I don't want him to just sit there unless you all have agreed that something else is going to, obviously Brown before Dean, but if we're going through the calendar in order, then we start with Horn first, but that's got a few moving parts right now. So I thought we'd do Mr. Brown. Was there something else you wanted to do first? Okay. Got it. Ooh, something just happened that was good.
We do one of them, have take them, they got it, I can bring the female up.
Got it.
Get an order.
Oh, I'm hearing all sorts of stuff now. All right.
Can you hear us, Judge McBurney?
Oh, yes. Now you guys are back. Look at that. What did we do? Oh, fantastic. All right. So let me do a couple things. Ms. Hubbard, I'm going to mute your phone for right now, okay?
Okay.
So we'll never know. Ms. Rivers, are you able to hear me? I guess you always were. Can I hear you now?
Yes, can you hear me?
I can. It's great to hear your
Okay.
voice.
Okay, great. I'm already set to go.
Okay. We're all set. I don't know what happened. Ms. Nelson fixed it. Okay, someone fixed it. Oh, you know what we have? We have the podium from another courtroom in here. I'll get rid of 8As. We had the wrong podium. So we were taking over 8A. That's awkward. Bye, 8A. Judge Barwick called. Why do I hear McBurney? Okay, we had the wrong podium in here. Mr. Webb, tell me what works best for you, given what you're working through with the knee. Would it be better? You've got several pleas for you to be seated at council table or standing up at the podium. That'll drive where we bring the defendants.
Whatever your monitor wants me to do.
I'm, as long as Ms. Rivers can hear you, I'm okay if you're in the back of the courtroom, in the jury box, wherever. So
If I
if
could
it's,
sit at council table, that would probably help.
why don't we do that? And then why don't we also remove, unless someone wants it, the plexiglass is right now serving no purpose. So if we got that off there, but yeah, don't you do it. It's a two-hand thing because those little pieces will plop out. And we will bring Mr. Brown out.
How you doing?
Thank you, Your Honor.
How's your birthday?
I knew there was a reason Mr. Abate was here.
Good for something.
Something.
What are we
You all right? Oh, yeah.
It depends. I'm doing a procedure tomorrow. It's a nerve ablation. Freeze the.
That's funny. Yeah, I didn't notice it either.
So we're ready for Brown?
We are. When you're ready, please.
Want to make sure.
Yep. No, thank you.
You gotta have an order going on.
Yeah, I'm
Mr. Abate,
yes, sir.
what is your understanding of where we are with the Kare Williams case?
So I was actually just texting Mr. Jacobs. He has waited a little bit longer than I had expected to get his order signed for a contact visit. So he is supposed to go tomorrow.
Okay.
And he said he'd let me know something tomorrow afternoon or Friday morning. My gut says it would likely be a negotiated plea based on our conversations, but I'll know for sure on Friday.
Okay. I only know from what I heard from Mr. Pinion and Mr. Jacobs. I mean, we're always together on that. It just didn't seem like there was a lot of wiggle room for Mr. Williams in that one.
He was sort of this
And wrong way on the connector is kind of, I don't know what the defense would, but we'll see. Okay. Because I'm hearing that the other case that was set to go on the 30th may be resolving, but Williams was ahead of it anyway. So we'll focus on that.
And that's what we were just discussing the last case. I think it's on there. It's Mr. Roberson and Miss.
Oh, right. Good.
Seeing how his medical situation is, because I don't want to subpoena people for no reason.
Okay. Well, we can talk about that as a group.
Yes, sir.
We're going to focus on Mr. Brown now.
God, my thank you.
You too. All right. We've got position 2 on our calendar. It's 20 SC 174164, State versus Antonio Brown. Mr. Brown is here in court with his lawyer, Mr. Webb. Ms. Hall, the prosecutor, is also in court. And my understanding, Mr. Brown, is that you are prepared to enter what we call a non-negotiated plea, where you and your lawyer are going to recommend that I sentence you to some number. Ms. Hall is going to recommend a different number, probably a higher one. That's why it's non-negotiated. And I'll listen to both sides and then let you know what I think the appropriate sentence is, given the facts of this case, what I learn about you, what I hear from the victim, et cetera. Is that your understanding of what we're doing today?
Yes, sir.
Okay. Any questions about that?
Yes, sir. So if
Needs some help with that. Okay. Try and speak again.
so if you was to give me a number or time, and if I don't like it, could I deny it?
So I don't remember where, I understand your question. And I don't remember where we are in the process. Do you remember, Ms. Hall? Does Mr. Brown still have his ability to withdraw, or did we cross that bridge? His old case? I just don't remember.
When we were in court last, Your Honor, the state made a recommendation. I put an expiration on it last Thursday.
Yep.
Which was, Veterans Day, so I moved it to Friday. You told him at that moment that if he did not, his rights were no longer reserved for today.
Okay. That was my recollection as well. Mr. Webb, do you have a different recollection?
No, Your Honor. It was a little bit confusing to me. I know the court thoroughly explained to him that if the plea offer expired, then he could go non-negotiated. But I don't actually recall that you said that he could withdraw it if it. I guess generally on a non-negotiated plea, it's my experience that you cannot withdraw.
Correct. Unless, if this were off a plea and arraignment calendar and it was non-negotiated, certainly the final plea rights would still be there.
Sure.
So, Mr. Brown, I think we've reached the point, since your trial date is right around the corner, that you always have the right to enter a plea. And it can be non-negotiated. So Mr. Webb is going to recommend something. I know you and I talked about, he could recommend less than 10 years, but that's not a legally valid recommendation. The armed robbery has a 10-year minimum. So the lowest Mr. Webb could go on your behalf would be 10. Armed robbery carries a penalty of up to life. So I don't know what Ms. Hall is going to recommend. She could be recommending life. It ought not to be a surprise to you, because she should have told Mr. Webb what she's going to be recommending. And then I will, as I said, listen to everything that is shared during the conversation and decide what I think is a reasonable outcome based on the input that I get. So I don't think at this point, well, let me get one more piece of data. What is your understanding, Ms. Wood, about Mr. Dean's final plea rights?
Judge, if I remember correctly, and I forgot my laptop, so I don't have my Odyssey, I thought that Attorney Franklin had preserved them. So I was under the impression that they were still active. I know ADA Hall and I have had numerous negotiations about today's non-negotiated plea. So I know Mr. Dean and I, though, did not come out at the court date that Mr. Webb is speaking of and put anything on the record. So
Right.
that makes a difference.
Well, it doesn't, I mean, it's clear from when we were last together, which was the 4th of November, Mr. Brown had his final plea rights. But that's why we had that whole conversation with Mr. Brown about how long the state would keep the offer open and how long the final plea rights would be in effect. I don't have a specific recollection, but I don't have anything in my mind that contradicts what Ms. Hall recalls, which is that Mr. Brown had a little bit of time after the 4th to be thinking, what is it he want to do if he wanted to enter a plea where he could withdraw the plea if he's unhappy with it. My thought is to just so that we've got sort of equal situation for everyone. Mr. Brown, you may, if you don't like the sentence that I pronounced today, you can withdraw your plea. But then the next stop will be a trial for you on the 30th of November. And whatever happens, happens there. And that's not a situation where you get to withdraw anything. Okay?
Sure.
So did I answer the question in a way that you understood it? We talked a whole lot. It was a fair question. I took a while to figure out the answer.
I mean, I understand just trial. I feel like trial just coming up a little too soon.
Well, that's one way to look at it. This situation that you're accused of occurred, I mean, you were indicted in January of 2020. So your indictment is coming up on 2 years old. And the situation for which you were indicted involves allegations from December of 2019. So just about 2 years ago. Some folks would say that your trial has taken too long to get here, but obviously COVID got in the way. Either way, Mr. Brown, you don't need to worry about that. That part you don't control. The 30th is when you go to trial. Today is the day to see if you're going to work it out by way of a plea. If you don't like the outcome of today, you have the ability to say, no, thank you. I would rather go to trial.
Yes, sir.
Okay?
Yes. And
All right.
Can I ask one more question?
Sure. You can actually, one of the things I'm about to tell you is you should ask all the questions you've got because I need to be comfortable that you understood everything we were working through. So what's question 2?
Okay. And besides whether I take this or not, do I have a chance, if I was to go to trial, chance to have a bond, to work it from the outs or anything like that? Because I do have a child that I'm missing out on that I do want to be a part of.
Understood. And that will come later in your life. But bond is not on the table right now. I don't foresee, Mr. Webb could always file a motion for bond. But I think the right next step, if it doesn't work out today, is to get 12 members of the community in here to hear about what this case is about and to decide whether the state can prove beyond a reasonable doubt that you robbed Ms. Gilbert and you shot Ms. Gilbert. And if they decide that, we go to sentencing. If they decide the state didn't do it, then you don't need a bond because the jury will have found you not guilty.
Yes, sir.
All right. Any other questions at this point?
No, sir.
All right. So in a moment, Ms. Hall is going to put you under oath. Once you're under oath, you need to answer all of her questions, truthfully and completely. You also need to keep doing what you've been doing, which is ask questions if you've got any. You lean over and ask Mr. Webb, you ask me, and we'll make sure that we take the time to answer your questions. Will you do that?
Yes, sir.
All right. Ms. Hall?
Thank you, Your Honor. Mr. Brown, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Can you please state your true, correct, and legal name?
Antonio Brown.
And Mr. Brown, you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
19. I stopped at 11th grade.
And you have not received a GED or anything else?
No, ma'am.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with armed robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony?
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to those charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defense?
No, ma'am.
You said no?
No, ma'am.
So we need to stop then. So Mr. Brown, I can't take a plea if you feel like I shouldn't, and I won't. If you feel like you need to spend more time with Mr. Webb. If you need more time with Mr. Webb, you should do that. But that just means we'll probably see you on the 30th for the trial. You've had months and months and months to be thinking about what you want to do with this case. And today I thought was the time that we would be discussing the plea. But if you're not ready to do that, we need to stop. You're the one who needs to be ready.
Okay.
The trial part, I don't ask you if you're ready. I ask your lawyer if he's ready. And you may say, I want more time, but that time is up. It is time for closure. Ms. Gilbert needs closure. You and your family need closure, but I'm happy to pause right now and you and Mr. Webb can talk some more, and then I'll bring you both back out and you can give me a report of, you know what, Judge, it's not going to happen today, but then we're done and I will see you on the 30th for the trial. We don't need to bring you back for another attempt to do what we're doing today, because I was with you a couple weeks ago and we talked about what the options were and what you needed to be thinking through. So I respect your announcement that you need more time. You just need to understand that today is a day for a plea. If you don't want to do that, I am fine with that. But then the only other thing that happens is a trial, and that's on the 30th. And we'll bring the jurors in and they will see whatever video there is. They'll hear whatever testimony there is. I don't know how good the case is for the state or not, but that's what you'll be up against. Does that make sense?
Yes, sir. I say I needed more time because the whole time I've been incarcerated, only time I talked about my cases when I came to court. I didn't have no visits, none of this I don't even know about this case. This is the only time I have talked in the courtroom. I don't know.
Okay.
I feel like this, I don't put up a fight for nothing.
Okay, Mr. Webb,
May I put something on the record, Your Honor?
please.
The last time that we were in court here, after I had visited with Mr. Brown at the jail, I conveyed to him the state's offer, which he, of course, did not like, but I also offered to have him come in and watch the video that the state had, video evidence, go over the discovery in his case. And I was informed by one of the deputies that Mr. Brown said he did not want to come back into court. He did not want to go over the discovery. He wanted to be taken back. So he was taken back to the jail. I've since seen him again at the jail and gone over his case. I've spoken with his custodial parent or aunt. And I believe she's here, at least her sisters are here in the courtroom. So with regard to any allegations that I have not properly spent time with Mr. Brown, I want the record to reflect that that is not true in my professional opinion.
Okay, no, I appreciate that. I also understand, given these are serious allegations, Mr. Brown may have a set of expectations that don't necessarily align with the realities of your workload or another attorney's workload, but Mr. Brown is not in a position to have hired an attorney who might say, I'll devote X, Y, or Z to this case. So I appreciate you adding that context, Mr. Webb. I also believe that Mr. Brown knows full well what this case is about and what the allegations are. He and I have been working on this case together for a while. So I respect his desire for more time. I'll repeat one last time, and then I'm gonna let you go back to lockup. Your choices are spend some time with Mr. Webb today to think through whether you want to go forward with a non-negotiated plea today, or I'll see you on the 30th and we're going to pick a jury in your case. There have been almost 2 years for you to be thinking about what you want to do. And I hear you loud and clear that a lawyer didn't visit you every day. But that's not what would happen with any defendant. You're not going to find anyone at Rice Street who says, yep, I talk with my lawyer every day. There's never enough time with the lawyer. That's what folks often feel. So I'm going to have the deputies take you back into lockup. When Mr. Webb is freed up, he'll talk with you, and then both of you can come back out and we'll get on the record, Mr. Brown, what it is you want to do. Okay?
Yes, sir.
All right. So I think what we'll do, Ms. Bumpus, are you in a position to handle Mr. Horn's case?
Yes, Your Honor, as long as the court is okay with my video not working.
I'm all right with that. We'll make sure Mr. Horn is okay with that. He'll have to look at a picture of you standing like on a wall near a mountain or something. Before we bring Mr. Horn out, though, I just want to understand, before, I think we were going to sort the case out, and then a bunch of revocations popped up. And I don't remember if Ms. Beza needed a chance to look at that, or you did, or both of you, but I don't want to bring Mr. Horn out unless you have a sense, Ms. Bumpus, that the stars are aligned and it makes sense to go forward, whether it's negotiated or non-negotiated.
Yes, Your Honor, I do believe that the state and ADA Base are pretty close on what we agreed upon. However, it's my understanding that probation was asking for a little bit more time. Is that correct?
Yes, Your Honor. So I've spoken with probation for the 4 open cases. They stated that their recommendation would be to revoke 2 years on each case to run concurrent. It's the state's position that as part of our plea today for the current DV case, the state's recommendation is 10 serve 1, balance probated. It's the state's position that we revoke 1 year on each of the probation cases, commute that to time served, close those out, so then we can have 1 open probation case, and that would be the new DV case, and he would have an additional 9 or so years, on probation, and we have 1 case moving forward. I think that makes the most sense.
Was just so I understand, and then I want to make sure Mr. Horn gets out here. You were saying that your recommendation on the revocation was 1 year, but reduced to time served. Mr. Webb, thank you for going back there.
Oh, you're welcome.
Take the time you need.
Okay for me to leave?
Please. Well, you're not leaving. You're going in there. It's where I need you to go. The 10 to serve 1, is that 1 year also reduced to time served, or is that 1 year to serve?
After speaking with the victims, it is 1 year is reduced to time served, balance probated.
Okay.
And I just think he's couple. Oops, sorry.
And then the family violence.
Sorry, I think he's just a month or less short of a year too, Your Honor.
Okay. All right. I'm hearing all this. Obviously, I'm not bound by it, but that's just helpful to know. And I'll certainly hear from Officer Brown as well. She's on this call, and I'll hear from her. But it sounds like Mr. Horn is interested in trying to resolve all this, and we ought to do that. So are you ready to go forward, Ms. Beza, if we bring Mr. Horn out?
I am ready to go forward, Your Honor, but I will say that the probation officer that I spoke with was Mr. Horn's probation officer.
Okay.
And her name is Miss Toinetta Davis.
Okay. Well, I don't see her on the call, but
yeah, no, she's not going to come on the call. Yeah.
All right. But we got Officer Brown from probation to help us work through all this. All right. Well, let's bring Mr. Horn out. Can Mr. Webb stay back there while Horn is out here?
No, sir. I'll check though.
Okay.
Coach, do you want him at this seat or up there? I can move.
One, I think you're welcome to stay. You may not want to sit with him, but I'll have him be up at the podium. Since he's flying solo, it'll just be easier. So be at that screen. And we're holding off on Mr. Dean while Mr. Brown is working through his situation. So we'll do Ms. Gore after we do Mr. Horn. Oh, right. We have to hold off on Gore. That's right. We'll probably do.
We're ready on Mr. Charles. And he
Yep.
signed up.
We'll do that. We'll do Mr. Charles after we do Mr. Horn.
Sir, as soon as they get through, you can't leave from that device. So
Okay, then he'll need to come out, and maybe we'll get a third deputy at some point, but I want to make sure we start moving some. He could be back there for 30 minutes, so we'll take some pleas, and he can get back there when we're taking a break, or you get additional staffing. That'd be great if we get one more person. Horn, please. Please. Mr. Webb, we don't have enough folks right now. We're making a request, see if we can get an extra deputy so that you could be back there, because we're going to try to do a few non-web cases.
He's ready to do non-negotiated, Your Honor.
Oh, well, that was quick. We're going to do Mr. Horn anyway,
All right.
because we've set that up. Ms. Bumpus is ready. And then when we're done with Mr. Horn, you can double check. You're ready to do that.
All right.
And we'll bring him out. Thank you.
I'll speak to his family in the meantime.
Okay.
What did you say, Judge?
Mr. Horn, and he can come to the podium. His lawyer is remote. Thank you. Mr. Horn, if you would come out to the podium, please.
how you doing today?
I'm doing all right. How are you?
All right.
So, can Deputy Warren, can you turn the monitor a little bit? The monitor rotates. It's catching Mr. Horn's ear. If you slide over a little bit, Mr. Horn.
I hear
No, your ear's good. I was just saying that all we were seeing was your ear.
Oh,
if you look on the screen, your ear's very handsome, but that wasn't my point. There you go. Perfect. All right, because I need Ms. Bumpus to be able to see you. So, Mr. Horn, you are out here. I have been told, because you're interested in entering a plea to your case like you were last time. But we have these 4 probation matters that caught up. We're trying to resolve everything at once. Is that your understanding?
Yes, sir.
Okay. So Ms. Bumpus is on your screen. You'll see a lot of people on your screen, but she is listed there. Her video isn't working, so it's just a still picture of her in some exotic location. But she is here and ready to move forward. Are you comfortable, Mr. Horn, going forward with Ms. Bumpus being in a different place?
Yes, sir.
Okay. If you have any questions and need to ask her something in private, let me know. I'm not quite sure how we'll pull that off, but we'll figure out a way to do it.
Yes, sir.
But it sounds like she's done a real good job of talking with you. And I think she knows what's coming and you know what's coming. So hopefully we can get through it with Ms. Bumpus being remote. The prosecutor is also on your screen as opposed to being here in court. And she's going to put you under oath in just a moment. Once you're under oath, I need you to answer all the questions that you understand truthfully and completely. But I also need you to let me know if someone asks you something that you don't understand. The questions are not meant to be tricky, but sometimes people word things in a funny way. And if ever we're doing what we're doing and you're not following it, I need you to say, wait, explain that. Okay,
Uh,
great. All right, Ms. Beza, when you're ready.
Good morning, Mr. Horn.
How you doing?
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may put your hand down.
Thank you.
Please state your true, correct, and legal name.
Stephen Matson Horn, Jr.
Are you at this time taking on the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
I'm 31 years of age. I went to 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses? Counts 1 through 5 on the indictment is aggravated assault with a deadly weapon. Count 6, possession of a firearm during commission of a felony. Count 7, cruelty to children. And count 8 and 9, simple battery, family violence.
Yes.
And do you understand that you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
And have you had enough time to speak with your lawyer, Ms. Kayla Bumpus, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Bumpus, do you waive formal reading of the indictment?
So wait,
And Ms. Bumpus, do you waive any and all defects in the indictment?
for purposes of this plea only.
Mr. Horn, have you previously been arrested on these charges?
No, ma'am.
Were you arrested on the charges that I read in the indictment?
Oh, yes, ma'am.
Okay.
Yes, ma'am.
Now, currently, the state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
Ms. Bumpus,
No, I do not.
has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading to?
Yes, ma'am.
For counts 1 through 5, aggravated assault with a deadly weapon, the minimum and maximums are 1 year to 20 years. Count 6, possession of a firearm during commission of a felony, that has a mandatory of 10 years because of a prior conviction. Count 7 through 9, because those are misdemeanors, minimum is 1 day, maximum is 12 months. Now, you understand that this is a negotiated plea of guilty, which
Yes, ma'am.
means that the state will recommend a sentence to the court of 10 years to serve 1, commuted to time served, balance probated, the Family Violence Intervention Program. In addition, as part of the plea, it'll be no violent contact with Lakeda Nance, Lakeeda, and Brendan Nance, BRIEDENNANCE, and further, no contact with Charlie Nance, Jeff Nance, and Forenstein Nance. You understand that that's the state's recommendation.
Yes, ma'am.
As to the probation matters, the state's recommendation is 1 year, revoke 1 year, and all 4 matters to run concurrent, commuted to time served, and in addition, terminate the open probation matters as there are only 2 to 3 years left on each of them. You understand that that is the state's recommendation regarding the probation matters.
Yes, ma'am.
But the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other. You understand?
Yes, ma'am.
You understand that this plea may be used to enhance sentences on other convictions in this jurisdiction, as well as in other jurisdictions included in federal court.
Yes, ma'am.
And do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea?
Yes, ma'am.
And do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am. Very clear.
Very
understand-
clear? Yeah, I would think by now it would be very clear. Okay.
And do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be a conviction following a trial? For example, your guilty plea conviction may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, ma'am.
And do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
And you understand that by pleading guilty, you are giving up the following rights. You are giving up the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial.
Yes, ma'am.
Has anyone forced you, threatened you, or promised you anything to get you to enter a guilty plea?
No, ma'am.
And Your Honor, I forgot to mention prior about the state's recommendation. Count number 6, the state would recommend to be null prost.
Okay.
So how do you plead to the charges in indictment 21 SC 179411?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that you have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Your Honor, as to Mr. Horn's criminal record, he has 10 felony convictions, mostly drugs. In a 2008 case out of Fulton, an armed robbery and an aggravated assault. 2009, willful obstruction of law enforcement officer. 2013, possession of marijuana. 2014, he has 2 cases, sale of a controlled substance and possession of sale of marijuana. 2017, possession of marijuana. 2018, an aggravated assault and possession or sale of marijuana, and a 2019 sale of marijuana. In addition, if this case would have proceeded to trial, the state would have expected its evidence to show that on August 22nd of 2020 at approximately 11:11 p.m., Officer Holmes was dispatched to 1391 Lorenzo Drive Southwest here in Fulton County in a response to an assault. Upon arrival, Officer Holmes made contact with the victim, Miss Lakita Nance, who is the mother of the defendant's child. They share a child in common. That child's name is Brendan Nance. Miss Nance told police that her and Mr. Horn got into a verbal dispute about Mr. Horn purchasing diapers. The dispute turned into a physical altercation between Mr. Horn and Miss Nance. During the altercation, Brendan was pushed down, Brendan the child, by Mr. Horn. Miss Nance's uncles, their names are Charlie Nance and Jeff Nance, approached Mr. Horn in defense of Miss Lakita Nance. As they were approaching and confronting Mr. Horn about pushing Lakita and the child, Mr. Horn pulled out a firearm and pointed it at all of the people present. The fourth person present was Ms. Fornstein Nance, which is the grandmother, pointed at all the people present and said, "I'll kill all of y'all." All parties on scene stated the same exact thing happened. The state has spoken with all parties in this case, with the exception of the child. Ms. Lakita Nance wants contact with Mr. Horn and stated that she is okay with a no violent contact order. I told her there has to be some kind of order in place. As to the uncles and the grandmother, Charlie, Jeff, and Fornstein Nance, they do not want contact with Mr. Horn. They also say they have no concerns regarding him being released, as they are not fearful of him. That is all from the state, Your Honor.
So a couple questions. Do you know how old Brendan is?
He was born in 2011, November 29, 2011. So 10.
He would have been
Am I math correctly?
nine at the time. Okay, so he is. It's not like he was an infant. He was big enough to be pushed to the ground. All right.
Yeah, no, he's not even.
All right. And why is the state null processing count 6?
Because, Your Honor, the defendant has, as part of one of the 14 SC case, 14 SC 128801, where he pled to possession or sale of marijuana, he also pled to a possession of a firearms charge. And pursuant to the OCGA, it states that it's a mandatory 10 years consecutive and it cannot be suspended, if I read it correctly.
Okay, I mean, it's your call whether you null process it or not. I just was curious. It's not because everyone has recanted and said there was no gun. It is part of the way you are negotiating a resolution.
Yeah, I thought that if I were to, and I could be completely wrong, it said it shall be punished by confinement for a period of 10 years. I didn't think that could be probated.
Okay, I don't know. Like I said, I'm not getting in the middle of it. I just wanted to understand. Last question for now from you. Tell me why you think time served is an appropriate outcome, given the fact that Mr. Horn has 10 prior convictions, 4 of which are open on probation. In other words, he was on active probation for 4 cases when he pulled a gun on the mother of his child, 2, we'll call them brother-in-laws, and an elder. I appreciate he didn't pull the trigger or anything like that, but that seems not really in keeping with someone who ought to be staying out of harm's way because he's on 4 open, active probation cases.
Yes, Your Honor. And that came about after honestly speaking with all of the parties in this case and their lack of concern. The uncles were definitely of the mindset that they were approaching him in defense of Lakita, and they just did not seem fearful or concerned. They made that very clear, as well as Lakita Nance. So really that came about after speaking with all of the parties in the case and getting their wishes of the trajectory of the case, and then trying to do what's fair.
Okay, got it. Thank you for that explanation. Officer Brown, thank you for joining us today.
Hello,
How are you doing?
I'm well, and yourself, Your Honor?
I'm hanging in there. My understanding is that Mr. Horn has 4 open cases that are subject to supervision, or at least they're open through DCS. One ends in 824, one ends in 292, one ends in 041, and one ends in 608. Do your records show that Mr. Horn has those same 4 cases? Do you have more? Do you have less?
No, I have all 4 of those cases.
Okay, can you tell me how much time remains on each one, please?
On the one ending in 824, he has 3 years and 19 days remaining. On the case ending in 292, he has 2 years, 4 months, and 24 days remaining. On case ending in 041, he has 3 years, 6 months, and 29 days. And on the case ending in 608, he has 3 years, 6 months, and 29 days remaining.
Got it. Okay. And do your notes or does a screen you can look at? Well, I guess Mr. Horn has been in custody for a while. I was wondering how he was doing on supervision of late, and he hasn't been supervised of late. Ms. Beza shared with me that your colleague, Officer Brown, had recommended that 2 years be revoked. Do you have any insight into that, or was that news to you, or what can you share about the origins of that recommendation?
That was news to me, Your Honor. I had no prior knowledge of any recommendations being had for these revocations.
Okay, so you don't oppose that or support it, or you just acknowledge that your colleague may have made that recommendation?
I would go ahead and support my colleague's recommendation due to the fact that he has 4 open probation cases.
Okay, makes sense. Thank you for sharing that. Ms. Bumpus.
Yes, Your Honor.
I'm ready to hear from you.
Your Honor, I just would ask that you accept the recommendation negotiated between the state and I. That recommendation is based off of the victim's statements that they are not in fear for their lives. This does appear to be an incident where my client is accepting responsibility for not handling himself properly. However, it does appear to be an incident where he was being attacked by multiple individuals or about to be attacked by multiple individuals. I know the officer isn't here today, and I'm just, offering this as a proffer as officer of the court. But before my client was arrested, an officer did get in contact with me because my client was trying to arrange to turn himself in. And that officer did let me know that if need be, he would come to court. But he did believe that my client was being jumped by the individuals in the home or the brothers or whatever, and that he was acting in self-defense. However, my client needs to understand and accept responsibility that because he has 10 previous felony convictions, that he has to do a better job of staying out of situations that lead to him being arrested, lead to him being attacked, lead to him feeling the need to pull out or be around a firearm. So I do ask that the court just accept this as negotiated between the state and I do think my client has had a year to sit down and think about what's really going on. And we would also be inclined to any other special conditions that the court deems necessary. If there's any programs, ankle monitor, anger management. I think he's already done family violence, so I don't think you can do that twice. But go ahead, Your Honor, I'm sorry.
No, I chuckled when you said you can't do it twice. But I'm following what you're saying.
Yeah, I'm not sure. I don't think you can. So Your Honor, I just would ask that you would give my client some leniency and, just impress upon him that if he comes back before you, that he's going to be in jail for a long time.
Okay, got it.
Yeah, I'm sorry, Judge McBurney. I'm sorry to interrupt.
Yes, ma'am. Officer Brown. Yes, ma'am.
I just wanted to add June 17th, 2019. Mr. Horn did have a revocation, which he was revoked 1 year and commuted to time served, but he was also instructed to complete the MADRC and the aftercare, and which he did not complete.
Okay.
And Your Honor, we did discuss this previously, and I'm not sure if we brought in the medical records to you or not. I think we did, or grandma came with him or someone, but my client was shot. And once he was shot and went to the hospital, he was unable to return to that program because of his absences. I'm not sure if you remember that or not.
No, I do. But what I don't remember, and Officer Brown, you may be able to help with this, is why Mr. Horn was revoked in June of 2019.
Clayton County misdemeanor charge, I believe, because I think I represented him on that.
Okay, so
the revocation order states that he pled to the new charges for the 19 SC case and the 18 SC case.
Okay, so it was some new cases here in Fulton. It may also have been something in Clayton, but the new cases in Fulton were part of the situation.
Yes, Your Honor.
Okay. And Mr. Horn, how long have you been in jail?
13 months.
13 months. When did you get arrested?
It's going on 13 months. I got November the 6th of last year.
Let me look this up.
That's when I
Okay.
came to Fulton County Jail, but they had me in custody in College Park Jail first, sir.
Okay. So it's over a year now, because here we are on the 17th.
Yes,
So you are coming up on 13 months.
yes, sir.
Got it. Okay. You've got at least one kid, and that is the young man in the indictment. And I thought it was Brendan, but it's Breeden?
Braylon.
Bryden?
Braylon.
Braden. Okay, Braden. Do you have other kids?
Yes, sir.
How many kids do you have?
I have 5 children.
The only one with Ms. Nance is Bryden? Yes?
And I have Shonda Horn, a little girl.
With Ms. Nance also?
Yes, sir.
So 2 kids with Ms. Nance?
Yes, sir.
Ms. Bumpus said something about family violence intervention. Have you already taken the family violence intervention program?
No, sir.
Okay.
My apologies, Your Honor. We'll definitely include that in the order. If
I will. I just wanted to
Okay.
confirm because I agree with you, Ms. Bumpus. If he'd already done it, it doesn't make sense to repeat it. But if he hasn't, then we'll do it. That was part of the recommendation. Mr. Horn, anything you want to add about this situation?
Well, over the situation, about this situation, I think that I have sat in Fulton County Jail enough time to learn about my bouts, my things of what I have did wrong facing my life, because I have never sat in jail this long and it feel like I lost everything, you know what I'm saying? And most of all, my children need me more than anything out there in the world. And that's something that I felt like I wasn't putting first, you know, and I love my children and I put them first much as I can. But as I sit in now, you know, sometimes when they say pack it up, you know, and you hear other man packing it up, or you just sit in your room and you thinking to yourself, like, how long you gonna keep making the same mistakes and folk want to hear the same thing? You know what I'm saying? Like, I really feel like this the time for me to get myself, I will have got myself together, you know what I'm saying? And it's time for me to make something out myself, because not just the court system, it's my family. It hurt when you call your family and they turn their back on you because of the same thing what's going on. You know what I'm saying? So by me sitting in jail and seeing everybody turn away from me and all I got is me and my Bible, you know what I'm saying? And this is where I got to vent to. It really made me feel like this, you ain't got no choice but to get on the right path, you know what I'm saying? And I wasn't raised in a bad upcoming and home bringing, so I can't put that on none of my family. I put it on myself because I chose the wrong route, but now it's just time for me to square up and go the right route and make people proud of the man who I gonna become, or not who I want to become or what I'm gonna become. You know what I'm saying? And it ain't about me no more. It's about my children, because they the bigger picture. You know what I'm saying? And I got younger people looking up to me, you know what I'm saying, who I feel like I got something to tell them, because I done been through so much, you know what I'm saying? I done been shot 14 times and I done did everything I could do. Like, I'm tired, you feel me? Like, I really want to be there with my family and help them. Like, this right here was a real breaking point. And I don't know what it is. I really think God put me here just to slow me down and just to show me like your family needs you. You know what I'm saying? Cause if you don't lose your life to the system, you lose your life to death. And I'm seeing a lot of people dying out here. And I want to be the greatest father to my children. You
So
know?
what's the plan? What's the right path going to be? You've demonstrated lots of wrong paths. Here we are on conviction 11. What you're going to work? What kind of work would it
I
be?
got the plan wrote down.
Well, but you should know. You've had 12 months to be thinking about it.
Yeah, I got a lot of plans. You know, when I get out there, you know, I got plans of going back to Atlanta area tech and give me my barber trade and start me a barber school. You know what I'm saying? And because I know how to cut hair, but I want to show other people a craft. You know what I'm saying? And I want to be a mentor for people and show them the right route to go. And I want to open up me a food truck because I like to cook.
So you're going to be the food
chef.
truck barber? People
You got to start somewhere.
No, you do. You do. I just want to know
saying?
where that is, because when you hit the ground, you're going to have kids who need things, and you know, it sounds like this all started over diapers, and diapers are expensive, and you're not going to be able to pay for a lot of diapers if you're in school.
Just a quiet for my brother.
One second. You got to get that guy quiet. So I'm just wondering what you've been thinking about doing, because we certainly don't want you back here anytime soon because you got caught selling drugs or with a gun or anything like that.
But see, I can do demolition work with my uncle, but I really want to do something what I want to love to do. So as while I'm doing that, I'm going to learn and get my degree on something what I want to do. You know what I'm saying, Your Honor? But for the time being, I'm going to do demolition work with my uncle. But what I really want to do is open up my own shop and have something what I can call mine and have me a bank account with everything.
The real stuff. I hear you.
Yeah.
It's your food truck or it's your barber shop.
Then go from a food truck to a restaurant.
To a hotel, to who knows what. I mean, those are real plans. I hope you can stick with them. I know you've had a complicated situation. Well, Mr. Horn, I find that there is a factual basis for your plea. You and Ms. Nance were getting in an argument and you let it go in a direction it shouldn't have. I'm not picking sides on this, but in the end, you need to figure out how to walk away. And you didn't. I'm glad that Bryden didn't get more hurt than him just hitting the ground, but that's nothing that a kid should have to be watching anyway. And then worst of all, you had a gun. Come on, man. You are one of the last people on planet Earth who should have a gun now with all those convictions. And it's not because I'm worried you can go out there shooting people. You know what guns can do. You got 14 holes in you, but that's something you got to be away from. Can't be in your house, can't be in your car. If you get pulled over and there's a gun in your car, even if you're like, hey, it's the guy in the back seat's gun, you're going to own that gun. And it's going to, all these things you're telling me you care about, you'll be away from again for a longer time. So you've got some important decisions to make if you're going to, now at age 31, going to start doing different things. But I find there's a factual basis. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we talk about, which you seem to. You seem like a smart guy, despite some of your decisions. Do you have any questions about anything we've talked about? Voluntary means that you are entering this plea because you've decided, after consulting with Ms. Bumpus, that this is the right way forward for you. Is that correct?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, which you will be for a while, and you have been for a long time, if you have a technical violation, maybe you miss a meeting or you're doing something where probation is frustrated, but you haven't gotten arrested for anything, you and probation will work through that. But if you get arrested for anything, jaywalking, speeding, on up to you've got drugs or a gun, that comes back to me. And I think Ms. Bumpus has provided a pretty good forecast of what would happen if the state can prove that there was a basis for your arrest. Ms. Bumpus, we are working off a copy of the indictment. Do you waive any issues that would arise from working with a copy of the indictment?
Yes, Your Honor, we so waived.
Mr. Horn, normally you'd sign the indictment, but we're not passing paper around right now. Do you authorize me to sign the indictment indicating your guilty plea?
Yes, sir.
Ms. Bumpus, may I sign for you?
Yes, Your Honor.
And Ms. Beza, may I sign for you?
Yes, Your Honor.
All right. Here's what I'm going to do on the sentencing front, Mr. Horn. Let me get the counts right. All right. On counts 1, 3, 4, and 5, I'm sentencing you to 1 year to serve. They'll all run concurrently with each other. Count 2 is going to be 9. Got to do that a little bit differently. Count 6 has been dismissed. Count 7 and 8 are both 12 months to serve. They'll run concurrently with count 1. Count 9, which is the simple battery on your son, is 3 months to serve. That runs consecutive to count 1. And then count 2, which is pointing a gun at your son, is going to be 8 years. That runs consecutive to count 9, but that is probated. So the sentence is different from what you've been hearing about, but what I envision it to be is that you are serving 15 months, 1-5. You'll get credit for all the time you've been in, and when you get released, you will have 8 years of probation. Special conditions of your probation: number 1, no violent contact with Lakita Nance and Bryden Nance, mother of your child, 2 of your kids, and your son. No contact at all with Charlie, Jeff, and Forestine Nance. Get your GED. You will complete the Family Violence Intervention Program, FVIP. And that's a series of classes. It's not like a 10-minute thing, but it's a bunch of weeks. You go every so often, and I think you'll learn some important stuff. I will waive your probation supervision fee for the first 3 months while you get on your feet figuring out, hey, I'll start with demolition because that's money in my pocket, or I'm going back to school, whatever it is. First 3 months, you don't need to worry about the probation supervision fee. And in light of this new conviction, I am going to revoke 15 months in all 4 of your open cases. You will get credit for all the time you've already been in, which is 12 months plus some days. And I will suspend the balance in all 4 of those cases. So those will be effectively closed out. When you are released, you're going to stay at Rice Street. You're not going to leave Rice Street. When you're released from Rice Street, you will be on probation in 1 case, this one. You don't need to worry about those other 4, but you got 8 years probation, which is a whole lot more than what's going on in those cases. My hope is, Mr. Horn, that you have reached that turning point. Maybe you didn't spend as much time in custody for your 10 other cases. I'm not hopeful that the 11th case is magic. Ideally, like your first case would be magic, but maybe this past year has had the effect that you described. What you described is pretty potent. I just hope it sticks, because it's easy to feel that way when you're on the inside looking out and missing your family. The true test will be when you're on the outside, and all those things that in the past have pulled you in that direction and gotten you all these convictions that you shot 14 times. You're going to need to turn your back on that and focus on family and work and being the man you say you want to be. Because if I don't see you again until I come to your food truck or your restaurant, then I'll know you made the right decisions. But if I see you dressed like that, I'll know that it was harder than you thought and you weren't able to shake the past. I hope you are. I hope for all of your kids and for Ms. Nance and your family that you are able to shake it. But it's not easy. I don't want you to pretend that it's easy and you're going to pop out and, hey, you know what? Now I'm going to go be a barber. Just like that. If it were that easy, maybe after conviction too, you would have been done. So I wish you luck. The sentence that I have pronounced, Mr. Horn, is less probation, but it's a little bit more jail time. I know you were anxious to get out. I can't see that being the right answer, given all the convictions you've had, and in particular, the fact that you had a gun again in this case. And so that's why I've gone up a little bit from what your lawyer recommended and what the prosecutor recommended. You have the right to say, forget it, Judge. I'm going to stay put. I'd rather go to trial on this case. And in 5 or 6 months, we can get you into a courtroom and you can have your trial. I will certainly honor that request. Or you can go forward with the plea that I've described. You have a feeling about what you want to do? You want to think about it some?
We can go forward, Your Honor.
Okay. Ms. Beza, anything else in connection with Mr. Horn's case from the state?
Nothing further from the state.
Ms. Bumpus, anything else on behalf of Mr. Horn?
No, Your Honor.
Ms. Bumpus, I want to thank you for all your work on this and helping us connect the dots with some of these older cases. Officer Brown, do we need to get Mr. Horn reporting instructions? Do you need to have an exchange with him at this point?
I just need to know what county he lives in.
So when you get out, where are you going to be living?
With my grandmother.
With your grandmother here in Fulton County?
Yes, sir.
Okay, Fulton County.
Okay, I'll send reporting instructions to the jail once court is over.
Okay, so Officer Brown will get reporting instructions to you. If you've got any questions about it, because you certainly don't want to miss your first date with probation, talk with Ms. Bumpus. She will be your source of info if you don't connect with Officer Brown. Yes, Mr. Horn.
And I just want to get an understanding. I have to do like 2.5 more months in custody.
At most, it may be the sheriff has the discretion as to what to do with that remaining time because it's misdemeanor time.
All right.
But at most, what you said. I mean, I don't know if it's probably about a half. It's less than 3 months. I'm just doing the math in my head. If you got in there on the 8th, but at most, it's 2.5 months.
All right.
Okay.
Thank you.
You're welcome.
You have a blessed day, Your Honor.
You too. Good luck out there.
Your Honor, may I be excused?
Yes, ma'am.
Judge Carnicel.
You go wherever you need to. Same with you, Ms. Bumpus.
Okay, thank you, Your Honor. I'm so glad we were able to get this resolved.
Same. Thank you.
Thank you.
Thank you, Your Honor.
I think so. Where did Mr. Webb go? He and Mr. Brown? Oh, okay, great. I think so. Let's just get confirmation from Mr. Webb. Do you want to talk with Mr. Brown one last minute? You think he can come out?
I think you should.
You got him in the headlock and did what you needed to do?
I don't want to admit that.
No, don't admit that. I think that's a good choice.
I told his sister to go, she could hire Alan version.
He would not visit him every day either.
Was he one of your professors?
He was.
That must have been an interesting experience.
That's one word for it. We learned much more about him than about criminal law.
Oh, yeah. I read one of his books and I was not, but
Well, you can imagine what the lectures were like.
I can't understand how anybody could say that trying every single case, the system would break down.
Right.
Break down with us, plea bargaining, you know? So I can understand trying a case and, oh, the facts coming out. Anyway,
I was okay.
I lost respect for the impeachment trial.
That's what I told her.
Ms. Hall, you ready? Great. Ms. Rivers, you good?
Ready, Judge?
I get this out of the way. It's a nuisance. Okay.
Your sister. All right, let's go back on the record in Mr. Brown's case. We took a break. Mr. Brown had importantly shared with me, and I appreciate him doing it, that he wanted some more time to think about his situation and to converse with Mr. Webb. Mr. Webb did spend some time with Mr. Brown back in lockup. Mr. Brown, are you ready to continue with the conversation we were having about a plea in your case?
Yes, sir.
Okay, you'll let me know if we need to stop for any reason.
Yes, sir.
All right. Do you remember where you were, Ms. Hall, or are you going to start from scratch?
I remember.
Okay.
Mr. Brown, are you satisfied with the service? I'm sorry, have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
No, ma'am. I just feel like, what I'm trying to say is, I just feel like this is my life that we're dealing with. So I feel like that, I don't mean no disrespect, you feel me? I just feel like, I don't know. I just feel like I have a better chance probably fighting this case with another person.
So when you say another person, do you have a lawyer that you intend to hire?
No, sir.
Okay.
Well, yes, we do. My sister is trying to build the money up still.
So that person isn't ready to go right now?
No, sir.
Okay. So you have the right to representation, which is being provided to you. You have the right to any attorney you can afford. Some folks are able to afford counsel, some aren't. But if you cannot afford counsel, which is your situation right now, then one is appointed to represent you. You had a lawyer from the Conflict Defender's Office for many months who has moved on to do a different job. And Mr. Webb has very ably jumped into her space and picked up your case. And that's your representative at this time. So at this point, unless you have someone who is prepared to file an entry of appearance, in other words, saying, I'm the lawyer for Antonio Brown, then your choice is to move forward with Mr. Webb, or you always have the right to represent yourself if you think that's a good idea. I will entertain that request, but I will tell you that I'll spend about a half hour trying to talk you out of it because it is very, very rarely a good idea for a criminal defendant to represent himself. But it is your right. I didn't hear you say that, though. I heard you say, hey, I think maybe I want a different lawyer. And like I said, that is, if you can produce another lawyer, that's great. But you have a very capable lawyer who has been appointed by the court to represent you. Okay?
So until my lawyer is paid for, can I have another public defender until?
No, unless there's, I need to be aware of some conflict in representation that has made it impossible for the two of you to work together. And I'm not aware of anything like that. If we need to have a private discussion where we have the prosecutor leave the room, we can do that, where you could let me know, look, I think that the best defense in this case is alibi, that I'm making this up. I don't want you to tell me what you think your defense is, but I'm just giving you an example. You might say, you know what? I've got an alibi. I was in Mississippi with my cousin, and I keep giving Mr. Webb the phone number for my cousin, and he will not call my cousin. He said, nope, I don't like the alibi defense. I think that the defense is self-defense, or there is no defense. You need to plead this case out. Something like that, that kind of conflict that we would need to talk about in private is the kind of thing where I would say, well, maybe there needs to be a different lawyer if Mr. Webb weren't able to explain to me why he thought that this alibi wasn't a good idea. And it may be that he did, I'm again making this up, that he called your cousin in Mississippi and your cousin said, I haven't seen Antonio in 6 years. That's not a good alibi witness. And so Mr. Webb is actually making a smart decision to say, we're not going to rely on your cousin who will come in here and say, I haven't seen Antonio in 6 years. So if it's something like that, there's this fundamental disagreement, then we should talk about it without the prosecutor here. If it is your notion that, dang, maybe a different lawyer could get me a different deal, that's not a reason why we would rotate counsel for you again. It would need to be that type of conflict where I'm concerned about Mr. Webb's performance as your advocate. And I don't have that concern right now, but it may be that if we spoke privately, meaning you and Mr. Webb and myself, that would come to light. So if that's the conversation you think we need to have, we should do that. Again, Mr. Brown, I'm not trying to force you to enter a plea. If you want 12 members of the community to see and hear everything that the state's got in this case, you should do that, and we'll get you your jury. If you think that could result in a worse outcome for you, because at trial, if you're convicted, the state, I assume, has already told you they're going to be recommended something a whole lot more than what they're recommending right now, then maybe going to trial is not what you want to do. But that's not a decision I make for you. That's the product of your discussion with Mr. Webb, where he gives you his professional sense of trial risk is big or little, whatever he's told you. Plea risk, you know what's going to happen. It's a plea. You just don't know where the sentence is going to be. And you don't like what the state's recommending, but you don't control what the state recommends. So that's sort of where we are. And like I said, I am neutral as to what you select. What I don't want to do is keep going down this discussion about a plea. If you know in your head and in your heart, you're not going to enter the plea, we should just stop. We don't need to spend any more time today on that. We'll get Mr. Dean out here. He can enter his plea. I don't know what he's going to do in your case. And I got other pleas to take. If you do want to enter a plea, we should do that. But if you don't, then let Mr. Webb focus on getting ready for your trial.
Yes, sir.
So tell me what you want to do.
We may move forward.
We're going to move forward? Okay. We'll keep going. Next question, please. Ms. Hall.
Counsel, do you waive formal reading of the indictment?
Yes, we do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, we do.
And do you waive moving forward on a copy of the indictment?
We do.
Mr. Brown, are you aware that this is a non-negotiated plea, but the state will still make a recommendation to the court?
Can I ask what you mean like by that? Can you explain more, please?
So that just means that we haven't come to an agreement on what we think, what the state thinks that you should plead to in this case versus what you and your attorney has talked about and what you think you should receive if you plead guilty to this case.
Yes, ma'am.
Are you aware that we will still make that are you aware of the state's offer of 20 years to serve 15 balance on probation for armed robbery?
Yes, ma'am.
15 years to serve on aggravated assault?
Yes, ma'am.
And 5 years suspended on possession of firearm during the commission of a felony?
Yes, ma'am.
So I'm clear. Is that the same recommendation that was made a couple of weeks ago when Mr. Brown is here, or has it changed a little?
It's exactly the same.
Okay, so this is something Mr. Brown, I know, has heard before, but we're just clearing up the non-negotiated part. So Ms. Hall is going to urge that I sentence you 20 years, serve 15, balance probated.
Yes, sir.
Mr. Webb is going to urge that I sentence you to something less than that. That's all we mean by non-negotiated. A negotiated plea would be both lawyers are saying, Judge, here's what you ought to do. Let's say you had agreed on 12, just pretending. Mr. Webb would say, hey, I think 12 makes sense. Ms. Hall would say, I think 12 makes sense. Then I'm hearing from both sides the same thing. That is often more persuasive than one side is here and the other side is there. And I need to work out, am I somewhere in the middle? Am I higher? Am I lower? Okay? All right.
And Mr. Brown, do you understand that the court can oppose any sentence authorized by law, including a higher sentence than the one recommended by the state, up to the maximum sentence on each charge in this indictment?
Yes, ma'am. Yes, ma'am.
Has your attorney advised you of the
I was trying to get him closer to the microphone.
Oh, okay.
So Ms. Rivers could hear him.
Do you understand? I mean, I'm sorry, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
So the minimum and maximum sentence for armed robbery is 10 to 20 years or life to serve. Aggravated assault is 1 to 20 years to serve. And possession of a firearm during the commission of a felony is 5 years to run consecutive to any other count. Do you understand that this guilty plea is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am. I understand.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a trial? For example, your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am. I understand.
Do you understand that by pleading guilty to a felony, if you receive, use, possess, or transport a firearm, or use a firearm in a crime, you may be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilt?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to plead guilty. The right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your right to waive these rights and give up? Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, sir. I mean, yes, ma'am.
In indictment number 20-SC-174-164, how do you plead to the charges of armed robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Brown. Your Honor, the state is unaware of any prior felony or misdemeanor convictions by the defendant. And had this case proceeded to trial, the state expects the evidence to show that on December the 21st, 2019, at 3393 Peachtree Road, Northeast Atlanta, Georgia, that was Lenox Mall. Inside of the garage, officers responded to that location to a person being shot, that person being Miss Carolyn Gilbert. When officers investigated this case and spoke with Miss Gilbert, she told officers that she arrived to work that morning and she saw 2 Black males standing. They didn't look suspicious to her, but she did notice them. She worked at Macy's at that mall. So she went into the mall, realizing that she forgot her cup inside of her car. She went back to her car to retrieve her cup. When she bent over in the back seat to grab her cup, Mr. Brown, the defendant, pulled her phone out of her back pocket. When she raised up, he then had a gun pointed at her face. Mr. Brown, the defendant, and his co-defendant demanded Ms. Gilbert's car keys. She refused. They asked multiple times. She refused each time. At some point, while the gun was still pointed at Mrs. Gilbert's face, she moved the gun out of her face, at which point the defendant shot her in the stomach. After the defendant shot her, him and his co-defendant, Mr. Dean, ran from that location to a nearby train station. The defendants leaving from the location was caught on surveillance. Not the actual shooting wasn't caught on surveillance inside the garage, but outside the garage, you can see on another level of the garage, they're running. Then you can see them outside of the garage going over to the train station. When they get into the train station, you can see them coming up the escalator, and then they get onto a train. We have surveillance showing them, Mr. Brown and Mr. Dean, depicting what had happened. Like you can see them raising their hands as if they were pointing a gun. You can't hear sound, so only thing I can do is assume that they were reenacting what had just happened. The investigator of this case gathered all the surveillance from the area, put out a media bolo. On that bolo, there were 2 hits, one being Mr. Antonio Brown. Mr. Brown was arrested on January 30th, a little over a month after the incident happened, when he was taken to APD headquarters. I'm sorry, before he was arrested, Ms. Gilbert was given a lineup and she was able to positively identify Mr. Brown as the person who shot her. And then during the interview with Mr. Brown admitted to robbing Ms. Gilbert. In that interview, he does state that the intention wasn't to shoot her, but it was to rob her. He says in his interview that she fought with him. That's not the information we get from our victim, but that she just pushed the gun because she didn't want it in her face. But in his interview, he admitted several times that he did. He is the person that shot. He is the person that kept demanding Ms. Gilbert's keys and she refused. He even describes what he did when he ran away from the situation. Apparently him and Mr. Dean had been friends for about 5 months. They met off of Martin Luther King somewhere. He didn't say whose idea it was, but that it was a mistake and it wasn't intentional. Ms.
The
Brown,
shooting wasn't intentional, but the armed robbery was intentional.
Right. So that is all from Mr. Brown as far as the incident. As far as Mrs. Gilbert, she is here to speak on her own behalf, but she is still, as I've told you several times before, still suffering injuries from getting shot in the stomach. As you know, one time we did have a hearing that was planned, and as she was on her way back to Atlanta for that hearing, she learned of another Lenox shooting, which made her turn around and go back up north where she is currently living in New York. But I'm gonna let it, when the time is appropriate, she would like to speak with you, Judge, on her feelings on this case. I believe that is all from the state.
Okay. Officer Brown, do you have any criminal history information on Antonio Brown?
No, Your Honor, we have no felony history.
Thank you. Ms. Gilbert, it is important and appropriate that I hear from you if there is anything you want to share. I know we met at least once when you were in courtroom 1D way back when. I know this case has been around for a long time, which is, I'm sure, difficult for you as you are seeking some form of closure and the ability to move forward. But I would like to hear from you if there is anything that you want to add to what I've heard from Ms. Hall today.
Yes, Your Honor. I'm currently seeking therapy twice a month to help me get over the anxieties of, on a day-to-day basis going on into public life. As you know, I am currently working part-time for the Census Bureau, as well as flying as a flight attendant for Delta Connection. And those two hand in hand, I have what is called post-traumatic stress. And, from that situation, it doesn't change, but seeking therapy, talking to someone, it helps, it doesn't change what happened and what has happened, but going forward, it creates a better situational awareness, for myself as well. It's been hard. Some nights I'm afraid. I do live alone. My family's not going to babysit me because I'm used to being independent. But, it's something that I could not get over. And it's something that I will continue to seek therapy for until I see the light at the end of the tunnel. It's not something that I enjoy. Being shot in the stomach is something very dramatic. I could have lost my life that day, had I not gone back for the coffee cup, just only because I know I had to do the walks. I know I had to pull the stuff on the floor, and I was a little bit overwhelmed with everything. And I just wanted to be efficient. It's something that, someone shouldn't have to go through what Mr. Brown did. Not.
I'm sorry, I'm having difficulty hearing.
Yeah, Ms. Gilbert, you're breaking up a little bit, just towards the very end there. If you could just repeat maybe the last sentence you said.
Mr. Brown, what Mr. Brown did was very careless, very ineffective. That was not nice as a young Black man to hurt someone like that. That was not nice. I did not hurt you. I did not disrespect you. And that was not my intentions. You hurt me very badly. And I will spend the rest of my life trying to get past that. It has hurt me traumatically. Now, maybe that means nothing for you. You're going to be a father. You're a father. That sets a bad tone as a parent, because my father never hurt anyone or done anything to hurt anyone in front of my presence. I have grown up with my dad. I've grown up with my mom, and they both grew me, even my grandparents. That way that you have, I hope to God you learn from this experience. That way, this rage that you have procures itself, because it's not funny to hurt people to get by. You could have come into Macy's, it's Christmas, and you could have asked the manager for something additional to do. I remember I wrote notes. You said you worked for Wendy's. You could have come into Macy's and asked for help, and they would have given it to you. You didn't have to shoot me. You didn't have to hurt me. There's no way what you've done could go unexcused. And I hope you understand that.
Ms. Gilbert, I appreciate you sharing that. I think it's important for me to hear. I think it's important for Mr. Brown to hear. And hopefully it was helpful for you to share that. I do have one question for you. You helped me understand how you're doing on the mental health front with the anxiety and the PTSD, but fortunately you're getting some therapy. Tell me how you were doing physically. You were shot, so obviously there was a medical emergency and you were attended to. Are there any lingering physical effects, or have you largely physically healed? Not emotionally or mentally, but have you physically healed?
Some nights I still do get pain in my back, because when he shot me at the lower portion of my stomach. But thank God for that, that it didn't penetrate, the bullet didn't penetrate to the bottom of my stomach, because I could have been crippled or killed. So when he shot me, my back, it was days before I can lift or bend or even stretch. So some nights I still get pain in my back. So I have to work out. I may walk sometimes, I may get on a treadmill, and I may run sometimes just to create rotation, because my foot would swell. If my back pains, then my feet, my ankles would become swollen as if they had water in them. I don't take any medication for that. I just need to go out and exercise, run, do walks,
power walk and the treadmill. And that's basically what it is. But that's as much as I can do. You know, some nights there's gonna be pain in my back. And if there is, I need to get up, I need to bend, I need to stretch, to rotate my joints, my ligaments, to see if I can get the blood flow working. Because again, when he shot me, I wasn't able to bend, I wasn't able to stretch. I went for weeks without being able to use the bathroom. And it wasn't until the wounds actually healed that then I was able to go to the bathroom, and start bending and start stretching. My feet was swollen for at least 4 weeks.
Okay, well, I appreciate you sharing that, and I'm glad to hear that on the physical side, there has been some healing, but it sounds like there are residual effects. Ms. Gilbert, again, I'm sorry for what you went through. I appreciate you staying involved with this process so that I could hear from you today. Ms. Hall, do you have anything else?
No, Your Honor.
All right, Mr. Webb.
Thank you, Your Honor. Mr. Brown wishes to make a statement, and also a family member, his sister, Rhonda Williams, is present, who would like to speak to the court. Before we do that, though, Your Honor, I would like to raise a procedural matter on the record. And forgive me if my memory of the law is foggy. I don't know if if the plenary power doctrine applies to judicial proceedings. But before Your Honor accepts my client's guilty plea to the indictment in 21 SC, which is the possession of a firearm during the commission of a felony, I just wanted to call the court's attention to the fact that I did file a demurrer to that indictment. I may have incorrectly denominated that as a special demurrer.
This is a different case or this case?
No, this is the third case. I'm sorry.
You're crossing wires right now. Different client. That's Mr. McKenzie.
It is.
Mr. Brown, one case, this one, the 20 SC, and there is a firearm allegation, but it flows naturally from the other facts that I've heard from Ms. Hall.
Sorry, Your Honor, my mind is in overdrive right now.
You've got a lot of cases on for today, and it sounds like you've prepared for each of them. So I will certainly hear from Mr. Brown. I will certainly hear from his sister. Anything more from you in connection with Mr. Brown's case?
Well, yes, before he gives his statement and his sister gives his statement, I just want to point out a couple of things that I have learned in terms of his social history. Of course, the court is aware that he's 19 years old. You're aware that he did not finish high school. He did not obtain a GED. I did learn that he grew up in a home without a father. I think the last contact he had with his father was when he was about 3 years old. His mother died when he was 13 of a heart attack, and he was essentially raised by his aunt. Now, his sister and he have two different fathers, so it's not her aunt, but it is his aunt. And I did speak with her on the telephone, and she explained to me the circumstances. And I'm not offering that as an apology for what he did. But I just want to point out to Your Honor, and interestingly enough, too, there apparently is not a juvenile history. There's not a previous history. You'd think in a circumstance like that he might have been prone to have been influenced by forces outside of the home. But I would like Your Honor to just take that into consideration, and then I'd like to allow Ms. Williams, his sister, to speak on his behalf.
Sure. Ms. Williams, if there's something you want to share, if you don't mind coming on up, you could stand over here by Deputy Warren.
You want me to place her under oath?
Nope. Good morning, Ms. Williams. I may, if you're hard to hear, ask you to take your mask off because the court reporter needs to hear you. You're kind of far from a microphone, but let's give it a try. It's fine.
Yes, first of all, good morning, court. My name is Rhonda Gore, actually.
No, I'm sorry.
Yes, sir. I am Antonio Brown's sister, and I did write something that's okay.
Let me make sure. Yes, it is okay. Let me make sure Ms. Rivers can hear you. Ms. Rivers, are you able to hear Ms. Nolly, or should I get her up to a microphone?
Microphone will be better, Judge.
Okay, if you don't, can she come to the podium? Does that work, Deputy Warren? Great, and you can take the mask back off while you're reading. That'll help. Thank you. And could you spell your last name for the record?
Yes, Nolley.
All right, I guess right.
Okay, Antonio is not the sum of the charges against him. I do not wish to speak on whether he is innocent or guilty, but I'd rather speak on who he is and how he made it to this point. He is now a 19-year-old male that has been incarcerated for almost 2 years. That means he was 17 years old, placed in confinement with his future at risk. At that age, even now, he is considered an adolescent whose brain is still developing. Most of us here can attest to the changes, twists, and turns our own life has taken from the age of 17 and even continued throughout our 20s. I say that not to excuse, but to give light. If I may shed even more light on his path that led us all to being here today, I must start with a life-altering death. January 3rd, 2016, my mother passed away. Antonio and I awoke to knocking at the door to find our mother collapsed and not breathing. We called 911, attempted CPR, until medics arrived, who still after an hour were not able to revive her. My life shattered, my heart was broken to the point of sharp pain shooting through my chest. It was only my faith and belief that brought me out. It took me 6 years to come to grips with what occurred and move past that grief to mourn my mom without it sending me into a state of depression for weeks or maybe months at a time. I was 24, Antonio was 13. The structure he depended on and knew as a family was shattered. I couldn't even imagine the trauma, imagine the effects of that scene and how it affected his young mind or how that one day has affected him every day since. About a month later, Antonio moved out of state to live with his father in Tennessee, with whom he had an estranged relationship. Within a year, Antonio was placed in foster care for the next 2 years. Studies have shown that even adults have waited at least 6 months before making an altering life decision, such as relocating. When he finally made it home with his aunt as his guardian, he continued high school, began working and was even considering a long-term career in construction. I could still see the pain in his eyes, heard it in his words of reminiscence of our mom. I didn't know whether to pry and possibly make it worse or leave him to heal on his own. Shortly after he began reaching out to old friends and what I view as an attempt to reach out to a time his life was somewhat normal, complete, when he had his mother with whom he had quite a fascinating bond. They shared jokes that only caused them to laugh. They had conversations that usually sons would find uncomfortable to have with their mom. So he went reconnecting with old classmates and friends that knew him then and also knew his mom. I should have saw this was a cry for help. This was his depression. Maybe I was blinded by my own depression, or maybe I saw it and was crippled by my own grief and unable to help him. Either way, I know in a way the adults around him wanted to help him, keep him away from anything that resembled a distraction from his future, but didn't take time to acknowledge the hurt, tragedy, and traumatic time of his past. We didn't see he was unable to look forward. We somehow failed Antonio. Antonio conceived a child before his arrest and was not able to meet her in person. His now 1-year-old daughter, Royalty, has been a dream of his since he was only 3 years of age. A young child with an active imagination, he always had a child in the scenario he would play out. He always was wise beyond his years. As he grew older, he would often speak about having a wife and a child. Royalty is his future. She has already begun to give him a reason to look forward. I'm asking that the court does not fail him as well, that his grief, his depression, and inability to mourn his mom does not continue to be the most significant event in his life. I am pleading with you, Judge McBurney, for leniency and understanding. I am pleading with the law, the prosecuting attorney, to consider her future as well as her 19-year-old father, to consider how the law and judicial system can help break a cycle of fatherless children and incarcerated fathers. Regardless of who the guilty offender is, I have prayed for healing for the victim, who is someone's daughter, someone's mother, and someone's sister and wife. I still pray for forgiveness in her heart so she may continue to move on with her life. And now hearing this guilty verdict, or him stating that he's guilty of this, I want to apologize because it's hurt me to hear that he was in this situation and he committed actions that hurt someone. My mother also was once robbed when he was maybe about 3 years old, and that it hurted me then, it hurts me now that there's something that's continuing to happen. So I really do pray for her healing. Ms. Gibbard, if you can hear me, I do pray for your healing, and I do pray
across the board, you're healing emotionally, mentally, and physically. Thank you, Your Honor.
Thank you, Ms. Nolly. Those were very thoughtful comments. I appreciate you sharing that. Mr. Brown, Mr. Webb said you had something you wanted to say. You can do it from right there. You just need to talk into the microphone, okay?
Yes, sir. I do want to say first that I apologize to Ms. Gilbert for everything. I do want to say that, man, when I came home, I was 16 years old, I turned 17.
When you say you came home, meaning came back from Tennessee?
Came from Tennessee, came home. I was in foster care. I still didn't have a mindset to whom I wanted to be. And now that this have happened, it's sad to say, but I have found myself. And I know that being incarcerated in these chains, eating this food, being cold, all is not for me. But I know I have made bad decisions and I'll take responsibility. I just ask that may I please have another chance. I beg for another chance at this. I just promise I will not let no one down. And I just want another life. Either was to take probation. I don't know. I just want another chance.
I understand what you're saying.
I made a chance. I apologize for that. I apologize. My family tried. My family tried. I let myself down. I let my mom down, my family down. I just ask that I have one more chance at life so I can redeem myself and show people that I am a good person and I'm not just some criminal that did something stupid. I was 17 around people that was way older than me. That's it, Your Honor.
All right. Thank you, Mr. Brown. I'm understanding what you're saying.
Yeah, heard on the amount of the sentence.
Pardon me, Mr. Webb?
May I be heard now?
Yes. Yep. I was going to say, I need to know because it's non-negotiated. I'm assuming you got a different number.
Yes, Your Honor. One of the things I didn't emphasize in mitigation of the facts, I believe the evidence is clear. I could be wrong, but I believe the evidence is clear that when the armed robbery took place and he placed the gun in Miss Gilbert's face, I think she tried to push his hand down or bat it away, which is a natural reflexive reaction, of course, of anyone. I think that's when the gun went off and shot her in the stomach. So I think it's consistent with the statement that he gave to the police against his interest that the shooting part was unintentional. I just want to emphasize that, the aggravated assault, although the armed robbery was. Your Honor, obviously this is a very serious case and I can't, there's nothing I can say to mitigate the pain or the injuries to the victim in the case. On the one hand, my duty as an advocate to my client is to request a minimum sentence of the mandatory minimum of 10 years. However, I also am realistic. I understand that it's not just an armed robbery where there were no injuries. So there needs to probably be an additional amount. I do feel like 12 years would be an appropriate sentence. I think 15, I'm not saying 15 is excessive. I'm not saying the state is not being generous in making that recommendation, but giving all the facts and circumstances, his youth, his family background, his remorse, I would ask the court to sentence him to 12 years to serve with the balance on probation.
Okay. Thank you. Mr. Brown, I view this in a way that's, I think, functionally very similar to Mr. Webb. It's not just an armed robbery. Sadly, we get lots of armed robbery cases, but they typically involve someone pointing a gun at someone else and getting their stuff into story. Already a traumatic situation, a serious crime, a crime that our legislature has said you have a minimum of 10 years to serve. Your situation became a whole lot worse when that gun you pointed at Ms. Gilbert went off. Whether it went off because you purposefully pulled the trigger or your finger was on it and you were nervous, and when she hit the gun, it went off, in some ways doesn't matter, because you had already put the gun, loaded bullet in the chamber, in her face. And a expected consequence of something like that is that you could need to use the gun. The person resists, the person reaches for a gun, and you pull the trigger. So this is more than just, and I don't mean to suggest that there is just an armed robbery, but it's more than just taking Ms. Gilbert's property. It's shooting her. We're all fortunate that she didn't die from that bullet wound. Had it been a few inches to the left or the right or up or down, she could be paralyzed. She could be dead. And then no one's talking about 15 years. People are talking about, is it life or is it life without parole? So you may not feel very blessed right now, but as you are thinking through and articulating very well your desire for a second chance and another life, your phrases, you actually have those opportunities despite the bad things you did. And I know you say you made some bad decisions, but I'm not focused on decisions. I'm focused on actions. You acted, you approached this woman with a gun in your hand, you put that gun in her face, that gun was loaded, that gun went off. And again, fortunately, Ms. Gilbert didn't succumb to that injury. So you did a bunch of real. You got something you need to say?
No, sir.
Okay. You did a bunch of things that were dangerous and reckless and wrong. It wasn't just bad decisions. But I'll tell you, I'm all for second chances. It's just that what you did is something where you're going to need to wait a little bit longer for a second chance. If we were here because you shoplifted something from Macy's, you would have been well on your way to your second chance, because you would have gotten probation and maybe you get back into school, your sister's support, you'd be working, who knows what you'd be doing. But it's not a shoplifting case. It's an armed robbery with a gun being fired and someone being seriously injured. So you are going to need to wait longer before you get your second chance. I hope you remain committed to that second chance. You will be able to redefine yourself. You will always be that convicted felon, but you define who Antonio Brown is when you get out. And if you go back to being with the kind of folks you were with that got you into the Lenox Mall parking lot with a gun in your hand and a interest in robbing someone, then you know what's going to happen next time around. But if you define yourself in a different way, then maybe that second chance, that opportunity you'll get when you're released will be something more productive. Mr. Brown, I find there's a factual basis for your plea. This does not sound like a case that would make a lot of sense to take to trial, given your confession and Ms. Gilbert's identification of you from the photo lineup as the person who stuck the gun in her face and shot her in the torso. So I can understand why Mr. Webb was encouraging you to work the case out. I also find that the plea is knowing and voluntary. Knowing means you've understood the things we were talking about. And if you didn't understand, you did what you do well, which is you ask questions. Hey, I don't understand this. I want more information about that. Is there anything that we, Ms. Hall, Mr. Webb, myself, have talked about with you up to now that you don't understand?
No, sir.
Any questions so far?
Yes, sir.
What's your?
It's not a question. It's a statement.
Okay.
First, I do take responsibility for everything I did. I just want to say that first, I did not take a phone from her or touch her, period. I didn't do any of that. That's all I want to say.
Okay.
And I didn't do all the extra stuff.
Got it. I hear what you have to say. That who pulled the phone out of her pocket isn't what I am particularly focused on here. And I don't feel like you were not taking responsibility. That if I said something that made you think like, gosh, Judge doesn't seem that I'm taking it seriously, all I was doing was letting you know that it's not just bad decisions, it's the actions. That's why we're here. That's what I'm concerned about. All right. So I do find your plea is knowing. I also find your plea is voluntary, which means even though you are not excited about the situation in which you find yourself, you have decided, Mr. Brown, after thinking about it real hard, after talking with Mr. Webb about it, that it is the right way forward for you to do a plea rather than go to trial. Is that a fair statement?
Yes, sir.
Okay, then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. What that means, Mr. Brown, is that when you're on probation, which you will be at some point, if you've got a small violation, we call them technical violations, you and probation can sort through that. I don't have to get in the middle of that. If you get arrested for something new while you're on probation, if it's that serious, that comes back to me, and you and I and a lawyer on your behalf will figure out what the consequences, if any, ought to be. Mr. Brown, there's not a good sentence in a case like this. I could sentence you to life, and that doesn't make Ms. Gilbert feel a whole lot better. It doesn't get rid of her PTSD. There's not a sentence that gets you back to your daughter and your family anytime soon, because there's a 10-year mandatory minimum. So there's not a sentence that's going to make you happy. It's really not about making people happy. It's about the sanction fitting the seriousness of the crime and deterring you and folks who may be following your case from doing something like this again.
I won't do this again.
I hear you say that. I hope that's how it plays out, because there's not a third chance, something like this. So what I'm going to do, Mr. Brown, as to count one is to sentence you to 15 years to serve. Count two, I'm going to switch that around. Count one, I'm going to sentence you to 13 years to serve. Count two is going to be 15 years to serve. That will run concurrently with count one. And then count three has to be 5 years consecutive, but I'll probate that. So the total sentence is 20 to serve 15, but it is 13 on the armed robbery and 15 on the aggravated assault. And then the 5 years of probation. It will be a special condition of your probation that you have no contact with Ms. Gilbert. That'll be easy. She's far away. But it'll also be a special condition of your probation that you stay away from the Lenox Mall, Phipps Plaza area. Don't need to go back there. When you get out, you can be in other places if you're still going to be in the metro Atlanta area. Ms. Hall, oh, and I want you to get your GED. If you're interested in second chances and another life, you'll knock that out while you're in custody. You'll get credit for all the time you've been in. So you are 2 years into it of the numbers we were just talking about. Ms. Hall, do you have any other conditions or things you want to share?
No.
Mr. Webb?
No, Your Honor.
Okay. Mr. Brown, to enter your guilty plea, you normally would be signing your indictment, but we're not passing paper around. Do you authorize me, Mr. Brown, to sign the indictment for you?
So what am I signing to do? Like what is the indictment?
It's your indictment. It's the you know what? I'll put it on the screen and you can see it. So if you look at the screen right now, that's the indictment. You and Mr. Dean, those are the charges. Your only counts 1 through 3. And if you see right here, let me do this.
He's going to sign it for me too.
I don't know where my little tools are. Anyway, I was going to try to circle that. You normally would sign it, but I'm not printing this out. We're going to do it electronically because of COVID. And so if you tell me I can sign it for you, I'll do that. I asked Mr. Webb if I can sign for him. He's going to say yes. I asked Ms. Hall, can I sign for her? But that way everyone is indicating, yep, we were here today. And Mr. Brown was entering a plea of guilty. That's all you're signing is the official charging document that was handed down back in January of last year that lays out the charges. Does that answer your question? Or you have more questions?
Yes, sir.
Okay, so my question is, do you authorize me to sign it, or do I need to print this out and have the deputy bring it to you so you can sign it?
Actually, I do have a question.
Yeah.
Before I sign or anyone sign anything.
Yep.
So what am I taking? What's the plea?
So you are pleading guilty. We've already gone through this, to the 3 counts in the indictment. They're right there on the screen. The armed robbery of Ms. Gilbert, shooting Ms. Gilbert, and having a gun in connection with those. Now, Mr. Dean has a different count as well because he was a convicted felon and he's charged with the same gun in the mix. You're charged with the first 3. That's what you've pled guilty to. Ms. Hall already told you about the ranges. It's 10 to 20 or life for armed robbery. We covered all that several times. You're entering a plea of guilty, which I've already accepted to those. So all I'm asking now is whether you will allow me to sign this document for you, or whether you want me to print this out and you're going to sign it. But your plea of guilty has already occurred. This is a formality.
Sir, you may sign it.
Okay, I will sign for you. Mr. Webb, may I sign for you?
She may sign for me, bro.
Ms. Hall?
Yes, Your Honor.
All right. I think we're done. Mr. Brown, do you have any questions about anything?
I was trying to, I was asking, like, what is the time that you're offering?
That I sentenced you to?
Yes.
I sentenced you to 13 years to serve on the armed robbery, 15 years to serve on the aggravated assault. And Mr. Webb can tell you why I did it that way. It has consequences for your eligibility for parole. And then 5 years after the 15 are on probation. So the total sentence is 20 years to serve 15 with the balance probated. That's what I sentenced you to. But Mr. Webb can talk to you about the significance, if any, in his mind of sentencing you differently to the armed robbery than the aggravated assault. Did that answer your question?
Yes.
Okay.
Got a lesser sentence to the armed robbery than the state was asking for. That's what makes the difference. You're eligible for parole on an aggravated assault. So the maximum you can do is 13, and maybe less than that. Okay.
That's his father, Judge. He wanted to address the court.
This Mr. Brown's father? Stepfather. Okay, if you have something brief you want to say, I'm happy to hear from you. I've already accepted the plea and I pronounced sentence, so nothing's going to change. But if there's something you want to get on the record, I'm happy to hear from you on the record. Okay, if you would come on up, stand by. Actually, if you come to the podium so our court reporter can hear.
Parole is when you're eligible for parole. Okay. You have to serve 10 years mandatory.
Morning, how you doing, sir?
I'm doing okay. Can you state your name and spell your last name for the record?
Orlando Nolly, Nolly.
Okay.
So after this, or do they have I think they said something like an MGM program that will allow him to, because he never really been in no trouble. That's why I was like, is there anything, they have that program that they can help him, to let him out? I mean, just so he can get himself together, like a second chance program or something?
So I'm not sure what you mean by an MGM program. And I did hear that this is Mr. Brown's first conviction. And Mr. Webb brought that to my attention, that we often see young men who, this is the culmination of, they were breaking into cars and then they were stealing things, and that doesn't sound like that was Mr. Brown's situation. And that influenced me. He has jumped from 0 to 60 pretty quickly, because this is short of killing someone, doesn't get more serious than this. And that's what I shared with him. I know you just got here, but I'm not aware of anything that would do what you're describing. Now, Mr. Brown will have the opportunity to apply himself while he is in custody. He can get degrees, he can get certifications, HVAC, this or that, so that he's learning useful things for when he gets out. He shared with me his very strong desire, and I believe him, to make a new life and get a second chance. That is a dream that's going to be deferred for a little while because of the, I believe, very understandable consequences of putting a gun in someone's face and then that gun goes off. And that's why we're here. So I'm happy if you've got a specific program you've got in mind, I'm happy to listen to it. But the programs that your stepson's going to be eligible for the foreseeable future will be ones offered by the Department of Corrections as opposed to something on the outside.
Yes, sir. I mean, 'cause I know my nephew, he had similar to the same crime, and they put in this program that allowed him to get himself out to get himself together. MGM, whatever it stands, I forgot what my brother just told me, but I know it made him, he did better as he went through that. Now, about him not being in no trouble, just, I don't know.
Okay. Well, I appreciate you being here for him. It's good that there's family here for Mr. Brown. Okay. Thank you. All right. Mr. Brown, last time, anything more from you? A surprise visit from your stepdad. It's good to have him here. Anything you want to add, or you understand where you are right now?
I really don't understand where I'm at right now.
So tell me what you don't understand.
I mean, I understand the case. I understand someone's hurt, not only robbed, but hurt.
No, you hurt someone.
Yeah.
You shot someone in the stomach after you put a gun in her face. That's where we are. Okay?
Yes, sir, I did it.
So what's next?
I'm just saying, if anything else, 13 years is a long time.
It is a long time. It is a very long time. I hear you. And you told me that when we were here in early November, that, you don't want 15 years, you don't want this or that. Great. Ms. Gilbert didn't want to get shot. She didn't want to get robbed. Fulton County didn't want an armed robbery to happen. There are a lot of things that people don't want. You did certain things, not just bad decisions. You did certain bad things. And a consequence of that is you're going to go to prison for a while. That's not a surprise, and that's not news. I don't expect you to be excited about it. I don't expect you to thank me for it, but I don't understand what you don't understand. You, through your lawyer, asked for a sentence that was not unreasonable. He said 12 years. I gave you a little more than that. I didn't give you more than what the state asked for. I don't think the state's recommendation was unreasonable. If this had happened in some other counties not very far away, the state would have been looking for life because you shot someone during the armed robbery. So I don't think you should be grateful about what's going on. You should be regretful about what you did and the consequences of that. But I don't think there's anything confusing about what's happening right now. You're not happy with it. I get that. But if there's something you don't understand, I'll try to explain it again. I've sentenced you. You don't like the number I gave you. I've tried to explain why it's the number I gave you, but it's not a requirement that you like it. It is a requirement that you serve it. I mean, that's sort of where we are. Is there anything else I can explain?
No, sir.
Okay. Thank you.
Can I ask another question?
Yes, you may. Last question. We got other stuff we need to do today.
Okay. If it's any chance that I know I heard about 2 for 1, so one day count for 2. May I do anything like that?
So what I can tell you is this, I don't play any role in determining your eligibility for release. Mr. Webb can talk to you about that, but that is a Department of Corrections decision, and then pardons and paroles, which is yet another group. They'll be looking at your file to figure out, hey, how's Mr. Brown been behaving in prison? If you're doing well, you're not making trouble, you're not running with the wrong crowd, then that's someone they say, well, we don't need to keep him here. And they'll look to release you maybe before your sentence is out. But that is a decision for other folks. I don't have a role in that. I could say he's a perfect candidate for parole. They'll say, well, that's not your decision, Judge. But it's also not a decision they're going to make right away. You're going to be serving some time before they evaluate you for eligibility.
Yes, sir.
All right. Thank you, everyone.
Thank you, Your Honor.
So we're going to take a 10-minute break. I need to give Ms. Rivers a break. And then my thought is that we do Mr. Dean, since we're in this flow. Does that work for Ms. Wood and Ms. Hall? All right, Ms. Nolly? The deputies would be the ones who'd have to answer that. My guess is they'd say no, there's generally not contact between, it's a very reasonable request, but that's usually not what the deputies are comfortable doing. Okay. I'm gonna come back out here at a little afternoon on that clock. And assuming Ms. Rivers is good to go at that time, we will see if Mr. Dean's plea can happen on his 2 cases.
When would you like me back, Your Honor?
After we do Dean, we'll do, were you able to bring, during the break, could you bring Ms. Gore up? Yeah, can you flip-flop them? Great, so we would do Gore after that, which is Ms. Wood.
I'll come straight back if you'd like. After
No, we got time. If you can be back by 12:45, we'll do non-web stuff.
All right.
We'll probably still be on non-web stuff when you get here, but I want to keep moving. I'm hopeful that this was the complicated one. I don't know that Mr. McKenzie will be a lot simpler, but hopefully Mr. Dean will be, and we got a few others. And I don't want you to think every plea is like this. It's just not. What's she doing here? Look at that. Is that your new DA hoodie? Well, welcome. Who are you here with? A coworker. Did you also defect from probation?
No, he's from Plea.
Okay. All right. Is this your first? Today's like a Wednesday. It's not your first day.
Yeah.
Well, welcome.
All good.
So far, so good? Good. See ya. Does this say trial division on that? I gotta give a hoodie like that. I like that. No, usually you're in court. All right. That's a new thing. Now I know where the $5 million is going. It's not to get new DAs, it's to get everyone hoodies. Yeah. All right. I'll go away so you can do that. Thank you. How'd you draw the short straw today? That was so cute. Meaning, good, excellent, okay.
I'm sorry.
Smart, because it was.
No, she
Once
wants to
again,
add.
Can you
might
bring Ms. Gore up?
I'll let you know.
Okay, well, I mean, we can do the next guy, because the next guy is, Dean.
Dean, yes, sorry, if you see on the radio, there's other folks that come up.
Okay.
So she would be able to score.
Okay, thank you.
How you doing? Good. Unfortunately, they're not gonna allow that. But security. Not sure. I don't set up. I think that was something that. These are.
We keep all of them. Yeah, that's right. Let me see this. So the thing that the video. Yes. I know. Yes, thank you. Oh, God. The back of my office. Will you back before we construction? Yeah, you'll be back. No, you're going to go down. Oh, you're going out to the office? Yeah, just. You need to. That's how I'm gonna stick it in here. There's no more.
Oh, okay.
I want to say something. Yeah.
Okay.
Okay, because I'm confused on keep separate. So Dean and Brown on the same case, but
Dean and
Brown on the same case, but they're not keep separate, which is crazy because we couldn't flip on him. So now we definitely gonna have to let them know they should be a keep separate because they shouldn't have been together in the damn beginning. That don't make no
Yeah,
sense.
'cause
Right.
Brown
They
is
came up together. We brought them up
Really?
together. Yeah, it's not a keep separate
Yeah.
order for them.
because
Now he definitely gonna need some protection if he's finna proffer or whatever.
Yeah.
I don't know if that's gonna happen, whatever. I don't know.
so Brown and that's what I was tripping on downstairs. I was like, hold on, there's three of them. All the
They came up here, Brown, Dean is a keep separate from. What's the other
Dean
boy
is
name?
McKenzie.
Well, why they need to be kept separate for?
Who?
Dean and McKenzie.
I guess they got some other cases together.
No, they don't.
Yeah, they do.
Yeah, they do. It's there right here.
No, Dean and McKenzie shouldn't have.
They don't have any
Yeah,
cases together.
unless they have like, I don't know.
Some
Hold
old
on.
cases, see?
Dean, he's a
Brown, co-defendant, Devonte Dean, the Payne case. Dean, okay, what McKenzie there? Keep separate from McKenzie. Yeah.
They wrote that wrong.
or it's supposed to
Keep
be.
separate from the code.
Yeah, I was about to say, that might be a typo.
Okay, is it right here? McKenzie, Payne cases, Quentin McKenzie, Tony Colby case. Yeah, because that's what I'm like, well,
Yeah.
why don't- No, it comes from him. I
So
don't know.
who? Ms. Nelson did it? Oh, Ms.
I don't know
Nelson.
that she did. That's his own whole game. So I already
I
know.
told Ms. Nelson she messed up, but.
No.
That was the first Linux case.
Yes,
yes, correct.
That was the first. I mean, it's- it's
There were
both
two
of them,
more
it was
after
two
that.
of them.
Yep.
They ran, and one of them jumped over a bush or something.
Yes, ma'am.
Yes.
So you know, what is you not understanding, but you game banging, you thugging.
He was.
Yeah.
Then he was around 56 or 7 years old. He was 17. And so I get it. We were off on life. I'm only going to 10 years because I've been here since then. I think that, I mean, I have to go. They treat me like first time to the district. Sometimes that's like, I want to do a lot of stuff. So, a girl, she's different. You know, so I get it. I felt for him.
I know. In his 15 is fair. That's
The other ones.
Ms. Hall? Ms. Hall?
Yes, ma'am.
Who talking?
We're still, I'm live on YouTube.
Okay.
Can you hear us?
Yes, loud and clear.
Okay, we'll be quiet then.
Here. Under control. Who was that? Miss, that was Miss Karen. Well, thank you, whoever it was.
It was me.
Thank you.
Okay, so who's doing it?
Oh, yeah.
Miss Karen said we still live.
Oh, good to know.
Just like. That is true. Come here, right quick.
Okay.
We're gonna do this, we're gonna come here, we'll get her, I still haven't got her. You said, hold on, what she said.
Let me know you back there. So I didn't take it yesterday. Yesterday, I forgot, apparently I didn't close the bag good enough. And so the ice melted and the water got into the sandwich. So. I was so mad. That I was very, very hungry, so I sacrificed my home with change.
So we'll be in one day.
I switched to American Deli. American Deli. To be perfect. They put something on the wings this time.
So when Brown goes down, Gore will, my female will come up. Is that correct?
Well, because I have McKenzie and Dean separated, I took Brown down already.
Okay.
But I still, because of our paperwork saying everything separate, so I can't
Right.
put each other face in each other. So as soon as we finish, I cannot believe that. Dean.
Okay.
I will get.
That's fine. Yeah, whenever she gets up here, I just need to talk to her for like 5 minutes and then it shouldn't take too long.
Pork on the water.
Where'd everyone go? Ms. Hall is here. That's the important part. Good. Ms. Wood, Ms. Hall, and we are ready for Mr. Dean when you all are. Were we able to get Ms. Gore up?
No, just because on our record, Mr. Dean and Mr. McKenzie are keep separate, so.
Oh, really? Dean and McKenzie?
I think that might have been a typo.
I was trying to figure out, I was trying to find out Brown but on my paperwork, so.
That's good. So we'll do Dean, and then what I'd like to do, if we still have, I worry about losing a few folks. Let me stop sharing. I'd love to do Ms. Hubbard. Take care. She's on the screen. So we'll do Dean. And while we're doing Hubbard, we'll flip flop them. And then we'll go back to after Hubbard, we can do Charles.
Okay.
Or Gore. We'll figure that out. Mr. Whitenauer may need to go there too. All right. We are going to do Mr. Dean as promised, but it turns out that the separation order is Dean and McKenzie.
I heard that was Ms. Nelson.
She's back. It's not important.
Oh,
I don't know.
no.
Ms. Hall's giving you a hard time. She's giving you the short timers approach. Mr. Dean, if you'll come on up to the podium, please. Ms. Rivers, you ready to go?
Yes, Judge, ready.
Great. All right, positions 3 and 4 on our calendar today are Mr. Dean's cases. Ms. Wood, is Mr. Dean entering a plea in both cases, or what's your understanding?
Judge, it's my understanding we're entering a plea on both cases, non-negotiated on the 20 SC.
The armed robbery?
Yes, Judge.
Okay, but I don't remember, something got broken at the jail, I think, allegedly,
Yeah.
is the second one. That's a negotiated plea.
Yes.
Okay, all right. So Mr. Dean, we haven't seen each other for a while. I'm Judge McBurney, and you are here today because Ms. Wood told me that you are ready to enter pleas in your 2 cases. They're non-negotiated, meaning Ms. Hall is going to make a recommendation in connection with both cases that is some number that hopefully you know because she would have told your lawyer. And then Ms. Wood will make a different recommendation, presumably a lower number. And then I'll let you know what I think a reasonable number is based upon all the facts and circumstances. You likely know, and if you don't, I'm telling you now, I just heard a whole lot about your more serious case because Mr. Brown just entered his plea. So I'm familiar with that. I was familiar with it before. We had a bond hearing when Mr. Franklin was handling your case. But I'm going to hear from Ms. Hall. I may hear from Ms. Gilbert again. That's the person who was robbed and was shot in your more serious case. But she spoke with me when Mr. Brown was entering his plea. Then I'll certainly hear from you if there's anything you want to say. Ms. Wood will be saying all sorts of things on your behalf. And if there's anyone else that I ought to hear from on your side, I'll do that. And ultimately, I'll tell you what I think a reasonable sentence is in your 2 cases. I think you still have your final plea rights, which means if you hear the sentence that I pronounce and you don't like it and you'd rather go to trial, you can withdraw your plea, no questions asked. The jury would never hear that you actually tried to plead guilty, and you can go to trial. I think I'll be hearing from Ms. Hall that there'll be some pretty serious consequences at trial if trial doesn't go well for you because of some recidivism notices that I think the state's going to withdraw if you go forward with your plea. But we'll get all that on the record, and then I'll make sure you understand it all. Okay?
Yes, sir.
Great. So the 2 things you need to do is make sure you speak loudly into that microphone, and then 2, answer all of Ms. Hall's questions truthfully and completely once she puts you under oath. All right? Yes?
Yes, sir.
Great. Ms. Hall?
Thank you. And thank you. Please raise your right hand. Do you swear or affirm the testimony you should give in the matter current before this court should be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, my lawyer. Please state your true, correct, and legal name.
Devonte Dean.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
Yes, ma'am.
You wasn't given normal medication that
No,
you take?
ma'am. Not this morning.
What do you normally take while you're at the jail?
Lamictal,
What is that for?
bipolar.
Bipolar? Did you get it yesterday?
Yes, ma'am. Yes, sir.
You've been getting it on a regular basis while you've been at jail,
Yes, sir.
but just didn't get it this morning.
Yes, sir. Because I was down at the holding tank.
Okay, is the fact that you did not get your medication this morning something that's making it hard for you to understand what we're talking about?
No, sir.
You're feeling like you know my role in the process, Ms. Wood's role, et cetera?
Yes, sir.
If at any time things get hazy, will you let me know?
Yes, sir.
Great.
Mr. Dean, how old are you and how far have you gone in school?
26,
And how far did you go in school?
all the way.
Meaning a high school diploma?
Yes, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been, in indictment 20 SC 174164, do you understand that you've been charged with armed robbery, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon?
Yes, ma'am.
In indictment number 21 SC 177527, do you understand that you've been charged with one count of interference with government property?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to all of those charges?
Yes,
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in both of these indictments, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss his case with your attorney?
Yes, ma'am.
You do need more time to talk to her?
What, okay, just want to make sure, so you, Ms. Wood can go back into lockup and talk with you. You have some things you want to talk with her about?
Yes, sir.
Okay. We will take a pause and let you guys do that. Do you, Ms. Hall, you are very flexible. Do you have the flexibility to pivot to Ms. Hubbard? Ms. Patel, are you still with us? I know technically you are. I see your name on there. Shamal Patel, are you there? Ms. Hubbard, if we can get Ms. Patel back on the call, we're going to handle your case. Are you still there? There's nothing on the screen. Maybe they thought they'd be back when Mr. Webb comes back. So Ms. Hall, is it still the situation that you likely won't start your new assignment till mid-December? Like as of today, that's your understanding?
Yes, Your Honor.
Okay. So we can do some good on-the-job training?
Yes.
Excellent.
We've been doing that all week. She may even take some pleas on Friday.
After today, she may say, no, thank you.
She knew what today was.
This is what you mean by having worked things out?
Try some next week.
Mhm. Ms. Patel and Ms. Hubbard, but Ms. Patel probably has the number for Ms. Hubbard. They're both on this call.
I'll see if I can get it against herself.
Great, thank you.
Sorry, Your Honor, I'm here.
Fantastic. Can you try to ping Ms. Hubbard to see if you can get her?
Will do.
Okay.
Judge, may I say something to the prosecutor real quick?
Sure. Who are you waving to?
My grandmother.
Is that the Carolyn's Galaxy?
That's me.
Judge,
Ms. Wood?
if the court can assist, Mr. Dean has a request to have the, and I think we are at the spot in the plea, for the minimum and the maximums for each charge to be put on the record.
Sure.
And why there is no deviation
Sure.
for that.
Got it. So I'll let Ms. Hall do that. Where we had stopped, Mr. Dean, let me make sure Ms. Rivers is still with us because we were going to actually take a different plea for a second, but we're pausing that. Ms. Rivers, are you still with us?
Yes, Judge.
Great. So we're back with Mr. Dean. Ms. Hall had asked you, Mr. Dean, do you need more time to speak with Ms. Wood? And your honest answer was, yes, I do. We took a break. You and Ms. Wood went and spoke for several minutes. You're back here. Looks like you are ready to continue to go forward with your pleas. And Ms. Wood is asking that we get on the record what the sentencing ranges are for each of the counts that you face. And we'll certainly cover that. That may not be the very next thing. I don't know the flow for Ms. Hall, but I promise you we'll get to that well before the real important questions like how do you plead are asked, okay?
Yes, sir.
All right, Ms. Hall.
Mr. Dan, just have my 4 more questions and we'll get to where you'd like for me to be. Are you satisfied with the services of your attorney?
Yes, ma'am.
Do you need more time to speak with her about your case?
No, ma'am.
Okay. Counsel, do you waive formal reading of the indictment?
So wait.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So wait for purposes of this hearing.
And do you waive moving forward on a copy of the indictment? We do. Okay. Mr. Dean, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
Okay, so for armed robbery, the minimum and maximum is 10. The minimum is 10 years, the maximum is 20 years or life. So you can those sentences. By law, if you're convicted of armed robbery, the judge cannot deviate, unless the state deviates, cannot put below 10 years. For aggravated assault with a deadly weapon, the minimum and maximum is 1 to 20 years to serve. So that's a range of 1 to 20 years, and the judge can sentence you to any wide range of the numbers in between 1 and 20.
Yes, ma'am.
For possession of a firearm or the commission of a felony, that is a 5-year sentence to serve that needs to run consecutive to another count in the indictment. So I will run it consecutive to count 1. That just means that whatever sentence you get on count 1, those 5 years will run consecutive, whether that be probated, suspended, or 5 years to serve. It will run consecutive, which means after you finish the sentence on the first charge. You understand?
Yes, ma'am.
And then for the last count is possession of firearm by a convicted felon. The minimum maximum for that charge is 1 to 10 years to serve. So the range is 1 year minimum, maximum is 10 years. You understand?
Yes, ma'am.
For your interference with government property, the range for that is also 1 year minimum and 10-year maximum. So that is the range that we have to stay inside of.
Yes, ma'am.
Have you, well, do you understand that this is for case number 20SC 174164? Do you understand that that is a non-negotiated plea, but the state will still make a recommendation to the court?
Yes, ma'am.
Have your attorney advised you of the offer from the state?
Yes, ma'am.
For that particular indictment, the state's offer for armed robbery is 20 years to serve 15, balance on probation. For aggravated assault with a deadly weapon, it's 15 years to serve. For possession of a firearm during the commission of a felony, it's 5 years suspended to run consecutive to count 1. And then for the final count, which is possession of a firearm by a convicted felon, the state's recommendation is 10 years to serve. You understand?
Yes, ma'am.
As far as indictment.
So the total sentence you're recommending is 20 to serve 15?
Yes.
Okay.
As far as indictment 21SC 177527, that is the count with the interference of government property. The state's recommendation for that case is 1 year to serve. Do you understand?
Yes, ma'am.
Do you understand?
Would that recommendation be to run concurrently with the other case?
Yes, Your Honor.
Okay.
Yes, Your Honor. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment?
Yes, ma'am.
On these indictments, I'm
Yes,
sorry.
ma'am.
Do you understand this guilty plea is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used in enhanced sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand if you receive, possess, use, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
I'm guilty in my best interest.
Okay, let me split the indictments. For as far as indictment 20SC 174164, are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
And how do you plead to the charge?
Excuse me, can we stop slamming the door?
Yeah, so it's not intentional. Unfortunately, the door, when it closes, slams. It's about to happen again. There you go. We will try to minimize the number of times people come in and out of the courtroom. But it's funny you asked that, Ms. Rivers. I'm about to send an email to Ms. Hansberry to get our property management people to adjust that door again, because it slams with a vengeance.
And it's really loud on my end. Thank you.
Sure.
So sorry.
Nope, you had to get out.
Okay, sorry. So I asked, are you pleading guilty to the indictment ended in 164? Well, I'll just go back for Ms. Rivers. Or in indictment 20 SC 174164, are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware, even if you do not admit guilt, this is a guilty plea and it places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
In indictment number 20 SC 174164, how do you plead to the charges of armed robbery, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon?
Guilty in my best interest.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have a limited right? Do you understand you have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that for a felony charge, you have 4 years to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
And as far as indictment 21 SC 177527, I think I spoke as if that was a non-negotiated plea earlier. It is a negotiated plea. And
That's the year to serve.
yes. Do you understand the state is recommending 1 year to serve, but the court can still sentence you to the maximum on that sentence, on that charge, which is 10 years to serve.
Yes, ma'am.
How do you plead? I'm sorry, is it your decision to waive your rights and enter a guilty plea on indictment 21 SC 177527?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
And do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of that guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of 3 prior convictions by the defendant, 2 in which are in Fulton County. One, I was told that it was taken under first offender, but not completed under first offender. And that was because the case ended in 164. He ended up being revoked, but that is, all 3 cases are theft by taken. 2 are in Fulton County, 1 is in Douglas County. Douglas did revoke him sometime that these dispositions were all in 2018 and 19. The latest one, which was the Douglas County case, that was February the 10th, 2000. I'm sorry, that wasn't the latest one, but that was February the 10th, 2018. The latest one was a Fulton County case, which is a theft by taken, disposition date of May the 22nd, 2019.
Okay. And the one that was first offender, the first offender status has been revoked
Yes.
in part because of the charges in 164.
Yes, Your Honor.
Okay.
And had this case I'll start with the latest case, which is the 21 SC 177527. If this case had proceeded to trial, the state expected the evidence to show that on January the 12th, 2021, while Mr. Devonte Dean was being incarcerated at 901 White Street, which is the Fulton County Jail, he got upset about a lockdown that was taking place at the jail. And in response to that, he ended up kicking and shattering a glass with his foot, the cell door. That's pretty much what happened. He did injure himself. So when he did that, so he was transported to Grady.
Okay.
It is my understanding he is healed from those injuries. That is the gist of that case. And then the more serious case, the 20 SC 174164, if that case had proceeded to trial, the state expected the evidence to show, and Your Honor, I know that you just heard all the facts, but I will limit them to Mr. Dean. That on December 21st, 2019, at Lenox Mall, which is located at 3393 Peachtree Road, Northeast Atlanta, Georgia, in Fulton County, officers responded to that location as to a person being shot when they were doing their investigations, they were able to pull a surveillance video from the surrounding areas showing Mr. Devonte Dean and his co-defendant, Mr. Brown, leaving the location from the shooting. They spoke with Ms. Gilbert, who is the victim in this case. She gave descriptions of 2 Black males. She described what those males had on. The surveillance videos were able to pick up on these 2 individuals that had the same clothing on that she gave as a description, running from the garage at Lenox to the nearby train station. The lead officer in this case put out a video to the media to try to get help from the community to figure out who these 2 individuals were, at which point Mr. Dean's stepfather called in and gave information that one of the individuals in the video was his stepson. The information that was given to officers was that Mr. Dean would not turn himself in, but his stepfather did not want him to be injured in the officers trying to apprehend him. So he did help in having the defendant surrender to officers. Ms. Gilbert was shown a lineup of Mr. Dean. Although she did not pick him out of a lineup, she did indicate to officers that his particular picture did look like the guy that was with Mr. Brown, who she did positively identify, but that on the picture, he looked a little darker than he did in person. So she did not want to actually make an identification since she was not 100% sure that that was Mr. Dean. There were interviews conducted in this case, one in which Mr. Brown indicated that Mr. Dean was his co-defendant or his co-conspirator in this case. And you've heard about the injuries from Ms. Gilbert. I'm not sure if she wants to speak again.
I'll ask her in a minute.
But as far as the investigations from what we've learned from the state is that Mr. Dean didn't shoot Ms. Gilbert, but he was there present and was a part of the armed robbery, parties to the crime of armed robbery, although it did turn to something different once Ms. Gilbert was shot. I mentioned to you in the last case that they both, Mr. Dean and Mr. Brown, was on the model train depicting what had happened. It wasn't, I know defense, or not particularly this defense counsel, but prior defense counsels felt as though Mr. Dean really didn't have an understanding as to what happened, and he was just running because Mr. Brown was running. The state has a completely different understanding of what happened. We feel like that he was culpable. He understood what was going on. He ran, and no one made him depict what happened with the shooting and act out what happened. I believe that is all from the state. Yeah, I think that's all, Your Honor.
Mr. Brown's statement to law enforcement indicates to you that Mr. Dean was part of this, knew what was going on, not just I had my friend come and then I surprised him by pulling out a gun and robbing this person.
Right, no, he did say in his interviews that the intention was to rob her, the intention wasn't to shoot her, and that Mr. Dean knew all about it. They only wanted to rob her of her car.
Okay, of her car.
Yes.
What kind of car was it?
Not sure or don't remember, but I'll tell you in just a second.
So that's one of those questions, Miss Charles.
I remember it not being a BMW or something, but she took very much pride in her car.
It's her car.
Wanna give it up.
She should.
Interesting enough, everything's listed as car.
It's not critical. I can ask Ms. Gilbert if it gets important. All right. Anything else from the state?
Nothing further from the state, Your Honor.
All right. Ms. Gilbert, I know you're still with us. You are welcome to make another statement. Your statement was put in the record in connection with Mr. Brown's plea. You don't need to repeat yourself, but you are welcome to share with me other thoughts you've got. It's really up to you.
Okay, Your Honor, Mr. Dean, you guys plotted to rob me to take the 2019 Toyota Corolla. It was a 2019 Toyota Corolla. It was brand new. It was my birthday gift to myself, working 2 jobs, you know what that's like. It's something that I take pride in, working a lot. And I don't know. I don't know what you guys did December 21st, 2019. That is injustice to me. I have to now seek therapy for, PTSD, which I didn't have prior to that. It's unfair to me. It's really unfair. I hurt really bad. I still feel as an adult that you could have stopped Antonio from hurting me. You guys would have to know that I was a Macy's employee. I mean, come on. You would have to know as the adult that I was a Macy's employee. It was clear. My tag was on me. It was clear. How could you entertain such careless behavior? What constitutes to that? What you guys did was really unfair. I hope you learned from this experience, and I hope to God that you guys get justice, that I get justice and peace. I've gone nights without sleep. My back hurts. My feet swells because of what Antonio Brown did. And that is not fair. I did not deserve that. I was a given person. I would give anything if you've asked me. But that day, I drove so long in traffic. The traffic in Atlanta was so bad. I couldn't believe it. I didn't want to give my car. I wouldn't want to give my car because I'm thinking you would hit me and run away. I wasn't thinking you would shoot me and encourage such careless behavior to happen as the adult. What was he doing hanging with you anyways? That's my thought. That's all I thought. What was he doing hanging with you? What did you guys have to prove? Is this some sort of a gang? Is this some sort of something you guys have to prove? Because this is not right. This is not fair. You didn't rob a white lady. You robbed a Black woman. And that hurts like hell. Because now I have to remain in society with PTSD. And now I can't date someone that's like you guys, because now I have to be very careful how I entertain that. That's not nice. That's something that will haunt me for the rest of my life. Now I have to be afraid of every Black man or Black dreaded man. That's not right. That's not right. That's not fair to me. And I hope to God you get your own peace. That's all.
Thank you, Ms. Gilbert. I assume you didn't mean to suggest that it would be okay if they robbed a white woman, but I appreciate you sharing those comments. Ms. Wood.
Thank you, Judge. Before I get started, I do want to let the court know there are a number of family members on Zoom, as well as here present in court. I know Mr. Stevens, Mr. Dean's father, would like to address the court at the appropriate time.
Of course.
Judge, this case is a tragedy. Any way you look at it, I don't have to tell anyone that. On December 21st, 2019, 3 lives directly were forever changed by what happened. Ms. Gilbert's, Mr. Dean's, Mr. Brown's. And on the flip side of that, there were indirect consequences because of this case. We all know the incident location has also changed. There's all kinds of consequences that have stemmed from what happened that day, Judge. So we absolutely understand that and understand the gravity of this case. Also, I want to echo what Ms. Hall said. There was a different attorney on this case for 1.5 years. I believe the posture of the case was headed in a different direction before I came on board. I know Mr. Dean himself was gearing up to go to trial in this case. Myself, Ms. Primovic, Mr. Dean met multiple times. We went through the case forwards, backwards, every which
You
direction.
got all the video, you got orders from me to share the video with Mr. Dean so that he could see what you were seeing.
And Judge, with all of the evidence coupled with Ms. Hall's recidivist notice, we do believe that resolving this case short of trial is absolutely the right decision. We just want to reiterate, Mr. Dean never had a gun in his actual possession on the day in question. There's no evidence that he actually ever demanded anything of Ms. Gilbert. I believe Mr. Brown's interview when he was brought in takes care of that as well, but we did want to put that on the record for Mr. Dean. He was cooperative with the detectives and investigators once he was brought in. I believe there's mention in the police report that he wrote an apology letter to Ms. Gilbert, so he was actively acknowledging his participation, Judge. In negotiating this case with Ms. Hall, I think we came really close to getting this to be a negotiated plea. And so here, right here at the end, it changed a little bit. And so that is why we're moving forward non-negotiated. Judge, we are asking the court to take into consideration that Mr. Dean did not have the gun. He wasn't the shooter, and that he did not actively demand any items. He was present, but not the actual possessor of the gun. We are asking the court to sentence Mr. Dean to a total of 15 years, with the first 10 years to be spent in confinement. We are asking for all credit that Mr. Dean may be entitled to. He was arrested on December 31st, 2019. Judge, if I may tell you a little bit about Mr. Dean as a person, he's 26 years old. He is a lifelong resident of the Metro Atlanta area. He's a graduate of Westlake High School. He has worked for a number of years with his father's carpet cleaning company. He has one son, and he does have a large amount of family support as well. One thing I did want to ask that in talking with his family and with Mr. Dean that we wanted to let the court know about are some of his mental health struggles. He was diagnosed with schizophrenia and bipolar disorder. He's been dealing with that since 2009. I know in the past couple of years, there have been some issues getting his medication and treatment plan in order. So it's my hope and his family's hope and Mr. Dean's hope that the Department of Corrections can assist with administering the appropriate classes or provide the correct medications and treatment while he is incarcerated, so that he may hopefully get the care he needs while there, and then upon his release be able to re-enter society with a clear mind and with his medications in check. So Judge, I'm not sure if the court is able to note anything in the disposition for.
I can recommend, I'm sure you explained that to Mr. Dean. Mr. Dean, the Department of Corrections does what it does. They've got their own set of classification principles and guidelines, and that will help decide what facility you'll be in and the nature of the care that you get, et cetera. But I can certainly recommend that you be housed at a facility that is in a position to work with your mental health diagnosis. Emphasis on recommend. It makes a ton of sense to do that. I'll make that recommendation. I just don't get to tell them what to do, but at least that'll be front and center when they're looking at your situation. You'll get a chance, and that's what's more persuasive. Everyone goes through the same diagnostic center where they learn a little bit more about you, where you're coming from, what your case was about, and that'll be a chance for you to raise your hand and say, you need to know this about me as well. I'll do a whole lot better if I'm in a facility that will guarantee I get the medication I need and helps me work through some of that.
So Judge, yes, we would be requesting that you make that recommendation. And otherwise, we're just asking for 15 serve 10, and then whenever it's appropriate for his father to address the court.
Sure. Let me, and that's the one family, I know there's some people online as well, but it's Mr. Dean's father.
Yes. Judge.
Great. So he should come on up, stand near Deputy Warren. So if you don't mind taking your mask off so we can hear you, and if you'd spell your last name for the court reporter.
Last name is Stevens, Stephephens.
Mr. Stevens, thank you for being here.
Yes.
Tell me what you want to tell me.
Yeah, absolutely. First of all, let me just offer empathy and sympathy for everybody involved. As a parent, your wish is that all of the right stuff that you try to do and put in front of your kids, the time that you devote, the interest that you devote, results in good results. It has been a challenge with Devonte, and I've come to a conclusion prior to this situation that a lot of the challenges have had to do with his mental health. I was so glad to hear his attorney address that with you and your commitment to move forward and making sure that he has an opportunity as a young man to work through something that he's not responsible for. His inability to make sound and solid decisions. He's working with me, and one day he's the greatest employee in the world, and the other day, next day, he may not even think about coming. He may go out and not even think about that he has a job. So the reality of that became not that he's a bad person, not that he has bad intent, but there was something beyond his ability to decipher between making solid decisions. And in discussing that with his mother and with his grandfather, it came to a conclusion that this mental health thing affects a lot of things, not just this situation. So we support him totally as a family. But our interest is we want to see him have an opportunity to get through something that he's not responsible for. It's in his DNA. And unfortunately, through the medicines and other situations in life where you see these situations, I don't think these people check their box that I want to go to the mall. And I know my son, the woman that, and Ms. Gilbert, and I certainly feel your concerns, but I don't think, knowing my son, that his thought that day was to get up and go to the mall and shoot anybody. His mother is pretty much the same age. He adores his mother. They have a great relationship. But once again, his inability to decipher and be clear about what's happening and to act accordingly, especially in a leadership role, is diminished because of his mental health. And so we put ourselves today in front of you, in front of this court, to say that we're not here to extract him from responsibility. But this mental health thing has got to be a bigger concern, not for him, but for everybody. This is a big issue that doesn't get addressed. And the protocol that we oftentimes deal with this in does not lead to an opportunity for development. It leads to an opportunity for depression, suicide, and things of that nature that none of us want. So it is our prayer today that he can be dealt with in a manner that still allows him to come through or to get the help that he needs, that can provide him with an opportunity to have some normalcy in his life, whatever the circumstances may be.
Thank you, Mr. Stevens. That is real insightful. And I will tell you, I share your interest in doing what we can to divert folks whose underlying issue is a mental health issue as opposed to a criminal issue. And unfortunately for Mr. Dean, the criminal activity in which he got involved is serious enough that a lot of the diversion opportunities we have were not available to him. We have folks who aren't properly medicated, who are bipolar, who are manic depressive, who are whatever, and they're off their medications. And so they're trespassing, they're panhandling. We are beginning, belatedly, far too late in the process, to say, let's get those people to help rather than to jail. Historically, the reaction has been you call 911, the police come and say, this guy's trespassing. He's been told 100 times to stay at the Shell station. He's back at the Shell station, so we got to lock him up. That helps no one because he's back at that Shell station in 3 weeks after he spent 3 weeks in the jail. So I'm very much aligned with you. I hope you can understand where it's more complicated when the criminal activity that's connected involves a gun, someone gets shot. Not saying your son did that, but that's what he got mixed up in. And so people are a lot less comfortable saying, let's divert this young man to get that treatment with the possibility of getting right back out. That's not to say there shouldn't be treatment, and we'll make sure the best of my ability that that happens. But I'm glad that there's another spokesperson out there saying there are hundreds and hundreds of people working through what your son is working through. And usually the way to address that is to connect them with resources, not to push them into jail, because they get back out untreated and then the problem repeats itself. Appreciate your time. You're welcome. Ms. Wood, anything else?
Briefly, Judge, to follow up on that. So this was Mr. Franklin's case for a year and a half. I came on board a few months ago. When I first met Mr. Dean, his request was for something along the lines of behavioral health treatment court, and we went through that this charge does not qualify. So I did want to let the court know that he was interested in that as well.
Sure. Mr. Dean, anything you want to add? You don't have to say anything at all, but you have a right to be heard if there's anything you want to share.
Your Honor, if I was to get sentenced today, I just want to hug my mother.
Okay. I got a couple questions for you. I heard you have a child. Is that right? Boy or girl?
Little boy,
Little boy? What's his name?
Dyson,
Okay. And does he live with his mom or with his auntie or
with his mom.
with his mom? Okay. Tell me how you got to know Mr. Brown in this case.
Like buying marijuana
From him or with him?
from him.
Okay. So that was the way your relationship began, is that he was a source of supply for you.
Yes, sir.
Okay. And then did you guys end up hanging out? Is that why
No, sir.
that day you were together? I'm not going to have you go through the whole process. I just am curious because as Ms. Gilbert pointed out, you guys are different age and in theory we're moving in different circles. You're local. Mr. Brown had been living in another state for a few years.
Yes, sir. I contacted him to purchase marijuana, and he told me where my location was. I told him I'm at Lennox. He said he'll meet me there.
Okay.
In the back of the parking garage, and from there
It spiraled out of control.
I didn't expect that to happen, sir.
Okay. Mr. Dean, you are entering what we call an Alford plea or best interest plea to the more serious case, the armed robbery case. And I can accept that. That is a situation where a defendant says, you know what, Judge, it didn't necessarily happen the way the state says it happens. But I don't want to run the risk of going to trial because the state could still convince a jury after they see this and hear that and given my criminal history. I, meaning Devonte Dean, feel that it's in my best interest to work this out with a plea rather than go to trial, even though I'm not saying that I did everything the state says I did. Does that describe your situation?
Yes, sir.
Is that what you'd like to have happen?
Yes, sir.
Okay, I will accept it as an Alford plea. I do find, Mr. Dean, that there's a factual basis for your plea. I appreciate that you were not the guy with the gun. You were not the guy who pulled the trigger, but you were what we call a party to what was a real serious crime that really just got exponentially more serious when Ms. Gilbert got shot. I also find that your plea is knowing and voluntary. Voluntary means that you've decided that entering a plea is the better way forward for you rather than going to trial. Is that a correct statement?
Yes, sir.
A knowing plea is just one where you've understood everything we talked about. And if you didn't, you said, time out, I got a question. And Ms. Wood answered it, or I answered, or Ms. Hall answered it. Do you have any questions that you feel have not yet been answered about your case or your plea?
No, sir.
Okay, then I'm going to accept your plea. Part of your sentence will be on probation. So I'm sentencing you pursuant to what's called the Probation Options Management Act. That means that while you're on probation, if you have a small problem, a technical violation of probation, you and probation can sort through that. But if it's more serious, it's something for which you get arrested, so new criminal charges, that'll come back to the judge and we'll figure out what consequences ought to flow from a new arrest while you're on probation in this case. Mr. Dean, I understand that you are connected to this case in a way that is different from Mr. Brown. You've added a little more flavor, helping me understand your connection to Mr. Brown. and why the two of you got to know each other, why the two of you may have been together on that day, that very unfortunate day when, as Ms. Wood has put it, I think quite accurately, 3 lives were changed forever. So I do think that your involvement was less in some ways than Mr. Brown's, although as Ms. Gilbert also noted, you were relatively speaking the adult in the situation. And so it's a little confusing that it played out the way it did. But the bottom line is you were part of it, and it had these real serious consequences for everyone involved. I'm going to sentence you, Mr. Dean, on count 1 to 11 years to serve, on count 2 to 13 years to serve. Count 4 will be 10 years to serve. Those will all run concurrently with each other. And then count 3 has to be consecutive, has to be 5 years. I'll probate that. So it's a total sentence of 18 years to serve 13. And that's, so we're clear, that's in the case ending in 164, because you have 2 different cases. I also find there's a factual basis in your non-Alford plea in the interference with government property case where you got angry with the door. And that's the case ending in 527. Your sentence in that case is 1 year to serve. It will run concurrently with your sentence in the case ending in 164. Mr. Dean, you'll get credit for all the time that you've been in. That will be part of the sentence you've already served. It will be my recommendation to the Department of Corrections that you be housed in a facility that is best equipped to help you work through your mental health issues and to treat you for those. It will be a special condition of your probation that you have no contact with Antonio Brown once you're out, and that you also stay away from the Lenox Mall, Phipps Plaza area. Should you continue to live in the Atlanta area, that area you'll need to stay away from while you're on parole or while you are on probation. I suspect you'll be on both, parole for a little bit and probation for a little bit longer. Ms. Hall, anything else in connection with Mr. Dean's case?
Nothing further from state.
Ms. Wood, Mr. Dean does enjoy his final plea rights, so I'll have you explain to him sort of why you think I structured the sentence the way I did, its impact in terms of parole and whatnot. And then if you let me know if Mr. Dean wants to persist in his plea or if instead he'd like to have this case go to trial on November 30th.
If we
Thanks.
have a moment.
Yep. And Ms. Patel, we're going to wait just for a sec, but I'd like to do Ms. Hubbard's plea next if you and Ms. Hubbard are still with us.
I am.
Okay, we're going to do Ms. Hubbard. You guys should sit tight just for 1 second, just to see. I'm assuming Mr. Dean's going to say, yes, I want to go forward, but he'll pop out in the doorway and his lawyer will come out. We just need to get confirmation that this is happening or not. Ms. Hubbard, are you there? Ms. Patel, do you have a way to see if Ms. Hubbard can return to her screen?
I'll try to call her. I just hope she's not using her cell phone. We'll
Right.
see.
Okay. Because he got revoked. But I think he's been in nonstop since he got arrested. I mean, he may have been in other facilities, but I think I would.
Hey, Miss Hubbard, can you hear me?
I've tried that too and wasn't successful. She may have gone to lunch, so she could be back soon. We've got other cases we can do.
Ms. Hubbard, your plea is next. Give me a thumbs up if you can hear me.
Oh, I see her now. That's great. She's sideways, but she's there. Progress. There she is. Hey, Ms. Hubbard, can you hear me?
Ms. Hubbard, can you hear me? Give me a thumbs up if you can. Okay, your plea is next.
Great. Excellent. Ms. Rivers, are you good going a little bit more, or do you need a break right now?
No, I'm good. Let's keep going.
Amen to that. Well, why don't we start with Ms. Hubbard? We'll pause when Mr. Dean and Ms. Wood are done chatting, but that'll be a 2-second discussion with them, and then we'll bounce back to Ms. Hubbard. So why don't we start with that? Ms. Hubbard, are you able to take yourself off mute?
Yes.
Excellent. Perfect. Well, we're going to start with your plea now. It's position 11 on our calendar today, 19 SC 165337. And Ms. Hubbard, Ms. Patel, your lawyer, has told me that this is a negotiated plea. So we'll get started in a moment. I need to know that you are okay, Ms. Hubbard, with 2 things. One, that you are appearing remotely. You have a right to be here in open court, but you are electing to appear over Zoom. Is that correct?
Yes, sir.
Okay, and you're all right appearing via Zoom?
Yes, sir.
Great. The other thing is that Ms. Patel is appearing via Zoom. She's not here in court either. More importantly, she's not sitting right next to you. You and she can have a private discussion if you need to, but are you all right with Ms. Patel appearing remotely and not being by your side?
Yes, sir.
Great. Then we're going to move forward. Ms. Hall is going to put you under oath in just a moment, Ms. Hubbard. Once you're under oath, you're going to need to listen carefully and answer all of Ms. Hall's questions, and we will take it from there, okay?
Yes, sir.
All right, hold on 1 second. Ms. Wood, is Mr. Dean comfortable going forward?
We're good, Judge.
Okay, great. Thank you so much.
Does he need to come back out here, or are we done?
No, if he's good, we're good.
Yes, Judge.
I'll take care of the paperwork.
I'll add that to the end of the record, Judge.
Thank you. All right. Ms. Hall, when you're ready.
Thank you, Your Honor. Ms. Hubbard, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Charnay Hubbard.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you haven't taken today?
No, ma'am.
How old are you and how far have you gone to school?
I'm 29 to 12th grade.
Okay. And are you able to read, write, and understand the English language?
Yes, ma'am.
And for the record, Your Honor, the state will be nullifying counts 2 through 4, which are willful obstruction of a law enforcement officer by use of threat or violence. And then 7 through 14, which include criminal trespass.
A bunch of cruel, yeah.
6 counts of cruelty to children in 3rd degree, and then 1 count of simple battery against a police officer or detention officer.
So put differently, we're going forward with 1, 5, 6, 15, 16.
Oh, there's another page. No, we're gonna know probably 16, 15, and 16 as well.
Okay, so we're going forward with 1, 5, and 6.
That is correct, Your Honor.
1 is still a felony,
It is.
and then 2 misdemeanors.
Yes.
Got it. Thank you.
You're welcome. Ms. Hubbard, do you understand that you've been charged with willful obstruction of a law enforcement officer by use of threats or violence, 1 count of simple assault family violence, and 1 count of simple battery family violence?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment including any potential defenses.
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
We waive.
One moment, y'all. Ms. Hubbard, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum maximum sentence for willful obstruction of a law enforcement officer is 1 to 10 years to serve. And the maximum for both misdemeanor, simple assault, and simple battery are both 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for the willful obstruction of a law enforcement officer, 2 years probation, 2 years on probation, and for both misdemeanor counts, 1 year on probation. But
Yes,
the court,
ma'am.
do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another.
Yes, ma'am.
You're recommending they all run concurrently?
Yes, Your Honor.
So 2 years probation.
Yes, Your Honor. Ms. Hubbard, do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to remain silent and not incriminate yourself, and the right to testify if you wish to?
Yes, ma'am.
Do you understand by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 19 SC 165337, how do you plead to the charges of willful obstruction of a law enforcement officer by use of threats or violence, and to simple assault, family violence, and simple battery, family violence?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have 30 days to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a misdemeanor charge and 12 months from today for a felon? I'm sorry, I crossed those. 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state, there's no felony convictions for the defendant. And
You're not aware of any criminal history?
no, Your Honor. And had this case proceeded to trial, the state expected the evidence to show that on February the 15th, 2019, at 3289 Sim Street, that's in Hateville, Georgia, Fulton County. Officers were dispatched to that location in reference to a disturbance call. When they arrived, they were able to see the disturbance taking place on the inside of the home. Ms. Hubbard was in a dispute with her mother, and officers intervened. One of the bless you.
Thank you.
You're welcome. One of the children that were inside of the home at the time told officers that her mom had hit her grandmother during the dispute. When officers tried to intervene with Ms. Hubbard, she ended up, she was yelling and making threats to the officers. She even flicked a lit cigarette to one of the officers. Officers tried to detain her, at which point she ended up elbowing one of the officers in the head. Several children, they all were present inside of the room when this occurred. But there is no evidence that she did anything to them other than the dispute.
They watched it.
Right. And that is why the other charges for the willful obstruction, which is other officers trying to intervene to arrest Ms. Hubbard. That is why the state decided to nullify those charges. She is taking responsibility for what she did that day. I know Ms. Patel will tell you more about her history and the things that she suffers from, but those are the reasons why we decided to nullify those additional charges in this case.
So Ms. Heinzman, Hindsman, would be her mother. One of the counts you're not, I guess that's the simple assault family violence. That's
right. So I should have looked at the indictment more closely when I the intention was to keep the assault and the battery against her mother, which is.
So that's in there, I guess, but that's what I'm asking. So her mother is Robin Heinzman.
Yes.
Okay, because that's in there. There's the assault hitting Robin Heinzman with a bottle.
Yes.
And then the battery, which is just making the physical contact. And it says that's the parent. Well, it describes her as a different role, that Robin Heinzman is the parent of Ms. Hubbard's child, which would work if Robin Heinzman is male, but we'll see. I'll let Ms. Patel clear some of that up as well. But law enforcement, I mean, you've talked with law enforcement, they're not gonna learn about this resolution and say what's going on.
No, I spoke with the lead investigator on this case, and that's how I know how the other officers were involved and no one was actually injured. So I didn't inform them of my intentions.
Okay, got it. Officer Brown, do you have any criminal history for Ms. Hubbard?
I'm sorry, Your Honor. I am not in front of my computer at the moment, but I know that she is not on any felony probation at this time.
Okay. Well, Ms. Patel, you may be able to address the next question then, and then I'm happy to hear from you about the rest of this case. I didn't hear Ms. Hall say anything about first offender, other than that she said Ms. Hubbard doesn't seem to have an adult criminal history. Is this a case where first offender is being sought or not?
Your Honor, we're asking for conditional discharge under 1613-2. So the drug first offender.
How does that fit here?
She was very, very deeply intoxicated at the time.
Okay.
And I can offer more information about this incident, Your Honor, when you're ready.
I am ready.
Your Honor, so this case is fairly old, from 2019. Ms. Hubbard was suicidal at the time. Essentially, this incident between her mother was her trying to make an attempt, her mother trying to stop her. She was very intoxicated, struggling essentially with a drinking problem and balancing her mental health. And she barely has any recollection of what she did. She is absolutely here to take responsibility, but that is how out of it she was at the time of the incident. her behavior towards the officer was inappropriate, but in the description of what the officers write, it seems very clear of someone who is not themselves. The initial attorney who had this case was Mark Kerr from our office, and he referred Ms. Hubbard to BHTC, and she was in BHTC for some time, and then she picked up a subsequent case, and BHTC kicked her out because of that case, which ultimately ended up being null prost. I had that case. Essentially, she was loosely tied into an incident, and the state felt that there wasn't enough there, and there wasn't any harm that Ms. Hubbard had committed. I tried, I would say, for the past year to beg and plead with BHTC to let them back in, let Ms. Hubbard back in, that they were not interested in having her come back into the program. With that being said, Ms. Hubbard has on her own been going to 10 Park Place. She gets her medications regularly. She's been consistent about them. When I met Ms. Hubbard, after she had been kicked out, she was in custody for about 180 days, close to that. And our first meeting, she was very different. Now she's a very calm person. She's one of my few clients that is very easy to communicate with. Her cell phone number changes. She takes all my calls. I can text her, I email her. And I've always been impressed with the fact that she's managed to come to every single one of the court dates, even if it's in the middle of COVID. And so I thought about options outside of BHTC, but I do feel that Ms. Hubbard has on her own gotten her life back on track. And I think that that's a testament to her willpower. Obviously, as a term of her probation, we would just ask that Your Honor request that she maintain her regular appointments with 10 Park Place and stay on all of her prescribed medications. But we are asking Your Honor allow her to do this under conditional discharge, and that you accept the plea as negotiated.
Your Honor, this is Officer Brown.
Yes, ma'am.
Ms. Hubbard did have 2 Fulton County cases. They were both sentenced under a first offender, 16 SC 143584, and that was for terroristic threats and acts, and that was in 2016. And another 16 SC 144273, and that was for aggravated assault in 2016, and they were both first offenders.
And did Ms. Hubbard successfully complete those, or are they still open?
No, they are no longer open.
I'm just looking at one of them, get a flavor for it. Okay. So my understanding, Ms. Patel, is that conditional discharge would still be available to Ms. Hubbard. Her first offender that she used would be under the first offender statute.
Correct, Your Honor. And I believe, and I could be misspeaking, but I believe those 2 cases were both reduced to misdemeanors that she took first offender on, but I need to double check my notes.
Okay, at least one of them was. I'm looking at the aggravated assault case. Aggravated assault was dismissed by the state, and Ms. Hubbard pled to criminal trespass first offender, 9 months probation. So I'm guessing that the other one would have mirrored that if they were pleas at the same time. Interestingly, it told her to stay away from Sim Street, but but I guess that expired. So, okay. Ms. Hubbard, is there anything you want to add, or did Ms. Patel cover what you wanted her to cover?
Yes, Your Honor, Ms. Patel covered everything.
Where are you staying these days?
I'm staying with my uncle now.
How long have you been there?
About 2 years now.
Okay, so that's a stable place for you to be?
Yes, sir.
Are your children able to stay with you, or do they stay somewhere else?
No, my kids stay with my mom, but I get them on the weekend here and there when she have to go to the doctor and stuff. But they stay with my mom.
Are your children with your mother because you and your mother arranged that, or did DFACS say that's how it needed to be?
No, my kids been with my mom. She had custody of them when I had a mental breakdown since 2010, and I signed rights over to her, temporary guardianship over to her.
How young is your youngest child?
He's 4.
How old is your oldest child?
14.
Okay, and they're all of them are with your mom?
My mom only has custody of 3 of my kids, but they all stay there because that's where they go to school at.
How many kids are we talking about?
5.
Okay. All right. Well, Ms. Hubbard, I find there's a factual basis for your plea. It sounds like in February of 2019, you were going through some pretty dark times. The police ended up showing up, and it sounds like you don't remember much of what happened, but enough people who were there were able to describe it. I also find that your plea is knowing and voluntary. Is there any question you have, or do you feel like you've understood what we've been discussing?
I can understand what you all been discussing.
Okay. And has anyone forced you to enter this plea, or are you entering the plea because after talking with Ms. Patel, you've decided it's the right thing for you?
Yes, I've decided after talking with my attorney, it's the right thing to do.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Ms. Hubbard, is that while you're on probation, if you have a technical violation, that's a little one, like you miss a meeting or something like that, you don't have to come see me. You'll work it out with probation. But if it's more serious, if you get arrested again, that comes back to me. Okay?
Yes, sir.
Ms. Hall, I didn't hear you say anything about no contact with Ms. Hubbard's mother or anything like that. It sounds like that would be impractical because the kids bounce back and forth. But 2, mom is not asking for that.
That's right, Karen.
Okay.
No reasons.
Ms. Hubbard, I am going to sentence you on counts. Did I hear you correctly, Ms. Patel, that Ms. Hubbard ended up spending about 180 days in jail in connection with these charges?
Your Honor, there was 81 days on the first arrest, and then when accountability court kicked her out, it was 177 days after that.
Okay. All right. So I'm going to sentence you on counts 5 and 6. That's when you were beating on your mom, to 4 months to serve. But I'll give you credit for the time you've already served, and you've served more than 4 months. So you're not going back into jail. And then on count 1, I'm sentencing you to 2 years. That'll be consecutive to count 5, and it'll be probated. I'm going to waive your probation supervision fees for the first 3 months. I will make it a special condition of your probation that you continue with all treatment that you're getting through Grady that helps you with mental health issues, okay?
Yes, sir.
And that includes taking any medication, anything you've been prescribed by a doctor, you need to keep taking while you are on probation, okay?
Yes, sir.
And then I'm going to request, I don't get to tell them this, but I'll request it, that probation assign to you a probation officer who is trained in supervising folks who are dealing with mental health issues.
Yes, sir.
I will sentence you pursuant to OCGA 1613-2C, because I find that while these are not crimes involving drugs, they were crimes that were the byproduct of you being addicted to a controlled substance / alcohol. And I think that's an appropriate use of this provision. You should know, Ms. Hubbard, though, you are now out of all of these first offender conditional discharge type things. I hope you never get arrested again, but if you do catch new charges in the future and they're felony charges, I think you will actually be taking a felony if you end up pleading guilty or going to trial and getting convicted. My hope is you have found some stability with your housing and your treatment, and we have worked past that. Ms. Hall, anything else in Ms. Hubbard's case?
Nothing further from the state, Your Honor.
Ms. Patel, anything else?
Nothing further from the defense.
Thank you for your work on Ms. Hubbard's behalf. Ms. Hubbard, do you have any questions?
No, Your Honor.
So Officer Brown may have some questions for you because you are going to need to very, very soon report to probation. Officer Brown, what do you need to know from Ms. Hubbard?
I just need Miss Hubbard's telephone number.
404 729 0259.
Okay, Miss Hubbard, I will call you this afternoon with reporting instructions.
Okay.
Great. Thank you, Officer Brown. Ms. Hubbard, you are free to go. Nope, you're not free. Oh, right. Sorry, I forgot. One thing I always forget. Good thing Ms. Hall is here for a few more weeks. Ms. Hubbard, if you were here in court, I would have you sign your indictment, but you're not here in court. Do you authorize me to sign your indictment?
Yes, Your Honor.
Ms. Patel, may I sign on your behalf?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Good, because I've already done it, but I'll make it official now. Thank you, everyone. Now, Ms. Hubbard, you're free to go. Look for your phone for a call from Officer Brown. And Ms. Patel, I think that's it for you. You're welcome to stay on, but if this was your only case, thanks for your time.
Thank you, Your Honor.
Take care.
All right, bye-bye. So it's 1:30. I want to take everyone's pulse. We've got some other cases we need to work through. We've got Ms. Gore. I know Mr. Whitenauer has been waiting patiently on the call to do that. I'm happy keeping going, but I want to make sure, number one, our court reporter gets the break she needs. Two, that our deputies get the breaks they need, although I think you get replacements so you can get a break, but you tell me. But we do want to work through Ms. Gore's plea. Mr. O'Neill will be quick. Mr. McKenzie, I fear, is going to be more like Dean and in particular Brown, but we'll do that. Mr. Charles will be short and sweet, I hope, although, well, you've met Mr. Charles. I've met him too. We'll see what happens. And that's it, but that's still plenty. So Ms. Rivers, I'm going to start with you. Do you want to take a half-hour break or do you want to keep going? You're on mute, but so I'm going to answer for you. No, what would you like to do, Ms. Rivers?
I would like to keep going. I'm good.
Okay. Ms. Hall, are you able to do that?
Fine.
Okay. Then why don't we do, I think it's easier if we do the female next. Yep. So we'll do Ms. Gore next. Mr. Whitenauer, I assume, approves of that one. And Ms. Charles, you are free. You're welcome to stay the whole time and learn. But if you need to take a break, do it. You guys can tag team, relieve each other, who knows what. Ms. Wood, are you okay if we keep going?
Please, let's keep going.
All right.
So Your Honor, what I want to know is how did you get jurisdiction over members of the royal family?
You'll see soon. Credit for time. She's already done 4 months. Yeah. Credit for credit. Yeah. So 5 and 6 are 4 months to serve concurrent with each other. Credit for time served. And then 1 is 2 years consecutive. To whether 5 or 6, you pick.
Okay. Any questions? Anything that the prosecutor asked you? You can absolutely go from me.
Ms. Wood, let me know when you are ready.
We're ready, Judge.
Great. We are now turning to position 5, which is State versus Ms. Gore. Hello, Ms. Gore. How are you? Good. I can. Ms. Gore, it's going to be important that you speak up as loudly as you can into that microphone, okay?
Yes.
Thank you. Ms. Gore, in just a moment, Mr. Whitenauer, who's going to be on the screen in front of you, is going to put you under oath. Once you're under oath, you need to be sure you answer all of his questions truthfully and completely, okay?
Yes.
Will you let me or Ms. Wood know if you have any questions?
So he's asking if you needed a minute when Mr. Whitenauer's asking questions, if you'll stop and let me know that you need to ask me a question.
Yes.
Okay.
You'll do that? Fantastic. Good. Mr. Whitenauer, when you are ready.
Thank you, Judge. Ma'am, my name is John Whitenauer. I'm an assistant district attorney with the Fulton County District Attorney's Office. As Judge McBurney indicated, I'm going to ask you some questions, but before I do, I'm just going to ask that you raise your right hand and I'll swear you in. Do you swear or affirm the testimony you're about to give and the matter pending before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, if you please lower your right hand, and if you would please state your name.
Rhonda Gore.
And ma'am, if you could state your date of birth and your age.
4266, 55.
All right, and ma'am, are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
Yeah, sir.
And can you read and write in the English language?
Yes, sir.
And have you had the opportunity to review the document that charges you in this case? That is the indictment.
That's this right here that we went through together. Like, so this is the official indictment and that's the charge. He's asking if we've had a chance to go through it.
No, we didn't do it. I don't do that.
So Ms. Gore, it's okay if you didn't read it all by yourself, as long as you and Ms. Wood discussed it. Did you have a chance to discuss that document, your indictment, with your lawyer?
Yes.
Yes, good.
And ma'am, do you fully understand the nature of the charge pending against you, the registry violation?
Yes.
Ma'am, in entering a plea today, you need to understand that you're giving up certain rights. By entering a plea of guilty, you give up the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses who may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on this charge by a jury?
Yes.
Okay. And by entering a plea of guilty today, you need to understand that for this one count of violation of the sexual offender registry, you face a sentencing range of 1 to 30 years in confinement. It's just what the law calls for, and you need to understand that. Do you understand?
Yes.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything anywhere?
No, sir.
So I do believe, just for the record, I think there is a Douglas County probation. But she's understands that she's not like in custody for that right now.
Okay.
So
And we'll hear from Officer Brown about anything that may be active for Ms. Gore.
Thank you, Judge.
Sure.
And ma'am, earlier I mentioned to you what the sentencing range is, but your attorney and I have spoken about this case and we've come to an agreement, and I assume that she's communicated this to you, but we discussed by you entering a plea of guilty to this one count that the state would recommend that you be sentenced to 5 years to serve 6 months with the balance on probation, with the special condition that you register per the statute regarding registry. That is 42-1-12. I'll note that as of today, you've been in confinement for 178 days. So we'd be asking that that be commuted to time served, and you would have already served that sentence. Does that make sense, ma'am?
Yes.
Okay. Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum permitted by law, which, as I indicated earlier, is 30 years? I'm not indicating what the judge is going to do. I just have to advise you that that's what the judge could do.
Yes.
Okay.
Okay. And Your Honor, will you be allowing Ms. Gore to withdraw her plea today?
Yes, if I sentence Ms. Gore to more than what you all have negotiated, she'll have the opportunity to discuss with Ms. Wood whether she wants to withdraw her plea and go to trial.
All right, thank you. And ma'am, earlier I indicated to you that I'd be asking that there be a special condition of your probation, simply that you register per the statute, which concerns registration. Do you understand?
Yes.
And ma'am, are you entering a plea of guilty with an understanding of everything that we just talked about?
Yes, sir.
All right, and if you can, just try to speak up a little bit into the mic to make sure that
Yes, sir.
Ms. Rivers can hear us, okay? And has
Yes,
anyone
sir.
used any, okay, has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, sir.
Are you satisfied with what your attorney has done for you in this case?
Yeah, sir.
Do you have any more questions for your attorney before we go on?
No, sir.
Okay, there's a bit of a delay there, so if you do,
No,
this will
sir.
be the time to speak with her. Okay. Have you understood everything that I have asked you so far?
Yes, sir.
And understanding all of your rights, do you wish to enter a plea to this charge today?
Yes, sir.
And how do you plead to the one count of state sex offender registry violation?
I said not guilty.
Say right here, say guilty.
Guilty.
Okay. And is your decision to plead guilty made freely and voluntarily?
Yes, sir.
And ma'am, are you a United States citizen?
Yes, sir.
All right. If you wish to challenge this plea for legal error, you have one of two ways to do it. Your attorney can explain what those ways are, but I have to give you a few advisements. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file a direct appeal. The second way is a habeas corpus petition. And for this felony, you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of your plea. Do you understand those time limits, ma'am?
Yes, sir.
Okay. Your Honor, this is a pretty straightforward registry violation case. The defendant was sentenced or convicted of child molestation on October 1st, 2003, and sentenced to 5 years of confinement, followed by 15 years on probation. She was required to report 72 hours prior to her birthday, which is April 2nd, which would have been on April 2nd, 2020 for this indictment. She failed to do so, and the Fulton County Sheriff's Office issued a warrant for her arrest for that failure. She does have some prior failure to registers, one in 2016 out of Douglas County, an earlier one in 2009, also in Douglas County, and then there's the underlying offense of child molestation in 2003. That's all from the state, Your Honor.
Mr. Whitenauer, the child molestation case, is that out of Douglas or out of Fulton?
Douglas, Your Honor.
Okay, so I guess I'll learn this from Ms. Wood. At some point, Ms. Gore has shifted from Douglas County to Fulton County as her county of residence.
That's my understanding based on my review of the registration notes from the Sheriff's Office.
Got it. Okay, thank you so much. Officer Gore, what cases remain open for I'm sorry, Officer Brown, what cases remain open for Ms. Gore? Sounds like the child molestation case ought to still be open maybe for another year or two. Anything else?
No. No.
Hold on, he's asking the probation officer.
Officer Brown is otherwise occupied. It's not going to change a whole lot of what we're doing. I just wanted to understand.
I thought I heard her say no, Judge, but.
Well, I think Ms. Gore said no,
All right.
as opposed to Officer Brown. Okay, well, I'm fine moving on. Ms. Wood, what do you have to share about Ms. Gore's situation?
Thank you, Judge. So Ms. Gore was actually on a calendar before this court in July of this year. And I had actually negotiated a case with ADA Parish. That was a day that Ms. Primovic was filling in for me. Ms. Primovic decided that she had some concerns, so she didn't feel comfortable moving forward as the stand-in, which is totally understandable. Judge, this is another sad case. Ms. Gore is 55 years old. She has been on the registry since 2003. There are some disabilities. Her lovely sister, Rodina, has been very active in trying to make sure that she does not miss report dates near her birthday. The reason that she missed last year is because that was during the height of the pandemic. The sister had actually thought she misunderstood the lockdown guidelines and didn't realize, she thought that it wasn't going to be open for them to report. So that miscommunication is what led to this charge. Douglas County, it's my understanding, actually picked her up on their violation for that last October. So it appears that she's actually been in for over a year, but some of that was for the Douglas County stuff. So she did get here on this charge on May 24th of this year. So the state is correct. She has been in 178 days. So we're asking for that credit. And then we just want to share some other things. So the sister, Rodina, will actively help her make sure that she does not miss another report date. She does have an 11th grade education. Before she missed the report date, she was working for a cleaning service. She has a grown adult son in Hapeville. She's going to reconnect with him once she gets out. We're going to make sure that she does her best to not miss another report date. Judge, we would just ask that you accept the state's recommendation.
Got it.
And I'm a little bit sick right now, so I'm gonna have to take care of my health.
Okay.
Officer Brown, Officer Brown dropped out. I think Officer Brown was having some technical issues. Whoop, Officer Brown is back. Can you hear us, Officer Brown? But it's camera only. We'll see. All right. Ms. Gore, can you hear me?
Yes.
All right. I can't see you, but I can hear you. And that's fine. That's the important part. Ms. Gore, I find there's a factual basis for your plea. You knew you needed to register. It sounds like with COVID, it got a little confusing for you and your sister. But it was resolvable if I think people had called the right phone numbers. Either way, we're going to move forward with it. I also find that your plea is knowing and voluntary, meaning you've understood what we've talked about, or you asked Ms. Wood questions about it, and that you're entering this plea because you think it's the right way forward for you. No one's forcing you to. I'm going to sentence you pursuant to the Probation Options Management Act, which is code for if you have a small violation of probation, you and probation will sort that out. But if it's a big one and you get arrested again, you and I are going to have to work through that. Ms. Wood, do you waive any issues that might arise from the fact that we are proceeding from a copy of the indictment?
Yes, Judge.
Ms. Gore, I'm going to follow the joint recommendation. I will sentence you to a total of 5 years to serve 6 months with a balance on probation, so 4.5 years on probation. I'm going to waive your probation supervision fee. Does Ms. Gore get SD?
Judge.
Oh, she was working, you said.
She was working, but that is one of the things our social workers are trying to help her sister get her, because I do believe she would qualify for some SSI. So
Yep. So I'm going to waive your probation reporting fees for the first 3 months. If it turns out that you qualify for benefits, we'll continue to waive those supervision fees. But if you are working, then you'll need to pay those supervision fees. And I think that's it. Mr. Whitenauer, did you have anything else? I know you wanted as a special condition that Ms. Gore register, but that would be a special condition of the law already. And if we're back here again anytime soon because Ms. Gore failed to register, that will register with me as a fairly significant violation.
Nothing further, Judge.
Ms. Wood?
no, Judge.
Okay. Ms. Gore, do you have any questions about what we've been talking about?
Well,
Nope. All right. The one thing I can't do right now is get you reporting instructions because Officer Brown has disappeared. Ms. Wood, will you help her with that? You can get the info, you can get it to Ms. Gore. I just don't want Ms. Gore to end up with a warrant 2 weeks in because she didn't report to probation.
just put.
I'm gonna give you this though, so you can.
Great.
Me?
All right. Thank you so much. Mr. Whitenauer, you're free to go.
Thank you, Judge.
So,
What's that?
case is dismissed.
No, so it's over with, so you'll be getting released, but can you read my handwriting?
We can bring Mr.
Yeah,
O'Neill out.
You know
We'll
I
need
know
Mr.
it's
Webb,
fun.
but that'll be quick. I think Mr. Webb is just back there.
Upon release, okay?
Okay.
And I will call your sister.
And then we'll
let
do
her know
Prince
what
Charles,
happened.
and then we only have McKenzie.
And once it gets filed, I'll get the copy to you, okay?
Okay,
Yes.
before we leave?
Yes, so it's
Okay.
not filed yet, but if
We
we
can
can
get
get
rid-
filed before we leave.
Okay.
Okay.
Slide further back behind, slide back in there. I put it in there. We don't need
So
it
put
anymore.
that with your other
Trial.
documents,
We'll
okay?
stay there
Okay,
for
you
now,
got
a
a
memory
card.
of
You
that
got
great
one of your
trial.
cards. Oh, you-
I don't think I have them with me, but take that, don't lose it. You want me to fold it up for you?
Well, I got.
You got
this.
it? Okay, yeah. So call me, right?
And give my sister a copy. of that,
Yes,
too.
I'm gonna call Rodina.
And I
when we
get this. I got a copy of that, right?
Right, I'll get you a copy of all the paperwork after today, okay?
Okay.
All right. Bye, Miss Gore.
So we're gonna have a brief conversation with Mr. O'Neill, and then we'll get Mr. Charles out here, and I think that's it for you.
Perfect. Thank you, Judge.
You bet.
I apologize, Your Honor. I was having some connectivity issues.
Yeah, we noticed. That's okay. I'm glad you sorted it out. So we finished the plea with Ms. Gore. And I don't know what info you need from me. Ms. Wood, her lawyer, gave her some basic reporting instructions because Ms. Gore is going to get out in the next couple days, and then she's going to be on probation for a while.
Okay, I would need her address.
Okay. So,
All right. I'll get Ms. Wood to get that to you.
Okay.
Dennis, here, you can sit here, Mr. Red.
Yeah, that's all.
How are you? Good. I'm Michael Webb. What's your name?
All right. Ms. Rivers, you do not need to take this down. Mr. O'Neill, good afternoon. How you doing?
All right, sir.
Good to see you.
Good to see you too.
We are just trying to figure out what's going to happen in terms of you and having a lawyer. Mr. Gaffney has withdrawn from your case, but that was long enough ago that if you or your family were going to hire someone else, that person should have filed an entry of appearance. There isn't anyone in the docket yet. So I wanted to get an update from you. And if your answer is, I am not going to be able to afford an attorney, then it just so happens, it's not a coincidence, the lawyer who will represent you is actually sitting next to you. That's Mr. Webb from the Conflict Defender's Office. But why don't you tell me the latest from your end?
I was here today to see, can I get a public defender?
Okay, that's what's going to happen. So Mr. Webb doesn't work for the Public Defender's Office. They represented your co-defendant, the Public Defender's Office, so they have a conflict. And we've got a whole separate shop of experienced attorneys called the Conflict Defender. They're just like Public Defender, but they come in when there are two defendants on a case. If one of them has a Public Defender, the other has to have the Conflict Defender so that Mr. Webb can be dedicated to your case and not your co-defendant. So the public defender already knows everything your co-defendant has to say, may have said all sorts of things about you. Mr. Webb doesn't need to be in the middle of that. He needs to be thinking about you and what's best for you. So I'm going to ask Mr. Webb to file an entry of appearance on your behalf. Once he does that, Ms. Hall, and you'll remember her, she's the prosecutor. She will get all the discovery to him. There's a lot of it in this case. Mr. Webb will get familiar with the case, and then he's going to come visit with you and give you his thoughts about what should be happening. We're pretty far along. You've been in jail for a while on this case. So I'm not thinking that Mr. Webb is going to have a real profound insight. He's going to tell you what he sees and what he knows about the case and the statements that were made. And he'll give you his advice of this is one we ought to take to trial, or this is one we need to try to work out. That's a conversation for the two of you. And in the not too distant future, I'm going to want to get you two back in court so that Mr. Webb can share with me what you two have been talking about. Not the specifics, that's confidential, but you know what? My client wants a trial. We'll get you a trial, or my client's going to enter a plea. And Mr. Webb will be working actually with Ms. Charles, not to change up on you, but Ms. Hall's going to go do other things in the DA's office. And ultimately, my guess is it's Ms. Charles who is frantically flipping through a pad right now. She's going to be the prosecutor handling your case, but they're a team and they're going to handle that. All of this takes some time though. Mr. Webb is going to need time to read through your case file, meet with you, and then let me and the prosecution know what the two of you decide ought to happen. Does that make sense?
Yes, sir.
Any questions about that?
No, sir.
Okay. Mr. Webb, I know you've got a lot on your plate right now and you're going to be unavailable for a certain window. And we'll continue to respect that. My guess is that we'll put this on an inquiry-ish calendar after you're back.
Yes, sir.
To see what you and Mr. O'Neill are thinking the right next step is. And if it's trial, we'll get that to happen soon because this case is not getting younger. If it's something that you and Ms. Charles have been able to work out, then we can have Mr. O'Neill come in anytime for the plea. But you need to learn more about the case before you can meaningfully counsel Mr. O'Neill as to the wisdom of a trial or the risks of a trial.
Yes,
okay. Do you have any questions?
How old is the case? Is it?
It's a 2019 case.
Okay, what's the case number again?
It's 19 SC 172-809 is position 6 on our calendar.
Right, I have.
Wasn't listed as your case. It was listed as Mr. Gaffney's, but that's only because there's not a new entry of appearance. He's officially off the case. I've signed the order allowing him to withdraw. And we were just giving Mr. O'Neill some time to see if he and his family were going to line up a replacement to Mr. Gaffney because he was retained. But Mr. O'Neill has told me he's going to rely on public defender-ish lawyers, and that would be you since there's a conflict.
All right, sir, I'll file an immediate entry of appearance.
Great. And then if you can make sure you do connect with Mr. O'Neill before your leave kicks in so that the two of you start to establish a working relationship.
Yes, sir.
Fantastic. Mr. O'Neill, any questions?
No, sir.
All right. You will see Mr. Webb soon. My hope is that he doesn't come see you until he's digested some of the case so you guys can engage on what's out there. All right?
All right.
Thank you.
I'll come see. All right. I'm having surgery at the end of December. That's why he mentioned the leave. So I'll come see you before then. No.
All right. Thank you.
You're welcome.
Next would be Prince Charles. No? Oh.
Did probation want me to give that address right now for Ms. Gore?
This is a perfect time if Officer Brown remains connected with us.
Yes.
Great.
Great. So it's 845 North Central Avenue. So Ms. Gore had told me that's in Hateville, but the report documents from the sheriff's office says that's in Atlanta. Zip code. So yeah, I'm not sure. It's a hotel though.
I believe it is. That's the address that we have on record for her. It did have a room number. So I don't know if you have that information available.
I do not have the room number, but I know that she can return to that location.
Okay.
Thank you.
Thank you.
Is this your government name? Okay. Wasn't sure.
Ready?
Ready, Judge.
Great. We'll turn to position 7, 21 SC 177903, which is State versus Prince Charles. How are you, sir?
I'm blessed. How you doing, sir?
It's good to see you.
Good to see you too, man.
It's been a minute.
Yes, sir, it has.
You've been maintaining?
I've been staying focused. Yes, sir.
Good, good, good. Okay. So I've been told that there's a negotiated plea. Ms. Hall, the prosecutor, is going to take over in just a moment. She's going to be asking you a bunch of questions. You'll be under oath, so make sure you answer truthfully. Do what I know you can do, which is ask questions. If something comes up that either is not what you were expecting or doesn't make sense, and either Ms. Wood or I will answer your question, and we will go from there. Okay?
Yes, sir.
All right, Ms. Hall.
Thank you, Your Honor. Mr. Charles, can you please raise your right hand? Do you swear or affirm the testimony you should give is not currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Prince Charles?
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone to school?
39 years old. I have a high school diploma and associate degrees, and I'm 12 credits from my bachelor's.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Your Honor, for the record, the state will be null pricing counts 1 through 6, which include all of the drug offenses.
Is count 7 a misdemeanor or a felony?
It is it should be a misdemeanor.
Okay, it just says I don't have the indictment in front of me, but it just says obstruction.
It is a misdemeanor.
So Mr. Charles will be pleading to 2 misdemeanors,
Yes, Your Honor.
including operating a vehicle while texting.
That is correct.
All right.
Mr. Charles, do you understand that you've been charged with obstructing of a law enforcement officer and operating a vehicle while texting?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Very much. Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So waived for purposes of this hearing.
And do you waive moving forward on a copy of the indictment?
Yes, that's fine.
Mr. Charles, do you understand that the 2 misdemeanors that you're being charged with, the maximum sentence on both of those will be 12 months to serve?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 290 days to serve, credit for time that you have already served, but the court does not have to accept their recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
You understand if you're placed on probation of any kind? I'm gonna skip past that because you're not going on probation. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to remain? Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, I do.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the, in indictment number 21SC 177903 to obstruction of a law enforcement officer and, operating a vehicle while texting?
All right, so that's 16-13-2 and 16-1024, right?
No. So it's this one right here, 161024A, and then 40-6-241.
Oh, good. All right, guilty for those.
Okay, and is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I do.
Right, thank you, Mr. Prince.
Thank you, ma'am.
You're welcome. Your Honor, had this case proceeded to trial, and I'm gonna, I am aware that the defendant is on first offender probation, but I'm gonna let Ms. Brown give you his history. If this case had proceeded to trial, though, Your Honor, the state would have proven or expected the evidence to show that on September the 15th, 2018, this incident happened on Old National Highway, that is in Fulton County. Officers pulled over a Mercedes-Benz that defendant was operating for operating that vehicle and operating a cell phone device at the same time. When the officer pulled over that vehicle, he did get the driver's license of the defendant. When he went back to his car to run his driver's license, he saw that the passenger of that vehicle was kind of fidgeting, kind of coming out the car, getting back in the car. He got out of his patrol vehicle and told the passenger to remain inside of that vehicle. But that passenger ultimately fled from the vehicle. He pursued that passenger, apprehended that passenger, and when he returned to the incident location, Mr. Prince and the vehicle that he had pulled over was gone. When they took the passenger to the Fulton County Jail for obstruction, he did tell officers that he knew where the defendant lived, and which was a Motel 8. And he gave the room number, Super 8 Hotel, and he gave a room number of 231. When officers went to that hotel, they did seek search warrants for the actual hotel room. When they made it to the hotel, they saw the vehicle that they pulled over parked outside of that room. But the defendant was in the lobby of that hotel. They arrested the defendant, took him to jail. They still searched that hotel room. Inside of the hotel room, inside the toilet was 180 MDMA pills, some marijuana, and a handgun. And that is all as far as the facts of the defendant's arrest. The state, while investigating the investigation of this case, and of course, it was also brought up by defense counsel. I looked further into it, spoke with supervisors about the actual search warrant that was granted for the hotel room. And we feel as though that was an inappropriate search warrant. It was not for the person of Mr. Prince. It was for the hotel room. That stop did not involve any drugs or any suspected drugs. It was not a hot pursuit. So that is why we have decided to no price to drug counts.
And Mr. Charles was in the lobby. So if it was for Mr. Charles, they already had him.
They did.
So it was a lot of drugs and a gun, not good to have, but maybe not lawfully obtained.
Correct.
Okay.
That is all from state. So that's why we're just moving forward on the purpose of the stop. Don't know if he would have received the ticket that day, but now that we're here, the obstruction for leaving the scene and for having his cell phone while driving the vehicle.
So the calendar lists another case, a 19 SC case, just in the notes. Is that something that this was this is a superseding indictment, or is there an open case? I don't want, Mr. Charles has had a lot of moving parts in his life. When he was in drug court, that was clear. And if we're closing things out, I want to close things out and not have him back here because we forgot to check something out.
No, we're actually aware of that case. Defendant wants to move forward on just this particular case.
I think that's a re-indictment. Yeah.
Right.
Yes.
Oh, yeah.
Yeah, it's a re-indictment.
Okay,
Completely different,
so,
I'm referring to, but yes, it was reindicted.
so 19 SC 168974, really, we could null pros, because it is this case. It's the driving while using a cell phone.
I'm sorry.
That's okay.
Removed from drug court, it was reindicted to add the drug cases, the drug charges.
So, Judge, I believe Ms. Collier was the one who initiated the reindictment. And that is what led to the trafficking charge in this one.
Oh, that's what's different, because I say there's all sorts of drug charges in the old one,
Yes,
but not trafficking. So weight is weight, and what was found in the toilet may have led to that. Okay, and then the only other case that looks like it's connected is closed. That's where Mr. Johnson represented Mr. Prince. I met Mr. Johnson. We've gone through a lot of this already. Okay, so 2 cases, effectively same charges, just one charge was upgraded. That's the plea is to the one with the upgraded charge, although that upgraded charge, after all that effort, is being dismissed. And it's a plea to 2 misdemeanors.
That's correct.
I think I got it. Okay. Let's see if Officer Brown is still here. Officer Brown, do you have any open active cases for Mr. Charles?
Yes, he has one out of Fulton County, 18 SC 157453. And that is for possession with intent to distribute. And he has 3 years, 2 months, and 23 days remaining on that case. He also has an open Clayton County case for possession of methamphetamine. And he has 5 years, 11 months, and 25 days remaining on that case.
Got it. Thank you. Ms. Wood, is there a plan to deal with the Fulton case today, the 18 SC case?
Judge, I thought we had already dealt with that one, but I could be wrong. Okay. If we could just confirm.
When we say dealt with, I'm looking at the docket of the case, and there was a order transferring it out of drug court when drug court didn't end well for Mr. Charles. That's all I got.
So do you have?
Yeah, may I speak, Judge McBurney?
You sure can.
In 2018, I had 2 separate cases, but in the same year. One was February of 2018, and the other was September of 2018. The September case was what I got the drug court for. The February case was what I got the first offender probation for. So these are 2 separate cases. It's already been resolved in Judge Millender's court last year, July. But because I asked to transfer out of drug court was when they re-indicted the 18 case of September and upgraded the trafficking. So those cases are already taken care of, the 2018 case.
Well, you say that, but there's nothing in the record. What do you mean taken care of? Like,
meaning when I had my lawyer, what's his name again?
Mr. Johnson.
Mr. Johnson, thank you. I had Mr. Johnson, we took care of both cases in 2018.
When you say took care of, though, tell me what you mean took care of.
Well, in Judge Millender's court for the February case, that they gave me first offender probation for that for 3 years. And the September case, that was also in 2018, this case that was upgraded was when they put me in drug court. So both cases was already resolved, and I got released from here last July and went back to Clayton County. And Clayton County ran everything concurrent as well, what I had here.
Okay.
And was resolved already. Now placed on drug court for the second case. So I shouldn't have any open cases. I should just have probation.
Well, that's okay. We're saying the same. Now we're saying the same thing. You don't have unresolved cases, but the case you're calling the February case, you ended up entering a first offender plea in front of Judge Millender, now Judge Ingram, in July of last year. And you had to stay away from Old National Highway, et cetera, and do drug court. That case has a big piece of probation on it, and that probation is open. That's what I'm asking Ms. Wood about is, this guilty plea you're entering today is a violation of your probation in the Millender case. And so rather than you being surprised 3 months from now when you get arrested on a warrant for probation violation, do we want to try to work through that matter today? I'm fine doing that. And I think it would be real easy to, the sentence I'm going to impose in this case, I would do for the revocation as well. I'll leave that probation open because this case, the 21 SC case, the drugs in the toilet case, it doesn't have a tail, it's done. And so I'll revoke the same amount of time in the 18 SC case and reinstate the balance so that Mr. Charles continues to have probation there and whatever's going on in Clayton. So you two should talk about that. You don't have to go away, just talk about it right there. But that's what I've been getting at is that, Mr. Charles, we can't leave hanging your open probation in Fulton County because probation will just take out a warrant when you enter this plea. And so we ought to, you don't have to, but we ought to resolve the probation piece as well. I'll be quiet for a minute.
Judge, and I think part of the confusion was that the active probation hold is for the Clayton County case.
Mhm.
So he knows that he's got to go down there to deal with that probation matter. So I will speak to him about this other one. Oh, sorry, I was gonna write to you.
So what happens?
So that's the case that you had with the private attorney. So he's telling you that basically he'll do the same thing that you're doing in this case. We're just telling you.
Okay.
You wanna do that?
Yeah.
So then that way you'll have that resolved and then you can just go to Clayton County and
All right.
handle that matter?
All right,
Okay,
that's
cool.
All right.
Judge, we're ready to proceed.
All right, so Ms. Wood, are you waiving any due process notice rights that Mr. Charles would have in connection with a probation revocation hearing in 18 SC 157453?
Yes, Judge.
Okay, great.
So Judge, if you may help us out here, so I think if the court could explain to Mr. Charles that we would be handling that revocation and then it would be reinstated for that probation.
Yep, I'll do all that. I wasn't sure, is there more you want to share about, Ms. Hall finished what she was going to do. I heard from Officer Brown and she's the one who flagged, hey, there's this open probation. So I've tackled that. I'll close the loop on it when it's my turn, but it's your turn now.
Briefly, Judge, we had filed a motion to suppress on this case, and I think this is the appropriate result for this case. He has been in custody. If you tally up the days, it's well over what the state is recommending. He is 39 years old. It's time for him to kind of get on the right track. We've talked about that at length. So Judge, we would ask that you accept the state's recommendation in this case.
What is the right track, Mr. Charles?
Honestly, getting my life back for my family. I lost my way back in 2018, man. Some things happened and I wasn't in the right state of mind, made the wrong friends.
Yeah, you were in it kind of deep. I mean, the stuff in the toilet, that's a lot of stuff.
Trying to help. Really, it was just about being around the wrong people. You know, a lot of these things wasn't mine, specifically mine, but just being in the wrong facility with the wrong individual, the wrong crowd will get you in some stuff. And the last 9 months, man, I've been soaking and learning a lot of stuff of a lot of these podcasts. And I realized if I was out on drug court, I would have never learned what I've accomplished these last 9 months. So I know to get back on track, first thing is to see if I could finish up and get my bachelor's, because I know that means a lot to me. I know I could do a lot more with that. And, you know, just be there for my family, because being locked up here, I can do nothing for my family, man.
You cannot. That's right. You're going to go back to New York or you're going to stay local?
No, I'm going to stay in Georgia. Okay. I have a lot of, believe it or not, I told you my job at Home Depot is still open.
All right. Well, right now, All of us could get jobs. We could walk in right now and get jobs at Home Depot. They are hiring like it's going out of style. So
But I had a good impression on them. That's why 9 months later, my manager still talks to my mother at least twice a week. I mean, twice a month.
okay.
Let her know what's going on.
All right. Well, Mr. Charles, I find there's a factual basis for your plea. You certainly obstructed law enforcement by rolling away, and it sounds like you were using your cell phone while driving. I've never had a case where that was charged, but you did it. So here we are. Obviously, there were more serious charges in the indictment. And that's the stuff that you really need to be reflecting on. You can try to make the big fast buck doing what you were doing back in 2018, but if it catches up with you, you end up spending a year of your life and you don't get that year back. And you're still youngish, but you need to use those years more wisely. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we were talking about. Do you have any questions?
Oh, yeah.
Voluntary means no one's forcing you to enter this plea, but you've decided after consulting with your lawyer that entering a plea is a good idea for you. Is that right?
Yes, sir.
Then I'll accept your plea. I'm going to sentence you, Mr. Charles, to 10 months to serve on count 7 and 10 months to serve on count 8. I'll run those concurrently with each other. That's about 300 days. You got a hold from Clayton anyway, so you're going to finish your sentence, no problem. Here in Fulton, you'll be off to Clayton. That'll close out this case. In light of this conviction, I am going to revoke 10 months of your probation in 18 SC 157453 and reinstate the balance. So there will not be a probation warrant for you from Fulton County. We're handling it right here, right today. Same sentence, credit for time served, all the time you've been in until they do the math and say it's been 10 months. That will take care of your old Fulton case and your new Fulton case. You've got business in Clayton to take care of. They'll do what they see fit. And then, and only then, you will be able to get back on the right track. And I wish you well with that. You have amazing capabilities. And I saw that for a little while in drug court, but you're also kind of headstrong and doing things your own way. Drug court cramped your style. I hope you find something that doesn't cramp your style, but keeps you away from the jokers you were running with when you got caught up with the drugs in the toilet. Okay? Ms. Hall, anything else in Mr. Charles's cases?
Nothing further from the state, Your Honor.
Ms. Wood?
Judge, I just want to make sure, since he's going to Clayton, is there anything reporting instructions that I need to tell him or?
It's a good question. We can ask Officer Brown. He certainly is not doing any reporting on the 21 SC case. You do your 10 months, that case is over. I don't know how it's going to work with Clayton and this. Officer Brown?
Yes, Mr. Charles will have to report to us within 48 to 72 hours of his being released.
From Clayton, correct?
From here. Let's start from here.
Yes.
Okay. You have a hold, so you gotta go to Clayton anyways.
Yeah, Clayton's not a voluntary thing. They have asked to see you in a way that we have to comply with. So you will be shipped off to Clayton, if not this week, first thing next week. And you probably will not come back here because you've done your 10 months. Clayton's going to do whatever they do. They may say time served. When you leave Clayton, you got to make sure you report to probation because there will be a warrant for that. You sure can.
Miss Anita Brown, that's my Clayton County probation officer?
No. Officer Brown works with the Department of Community Supervision. She's based out of Fulton, but she's just helping out today. You may never see her again. I don't know, but she's not the person. You're not going to be looking for Officer Brown. You're going to be going to probation saying, "It is I, Prince Charles," and they will say, "Great," and they will connect you with whoever's going to be supervising. Okay?
Yes, sir. One last question. Will Clayton County know that I didn't catch or charge to violate probation? It was just part of the plea that I didn't finish? Or would it be charging me as it?
Clayton County will have all the paperwork that flows from today.
All right.
So you'll be able to talk with the public defender down there, and that person will be able to articulate exactly what happened here. Okay?
Yes, sir.
All right. Thank you, everyone.
Thank you very much, Judge.
Judge, I believe this concludes my business. May I be excused?
Yes, ma'am. Long day. Thanks for your help. You did great work.
Thank you, Judge. Do you have any questions?
No, do I have a copy of that?
Once everything gets filed, and I'll get you a copy.
Thank
Okay?
you very much.
You're welcome. Good luck to you.
See you later. Hopefully I see you later.
Well, yeah, you can see me just at Home Depot.
Yes, sir, you definitely will.
Excellent. To get a new sink this weekend, but you won't be there.
Ms. Dawson, there's my plea forms. Are you gonna see this for next? I am. Do you want me to take some material? I do. Yeah, Mr. Abadi also is sending stuff.
So we're gonna take a 5-minute break, and I think all we've got left is McKenzie. Is that right? All right, so I'll come back out. We'll do McKenzie. Have you been talking with him? You have a sense of where we are?
I
You want to talk to him while we take this 5-minute break?
Sure. I have a better offer from the state, so I guess.
Should we wait 10 minutes? You'll get an even better offer?
No.
No, this isn't your supervisor swooping in. It's like, what are you doing? Okay.
I don't want too much time.
No, it's 5 minutes.
Okay.
I have
I'm
to
gonna run
have
to
some
the
water.
Yeah, I don't want him to think too much. This next one is gonna be another marathon. I have to go to the restroom first.
I got it. Thank you so much. See y'all on Friday.
You be here Friday? You have anything on Friday?
I have a lot on Friday.
Friday, great. We'll see you Friday. Have you met Miss Charles? Meet your future opponent.
Okay, I was gonna say, I wondered if you were, Okay. Nice to meet you.
All right.
Where are you? This house.
Yes, ma'am.
Okay. Welcome aboard. What's your first, is this your first day or? Like with her first she like transitions out?
I don't know when she's leaving. My first is technically.
Okay.
Doesn't go to December. So we're gonna be chilling for a month.
Oh, cool.
And
Okay.
then, so I guess we'll be officially spoken of.
Okay.
Next year, and then years.
Okay.
She sent to me for the next month, so it's pretty much.
Okay.
It's done. It's all over.
Well, she can tell you all about.
Yes.
Prince?
Yeah.
Okay. She can tell you, I just got moved in this courtroom in July, so I inherited like all the cases that were like, different expectations. So I'm sure she'll tell you, I think today we wrapped up for like, there's another that I've just spoken to her about, so she'll give you the phone number. Yeah, we're like trying, there's a lot of people. Yeah, I give it to all.
You do some lunches. Because that's a festival. Oh, so, what are you gonna see?
I did.
Oh, you did?
Well, see, that was not my fault.
I need that to be sent to somebody else. I don't even know why, Ms. Nelson, I don't even know why you did that.
Well, they didn't send me their notice, only one I had is Lacey Wood.
So she's not talking about it.
Yeah, that's the only one though. So if.
You can just.
Sister want me to come back there? Thank you. I appreciate you. I owe you.
She couldn't wait. She couldn't wait to add nothing for you. She was itching. I'm talking about Ms. Nelson.
No, what I did, what I said is, she ain't here now.
I know.
I know what you did.
I needed some dates.
Wait, so did it come out today? Is that why I haven't seen it?
No, wait a minute.
Oh, I was about to say.
Cassie,
I know you're gone,
I was gonna say, yeah.
but I hadn't heard about anyone else being gone.
Oh my God.
But you guys are getting stuff done.
Yes, we are. You just wait till Friday. More coming your way. Well, it's so nice to meet you.
And you know, we took a whole lot.
Yes,
more.
absolutely. Bye, Miss Nelson.
All right, I'll see you on Friday.
Yes, ma'am. I hope not as long. I'm just trying to resolve some stuff again. Will you be home by then? Okay, cool. Awesome. Yeah. You too.
Yes. I'm sorry. I'm at the end of it. I'm sorry. You know, once you get the notice, just email it to me. No, I just emailed it to me. They fancy, they follow. Oh. I just emailed it to me. No, she really don't have to be to know. Do the whole world, you know, when you on vacation. But you know, that's public. Oh, I can see it. They like, all right, y'all, last one.
This isn't the last one. Is
Yes, it is.
Like the last one, not for today, for not ever.
Oh, no. Miss Nelson, calm down.
Like, hey,
The last one for today. I'm tired.
like, really?
One thing I don't have to worry about.
Try it.
Trial. I thought it was gonna be a trial. Oh, let's see. Oh, I'm sorry, Miss Karen. Miss Karen reminds us that we on live. I'm gonna talk about nothing.
Is this person gonna take a plea?
I have no idea. If he doesn't, I have another case meeting on Friday. Bye, Mr. Harris.
We're gonna fly, we're ready to go.
Okay.
That's the chair.
No. Not happening.
Fine. I'm gonna ask.
Oh, you go, oh.
Until. Oh, well, I see what you're saying. You got it, you got 14.
I was like, wait, you asked me what?
Let me, I'm so tired here.
You're tired here. It's, Nelson, I have a new plea litany over there. Not because I'm talking fast, it's because it's different.
Oh, wow.
It's because of my clients.
I've been stumbling over that plea litany because it's new, I'm not used to whatever that is.
Well, I was kind of glad you were going a little slower.
What would you need
Oh,
to
you
do?
know, I'm going slower?
Just a
I'm
time.
probably a little slower when I'm looking at them. Because I look at that.
You need to reload it to not ask, are you satisfied with the services of the training?
Because they gonna say no. They need to be satisfied though.
Yeah. Well, I mean, that's such a subjective thing. I wonder why they came up with that in the first place. Are you satisfied with the services of your attorney? Because I mean, even if they say they're satisfied, they're still gonna file a habeas petition.
Yeah.
So seems like it ought to be reworded, but who am I to suggest anything that makes sense? To the powers that be, that is.
Actually, do you anything honestly with my computer guys? Yeah, I mean, this number. Can you give me all of that? 18 and 19 on McKenzie? The revocation one. Oh. In case we do it. You got it.
Got 18 and 161.
So, Ms. Charles, the plea with Prince Charles was much more typical of how quickly, so there was that little railroad juncture with probation. They usually go like that. You are seeing today that plea with Mr. Brown was one of the longer pleas. And Mr. Webb, thank you for sticking with it. But
Got that, Your Honor?
it's not you, clients have indecision, they're facing big terms, but most cases it's 5 to do 1 and it's a 10-minute affair.
Yeah, well, he threw me for a curve on a couple of those things.
Well, and this next one, I don't think is gonna be a lot simpler, so. If you are. I have to, you guys are gonna love this. I have to get on a Zoom call at 3. So we're gonna do a half hour with Mr. McKenzie, then we have to pause. And then I have to go talk with Daisha Young about pre-indictment matters for about 15 minutes. And then
Okay.
I'll be back here, so.
Well, hopefully we can finish.
Come move a little faster.
We'll see. Yeah, as long as Ms. Rivers can follow along.
Oh, yeah.
The deal is,
Forgetting about the
we have to, it's a negotiated plea, so we have to agree.
She's here,
to
she can look at me.
Who forgot about me, Ms. Hall?
Yeah, Ms. Hall, short timerism.
You understand?
How quickly we change.
That's all right.
I
We'll
know
get
you
started.
Definitely slow me down if I'm talking too fast.
All right, let's get on the record in positions 8, 9, and 10 on our calendar, all of which belong to Mr. McKenzie, who is in court today with Mr. Webb. Hello, Mr. McKenzie.
What's up?
How are you?
Good.
Mr. McKenzie, my understanding is that we are going to attempt pleas in your 3 cases. Is that your intention?
Yes.
Okay. Ms. Hall, the prosecutor, is going to put you under oath in just a moment. Once you're under oath, it's important you answer all of her questions and mine truthfully and completely. It is just as important that if you have any questions, you let Mr. Webb or me know so that we can answer those questions. Will you do that?
Yes.
Okay. We're going to get as far as we can until 3. I have to take a phone call at 3 o'clock and we'll get you back out here if we haven't finished to do the rest of what we need to do. All right. And when you are answering your questions, make sure you answer out loud because the court reporter can't take down a nod or a shaking of your head. So yes, no, maybe, whatever your answer is, make sure you belt it out into that microphone. Okay.
Yeah.
Great. Ms. Hall, when you are ready.
Thank you. Mr. McKenzie, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yeah, ma'am.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Quentin McKenzie.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone to school?
21.
And how far have you gone to school?
10.
10th grade?
Yeah.
Okay. And are you able to read, write, and understand the English language?
Yes.
And indictment number 19 is C-171-153. Do you understand that you've been charged with criminal attempt to commit murder, aggravated assault with a deadly weapon, criminal attempt to commit robbery, and possession of a firearm during the commission of a felony.
Yes.
In indictment number 19SC 167443, do you understand that you've been charged with robbery by sudden snatching?
Yes.
In indictment number 21SC 178578, do you understand? One moment, Mr. McKenzie. Your Honor, for the record, the state, for the purposes of this plea, will be no price in count 1 for this defendant only, possession of a firearm during the commission of a felony, and just proceeding with count 2, which is possession of a firearm by a first offender probation.
So Tony Cody got some different counts. Mr. McKenzie has counts 1 and 2, and you're dismissing count 1 and only going forward with possession of firearm by first offender.
Yes.
Got it.
That's in case 21 SC.
Yes.
78578, right?
That's correct.
Okay.
Mr. McKenzie, do you understand in that case that the 21 SC 178578, you're charged with possession of a firearm by a first offender probation?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to the charges in all 3 of these indictments? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of in all 3 indictments?
We do.
Okay. And do you waive any and all defects in these indictments, including with respect to the defendant's name?
We do.
And do you waive moving forward on copy of each of these indictments?
We do.
Mr. McKenzie, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes.
I will go over them with you again. The minimum maximum sentence for criminal attempt to commit murder, because that is a attempt, usually you will be facing life for that charge. However, it'll be half of that. So you're facing 15 years to serve on that count. On aggravated assault with a deadly weapon, the minimum maximum is 1 to 20 years to serve. For a criminal attempt to commit robbery, again, that is an attempt. So you would be facing half of what that charge would normally be sentenced under. So you'll be facing 10 years to serve on that charge. And for possession of firearm during the commission of a felony, you'll be facing 5 years to serve. That count will be ran consecutive to any other count in the indictment. For robbery by sudden snatching, the minimum maximum. You was gonna say that?
Pardon me, Ms. Hall. My reading of the statute on criminal attempt to commit murder, I advised my client that the maximum was 30 years. I thought it was 1 to 30 because of the nature of the felony. I mean, I'm happy if it's only 15, but I didn't want to give him misinformation.
I'm looking it up because we want to get it right. I don't, this has come up before. It came up because of the co-defendant. So we'll get it right. Let's press on and I'll circle back to the ranges for counts 1 and 3.
Yes, sir. I didn't mean to slow things down.
You're not slowing things down. I had the same question, so.
Thank you.
Sure. For the robbery by sudden snatching, the minimum maximum is 1 to 20 years to serve. And for your last case, the possession of a firearm by a first offender probationer will be 1 to 10 years to serve. You understand?
Amen.
So according to 1646, OCGA 1646, the range for attempted murder is 1 to 30. And 1646, penalties for criminal attempt. A person convicted of the offense of criminal attempt to commit a crime punishable by death or life imprisonment shall be punished by imprisonment for not less than 1 year nor more than 30. So it's a range of 1 to 30, probated, suspended, whatever it might be. So the range is 1 to 30 for count 1, and it's 1 to 10, which is mostly what Ms. Hall said for count 3.
So I gave my client the correct advice.
You did. Good work.
Thank you.
And again, these are all ranges. This is not what the state's recommended. This is not what your lawyer's recommending. You just need to know the universe.
And I asked Your Honor, because I just wanted to make sure, because we charged under 1641.
That's the way you charge it, which criminal attempt, but sort of like the theft charges, the offense is here, the penalty is in a different statute. It was correctly charged.
Mr. McKenzie, do you understand this is the so I'm gonna break the indictments up so that we're clear. For indictment 19 SC 171153, do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of for criminal attempt to commit murder, 14 years to 20 years to serve 14 years, balance on probation. For aggravated assault with a deadly weapon, 14 years to serve. For criminal attempt to commit robbery, 10 years to serve. And for possession of a firearm during the commission of a felony, 5 years suspended, which will run consecutive to count 1. For indictment 19 SC 167443, robbery by sudden snatching. Do you understand this is also a negotiated plea of guilty, which means the state will recommend to the court a sentence of 10 years to serve, a sentence of 10 years to serve. And for your last case, 21 SC 178578, for possession of firearm by a first offender probationer, the state's recommendation for that charge is 10 years to serve. Do you understand that these
And these would all run concurrently with each other? So overall, it's the 14 years. Okay.
You understand that the court can sentence you to, the court does not have to accept that recommendation from the state. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another.
Yeah, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yeah.
Do you understand if you're not a, do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would. And this is true regardless of any advice by your attorney or anyone else.
Yeah.
If you don't understand the question, just let her know, okay?
I know what she's saying. I'm legal immigrant.
Say that again?
Yes, yeah, I know what she's saying.
Okay.
Do you understand about pleading guilty
Yes.
to a felony? Do you understand by pleading guilty to a felony if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yeah.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 19 SC 167443. Oh, sorry. How do you plead to the charge of robbery by sudden snatching?
Yes.
Indictment number, and is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have 30 days to appeal this guilty plea conviction?
Yes.
In indictment number 19 SC 171153, How do you plead to the charges of criminal attempt to commit murder, aggravated assault with a deadly weapon, criminal attempt to commit robbery, and possession of a firearm during the commission of a felony?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And finally, in indictment 2-1 SC 178578, how do you plead to the charge of possession of a firearm by first offender probation?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have 30 days from today to appeal your guilty plea conviction?
Yeah.
Do you understand on any felony charges, you have 4 years from today and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of the guilty plea?
Yes.
Thank you. Your Honor, the state is aware that the defendant is currently on probation for 2 different cases.
14. So I gotta do
He
the
does
whole
not have any
14.
felony convictions at this moment though, but those 2 probation cases are 18 SC 161596 and 19 SC 171. I have to scratch that.
Yeah, I've got a different, no, I've got 18 SC 159634.
That is correct.
That's one of them.
That's one.
Okay,
I wrote what was on the calendar. I don't have the other one.
okay. But we'll get that through probation because I think if Mr. McKenzie doesn't sort stuff out today, he's supposed to be back on Friday for some revocation issues, but we can wrap them all up today.
Yes.
Okay, we'll get that information from Officer Brown.
The other case is a 17.
Yes, it is.
Okay,
It is. So I'll tell you the facts, Your Honor, but he doesn't have any felony convictions as of today.
does not.
Does not.
Okay, which is why it's first offender probation or, got it.
Yes.
Okay,
So Your Honor, starting with the first case, which is the criminal attempt to commit murder case, 19 SC 171153.
Mhm.
If that case had proceeded to trial, the state would expect evidence to show that on August the 14th, 2008, officers responded to a person shot at that.
just so I'm clear, 2008?
18.
18, okay. That's all right. You may have said 18. I heard 8, like, gosh, that's a big delay. Okay.
Statute of limitations.
Yeah, Mr. Webb was starting to stand up.
2018.
Yeah.
And that happened, so there are 2 incident locations. It started at 50 Alabama Street, which is the 5 Points train station
Mhm.
area, and it came down Peachtree Road, East Peachtree, West on Peachtree, where the victim was shot, but officers responded to that location in reference to a person shot. When they arrived, they saw the victim, Mr. Daquan Harris, who is appearing by Zoom today. He was on the ground shot. There was also an off-duty officer that was in the area that day who heard the gunshots that reported also to this area. They were not able to speak with Mr. Harris due to him having surgery. He was shot in the chest and twice in the leg. But during investigation, it revealed that Mr. Daquan and his friend were here from North Carolina. They were at the 5 Points train station. They were approached by the defendant, his co-defendant, who we've already closed out his case, Mr. Bush, and 3 other gentlemen. They asked Mr. Harris and his friend if they wanted to buy any drugs. When Mr. Austin, which is the other victim in this case, he went into his pocket, and when he went into his pocket, Mr. McKenzie grabbed him to try to take whatever money he was pulling out of his pocket, at which point Mr. Harris and Mr. Austin ran from the group of guys. They ran west on from 5 Points coming, I'll say, towards the courthouse. The defendant and the other 4 people that were with the defendant, 3 of them were on scooters, 1 was on a bike, and 1 was walking. 3 of them were armed with guns, including Mr. McKenzie. They kind of intersected the victims when they were running, and when they were able to see them again, they just started shooting at the victims. Mr. Austin was not hit, and he was not injured at all. But Mr. Harris was hit 3 times, and he did He did survive his injuries. However, he's still having to this day complications breathing and walking from being shot 3 times. In the investigation, there was surveillance video that we have where it shows Mr. McKenzie and his other co-defendants come up by the restaurant called Yums at the corner of Peachtree and Martin Luther King. You can see them shoot. You can see them shoot. You cannot see the victims in the surveillance video, but you can see them shoot. We were only able to apprehend one other person from the incident, and that was because Mr. McKenzie was the one who gave us the co-defendant's information, Mr. Ja'Cory Bush. When officers pulled that surveillance video, they were able to get, Mr. McKenzie is familiar in this area. So one of the officers was familiar with Mr. McKenzie. They provided a lineup. Mr. Harris was able to pick Mr. McKenzie out of a lineup. I'm trying to think of those. Once he went to the interviews with officers, that's when he gave more information as far as Mr. Bush being involved in this incident as well. This has been a case that I've had for a while. Try to work it out with Miss Snyder. My person that I took over the case for, they were also trying to work the case out because Mr. McKenzie gave that information as to at least another person that was involved. I think that there was some type of conversations that were had about possibly cleaning out this case. And that is why I have kind of stuck to that and have not asked for anything higher on this particular case. I have spoken with the victim several times in this case. Mr. Harris, Mr. Austin does not want to be involved in the case. Again, he wasn't injured. He just was shot at, and he after his friend fell, he kept going to get away to get help. Mr. Harris does want to see Mr. McKenzie pay for what he did. He does not want to speak today. He just wants to hear and see what's going to happen. But if there is a trial, he is willing to come up from North Carolina and testify, or even Friday, come up for the revocation hearing, because this is the case I plan to put up at the revocation hearing. That is all for that case.
All right, before you go on to the next one, Mr. Harris, this is Judge McBurney. I just want to thank you for being on the Zoom session. You don't need to say anything. Your presence here speaks enough. I hope you continue to heal from your injuries, and I'm real sorry for what you went through, and frankly, that it's taken this long. It's a case from 3 years ago for us to get around to working through it. But I hope you are doing okay in North Carolina. Thank you for being here. Back to you.
Thank you, Your Honor. Now that was the first indictment, the second one being 19 SC 167443. This incident, it proceeded to trial. The state expects the evidence to show that on April the 4th, 2019, officers received a call at the same area, 5 Points train station, so 50 Alabama Street, Fulton County. Officers received actually didn't receive a call. The victim flagged down an officer that she saw, and she let the officer know that someone had just snatched her pills from her. They immediately started an investigation. They went into that store. She was inside of the pharmacy store that's located directly across the street from 5 Point Station. It's all connected. It's just across the street. She said that she noticed the guy in line. She thought that person was getting prescription pills like she was, but she didn't think anything of it until she walked out of the store. The defendant snatched her bag of pills and took off running. She did give chase. She was not able to catch Mr. McKenzie. She did pick out someone that she thought was Mr. McKenzie at some point when they were investigating this, but she did let the officer know once she got closer to that individual that was not the person who snatched her pills. Officers were able to pull the surveillance video from inside of that store. When they pulled that surveillance, again, officers are familiar with Mr. McKenzie. They were able to pull up a photo of him, put him in a lineup. They met with Miss Smith. Miss Charlotte Smith is the victim in that case. Or Charlotte Smith. She was able to positively identify the defendant as the person who snatched her pills in this particular case. And she did not want to give a statement, but she did want you to know that her pills were about $200. And she had to go through a lot to get her prescriptions reissued and stuff from her doctor. Officers were able to put out a warrant, and they did eventually apprehend Mr. McKenzie at his favorite spot in 5 Points a couple days after the warrant was issued. And then the final case, which is 21 SC 178578. Officers responded to, again, 5 Point Station in reference to a person shot. The person shot, though, was Mr. McKenzie. And once they reviewed, Miss Rivers, the address is also 50 Alabama Street, Atlanta, Georgia, Fulton County. That's the 5 Points train station. Officers reviewed that surveillance, and they saw that Mr. McKenzie and his co-defendant walked up to a guy that was on a scooter. It looked from the video that they were trying to rob him. The person that was with Mr. McKenzie started to go into the pockets of that victim, and he did have a gun. The co-defendant had a gun. Mr. McKenzie also had a gun, but at that point of the armed robbery, he wasn't pointing or anything. Once the co-defendant was able to get whatever he took out of the victim's pockets, the victim started to walk away, but turned around and opened fired on Mr. McKenzie and the co-defendant. Co-defendant was not struck. Mr. McKenzie was struck, I believe 2 to 3 times. So you can see him falling with his gun in his hand on surveillance. And that is why he wasn't charged with armed robbery, but he was charged with the possession during the commission and with the possession by first offender probationer. That is all. Mr. McKenzie was taken to Grady, and he has since recovered from, or as far as I know, recovered from his injuries.
Got it. All right. We're gonna pause right there. When I get back from this short call, I have to go get on. Officer Brown, I'd like to hear a little bit about Mr. McKenzie's. Sounds like he's got 2 first offender cases. And then Mr. Webb, I will hear from you about Mr. McKenzie. And then if Mr. McKenzie, you want to say anything, I'll certainly hear from you. You don't have to say anything at all, but you get that chance. And we'll see if this is a case that we can, these are cases, really 5 with the 2 probated cases that we can bring to some closure. I'll try to keep this call as short as I can. You all should take Mr. McKenzie back to lockup because it's going to be 5 minutes at least. So he shouldn't stay out here. When I get back, we'll finish things up. Sorry about the conflict. I thought we'd be done by 3. Do you need anything? You just spectating?
Yes, sir. I was looking at Judge Adams.
I'll find out.
Where would Judge Adams be since she's the presiding judge?
Was it lunch, but also not in the building?
No, she's not in the building. Yeah, if you you need to wait a little bit. Where is it? Okay, if you give it to me, I'll at least hold on to it. How are we doing so far, Mr. Webb? Does it seem like it's going okay? This,
Yes, sir, very good.
okay.
I think there was one thing I need to ask was.
You can do that in a second. Yes? Great, thank you.
That's mine.
Oh, okay. I didn't know.
Yeah, tricky?
No.
Usually, right?
Yeah.
I just had a quick.
That's okay, I know.
I just had a quick question about 1611, 131B. I was looking at the statute. I was keep recommending in this possession of the person offender probation. It's 110 is the sentence, right?
Only because she's, I don't have to. Yeah, he doesn't work. You know what I'm saying?
Yeah,
So it don't
okay.
matter.
Yeah, it doesn't matter. I just wanted to make sure.
You
Right,
you
it was Friday. And it's 5 to 10, it's a subsequent.
Yeah.
Yeah, but he probably, Deidre,
I mean, no.
what's up, Deidre?
Ask Gordon what's that.
Who?
Ask Gordon what's that.
What do you mean?
That's what y'all be having.
You getting some brownies?
That's what y'all be having. Huh? That's what y'all be having in here.
What? Go ahead. And where's Gordon?
Yeah.
No, Gordon good. It's the other one. It's the other one.
Okay.
Whoa. Problem child. Yeah. Problem child. Yeah. Yeah.
I bet you know.
What you doing,
Shoot, that's a understatement.
What's that, Ms. Nelson? Stop slamming the door.
My son. So my son, hey, Dad. Look. My son said, Dad, you do the job. Tell my boss.
You know, almost like five.
Yeah.
We just opened up, what's the name? Birthday.
Oh.
Yeah, that's it. I was like, oh, I made it. And I was all, I thought everything. Yeah, I don't have it. Oh, Lord, it's me. Oh, I thought you said
You know what I mean. He stayed out. So you can't go to yeah, I call it. They are walking. You know, that's when you start doing it. You start doing jurors on one side. You know, Hall again, big team. And I was also, I'll wait a few minutes. I hope I can stop a little. Yeah, I'm gonna take right now.
oh, I hope you see. I'll read that. Yeah, but not there. I come to her classes and they will bother. You want me to find yeah. See, I must be see you on that. Aren't you baby? Oh. Right, she gonna be like, well, they're not there. Oh, yeah, Brian is, was a, yeah, start with 19. Say what? Cause you like it. Girl, I'm addicted to it. I
Cassie,
Yes.
he wanted to know what his co-defendants get on one of those cases. Is he pled or?
I don't know, because it's not, no, he hasn't, and he was tapping with evidence and stuff, so it may.
Okay, I'm just gonna tell him, you don't know yet.
Yeah.
I don't know why he was so preoccupied with that. Misery loves company, I guess.
Oh, Mr. Bush, oh, he was chasing life.
Really?
But see, he actually has convictions.
He did.
Your guy doesn't.
Well, the victim almost didn't make it from what I could tell from the. Make a payment.
Well, I will be here. I'll miss. Oh, that's great. You're trying to believe me. I'm gonna be here. I mean, you can still send me the camera. Trying to get rid of it. I'm just thinking. No, I didn't make this. I did. Oh, I was. Just in case, yeah, change my mind.
Yes, Alicia. Huh?
I'm afraid.
Yeah, or leave me at 4:00. No, I have car.
So they're still going on, who's on service, that's not smart. That's okay.
Yes, your number one is 8 o'clock. I know. I can't even go to today. On his Snapchat. He posted a video on himself. Oh, I love it. And it's, like a parent. I love it. Oh, no. Tell my moves, I love it. Okay. He said you got your heart and what will to share.
So it's the wrong room. It's wrong. No, 770-545-93.
That's not hard.
What's up?
They said the fire on child.
Don't tell me.
But the number is in the program.
Don't tell me.
No. No, we was sending out a group message. She needed. That's crazy. She needs to send it. Because you can't leave them.
So listen, so if I get my first, I get. Both my gifts. I'm about supporting gifts for me and my spending. You're not under my, so I'll be there when you're not under the way only to give. This is right. You ain't black, you haven't worked the elements the whole time. You can clap like this. Okay, Judge ready?
I'm Oh, I am ready. Give me 1 second. I left one thing there, but yes, you can bring them out. Get everyone ready.
I'm done with my part. Cancel. No. Oh, I know.
I'm gonna be brief, as briefer than I ever been. I have to be.
They be thinking we work from 9 to 5, no, our schedule is 8. Oh, I did not know that. Really, you know, a lot of them think we work from 9 to 5. Why would they need to put you on our schedule? I'm here, 8 o'clock in the morning. I hear it about 6. I don't even know. Oh.
Hey, Quentin. I don't know about your code.
You're present, Your Honor.
Yeah, he's not.
Great.
Yes,
Thank you, Sergeant.
So I don't know what he's gonna get.
All right, Officer Brown, you've been hanging with us for a long time today. I appreciate it. You're never gonna want to come back to this division again. You still with us?
Yes.
Excellent. Where we left off was needing to get an update as to Mr. McKenzie's I think he's got 2 open probated cases. Is that correct, or just 1?
He has 2.
Okay. I trust you're not driving on the perimeter as you look at those papers.
No.
Okay, it's probably just
but
the background that's moving by.
It is, but he has 17 SC 156 376, and he has 29 days remaining. He has 18 SC 159 634, and he has 24 days remaining.
Wow, it's a lot of time left. All right. That would have been an interesting revocation day after tomorrow. Oh, but they're first offender. That's right. That's what you had talked about, is that you wanted to revocate. Okay, understood. Thank you so much. Mr. Webb,
Yes, Your Honor.
your turn.
We would ask the court to accept the plea, the negotiated plea. I'm sticking to the plea agreement. I think my client may have some additional requests he wants to make. And then we can, I guess, depending on how the court sentences, that would take care of the probation revocations. I have some ideas about that, but I'm sure Your Honor is light years ahead of me and you're thinking.
No, I mean, one approach is to leave them as first offenders and revoke the balance, and that takes care of it. There's less than a month on each. I'm going to ask Ms. Hall in a minute if she thinks that instead the first offender should be revoked and Mr. McKenzie should be resentenced. I'll hear that argument. If she's got it, I'll just note for the record, he's going to be sentenced for 3 different felonies today. So I don't know that it changes a whole lot, but I am open to hearing all those things. But your recommendation, Mr. Webb, is that I follow the negotiated 20 to serve 14 across all those cases and do not revoke Mr. McKenzie's first offender status, just simply revoke the balance and close those 2 cases
That's
out.
what I was thinking, Your Honor.
Okay.
And I guess I should mention one other thing on behalf of my client. On the robbery by sudden snatching, and we're not disputing the elements are there for the offense, but it was a little bit of an odd situation. The victim obtained prescriptions for Klonopin, Xanax, Percocet, Zoloft, and I don't know what else. She said she had a pain medication. And I'm just wondering, that's all.
Okay. Well, she could have had Chia Pet inside the bag. If it was suddenly snatched by your client, that's robbery by sudden snatching.
Of course, Your Honor.
Just happened to have been a high value cocktail of prescription pharmaceuticals.
Definitely.
Okay. Mr. McKenzie, is there anything you want to share? You are welcome to say nothing at all. You're welcome to tell me what you want to tell me about you, your cases, whatever's going on.
I'm good, Your Honor.
You're good.
Yeah.
All right. How long you been in?
Like 13, 14 months.
Okay. All right. And are you an Atlanta native? Did you grow up in Atlanta?
Yes,
Where did you go through 10th grade?
Grady High School.
Grady High School? All right. Well, Mr. McKenzie, if you're good, then I'm good to move forward. You are entering pleas to 3 cases today. I find there is a factual basis for each of the 3. I also find that your pleas are knowing and voluntary. A voluntary plea means that you're moving forward today because you've decided, after talking with your lawyer and thinking hard about it, that it's in your best interest to go forward with the plea. In other words, no one's forcing you to do this, but you've decided, you know what, this is a better situation than going to trial. Is that a fair statement?
Yes, Your Honor.
Okay. And a knowing plea just means you've understood all the things that Ms. Hall talked about, Mr. Webb talked about. Do you have any questions about anything so far?
No.
Okay. Then I'll accept your pleas. I'm going to sentence you pursuant to the Probation Options Management Act. And all that means is that when you're on probation, you've been on it before. If you have a technical violation, maybe you miss an appointment with a probation officer, something like that, you and probation will figure that out. I don't have to get dragged into that. But if you catch new charges, you get arrested for something, that comes back to me and we'll work through what should happen with your probation because of the new allegations. Mr. McKenzie, as part of entering your guilty plea, you would normally be signing each of the 3 indictments where it checks off that you're pleading guilty, but we're trying to keep everything electronic during the pandemic. Do you authorize me, Mr. McKenzie, to sign your name on each of the 3 indictments?
Yes.
Mr. Webb, can I sign for you?
You may, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Okay. Well, I don't see any reason not to follow the recommendation from the 2 sides. It's a lot of time, but it's a lot of cases, and it sounds like this was real serious for Mr. Harris. You may not be feeling real fortunate right now because you're getting sentenced to a fair amount of time in prison, Mr. McKenzie, but if Mr. Harris had expired, died from the gunshots, then you and Mr. Bush and others would be looking at a real different vista than sometime. It would be all your time that we'd be talking about, life sentences. But that's not where we are. I hope that Mr. Harris continues to improve and is able to move on with his life. In case 19 SC 171153, I'm going to sentence you to 14 years to serve on counts 1 and 2. Those will run concurrently with each other. 10 years to serve on count 3. That'll run concurrently. So a total of 14 years to serve. Count 4 has to be 5 years. It has to be consecutive. I'm going to probate that. So your overall sentence is actually going to be 19 to serve 14 rather than 20 to serve 14. And my thinking is this: you're going to be in prison for a long time. When you get out, you're either going to do well on probation or you're not. And we don't need 6 years to figure that out. If after 1 year, you're getting arrested again because you're grabbing some lady's pills or you're on a scooter and you're shooting at someone, I'll know what to do with the rest of your probation. But if you're doing fine because you've decided when you get out, I'm done with the whole jail thing, then we don't need 100 years of probation. You'll be doing okay. We'll see what that is. In 19 SC 167443, the pill snatching case, I will sentence you to 10 years to serve. That will run concurrently with your sentence in 153. And finally, in 21 SC 178578, case where you got shot, where'd you get shot?
In your body.
Where in your body did you get shot?
My neck and my stomach.
And how are you doing physically?
I'm good.
You're good. You can eat and drink and everything comes out where it's supposed to and not out through your stomach or anything?
Yeah, I'm good.
You're good. You're always good. All right. Do good also. That would help. So 21 SC 178578, your sentence is 10 years to serve to count 2. Count 1 has been dismissed. We'll run that concurrently with the other 2 cases. And in your 2 open probation cases, 18 SC 159634 and 17 SC 156376. I'm simply going to revoke the balance and close those cases out. So those will be done in a month. And I think we've covered everything. I'm going to add as a special condition to your probation in the case ending in 153 that you get your GED if you haven't done that while you're with the Department of Corrections. But hopefully you'll do that while you're with the Department of Corrections. Ms. Hall, anything else in connection with Mr. McKenzie's 5 cases?
Yes, Your Honor. I forgot to add to my recommendation for him to stay away from the 5 Point train station. Even though he'll be gone for a while, when he gets out, we want him to stay away from there.
Yeah, so where's home for you? If you got out today, where would home be?
On Northside Drive,
Northside Drive, and what's there? Is that a mom, an uncle, a girlfriend?
my brother,
Your brother? Okay. Is that an apartment or a house?
apartment.
Okay. All right. I will add as a special condition of probation in the case ending in 153 that you stay away from the outside of the 5 Point station. So you can still take MARTA and all trains go through 5 Points. You cannot get off at 5 Points because you can't be in that esplanade area outside. That is where almost all this stuff happened. That is where Mr. Bush had issues. That is where you had issues. And so you'll need to find a different place to be hanging out if you're hanging out. I hope instead you'll be working or going to school or who knows what, but you'll decide that. Anything else, Ms. Hall?
Nothing further from the state.
Mr. Webb, anything else on behalf of Mr. McKenzie?
No, Your Honor.
I forgot to say one thing. You'll get credit for all the time you served. That's automatic, but I'm going to say it anyway, so it's on the record. So as long as you've been in on these charges, that time will be credited towards the time you're serving.
I believe it's about 13 months, Your Honor.
That's what he told me. So I think that's it, unless you have any questions, Mr. McKenzie. You're good?
Yes.
He's good?
Oh, yeah,
He's
be
good.
eligible for parole and
Pardon?
be eligible for parole.
Yes, yes. He was asking if he'd be eligible for parole.
He is. All right. Thank you, everyone.
Thank you, Your Honor. May I have it?
I'm not sure. Let me look at the calendar. Whoa, just in case. Yes, you may, Mr. Webb. Good work today. Thank you.
Very much.
Ms. Hall, good work. Ms. Charles, I'm going to repeat it. Not all pleas are like this. This one went pretty smoothly. But you got to see, I think, the full spectrum. You won't have many Antonio Brown style pleas, which is a good thing. All right. I will see some of you on Friday. You're going to give Ms. Charles anything to do on Friday? Contemplating. All right.
We have a couple, please. We'll see.
Good.
You won't see me on Friday, Your Honor. I'll be in Judge Dunaway's court. I don't think I have anything here Friday. Do I?
We've got a calendar. I have no idea.
10 o'clock in the morning. And Your Honor, we're
I
gonna
do.
be via Zoom. Yes, you have a possession of a cocaine case with someone, 10 o'clock. It's on the one page.
Is that the one where she was supposed to give proof of her anger
No,
management?
that's on the later calendar.
So don't be a stranger on Friday. If you need to, you have the calendars, because I know they were sent to you. Please check them. And if you're here on Zoom, that's fine. But if we need to work with Judge Dunaway's people to get you freed up, that's fine. But
Sure, Your Honor.
I'll need you to plug in.
Okay, thank you.
You're welcome.
Just what's the name of that?
Oh,
Octavius McGee.
That's on this one?
Yeah, that's the only one with probation. Yeah, the others were just straight time.
Because. One more, right? Yeah, hers is 130, so one of them was
So I'm gonna finish reading it and I'll come back out here. I started. It's a Google thing. All right, so I'll be back. So I'm gonna go do next. You're welcome. Thanks for your patience.
I didn't know. How I had to do sit there, yeah, right. I wish that was the case.
No, sit there.
Did you find out what?
That's Robinson.
Whoever that is, they have possession of cocaine case.
Okay. What?
Charnay Robinson, that's the one that's in the the state system. Remember I emailed you a while back about it?
Oh, right, this is a WebEx or something. Well, she'll be appearing
Oh, good.
from prison.
We'll be on Zoom.
Is it P&A or?
Don't ask me, you got the calendar, read your calendars.
I will.
It is.
I was so focused on the Quentin McKenzie that I didn't look at anything else.
It is.
All right. I'll be here.
I'm not gonna, we're gonna appear via.
Well, I mean, I'll be here via Zoom.
Okay, we're gonna do Zoom in the afternoon. We have another conference like 1:30.
Okay.
I'm gonna come into the court.
I'll work it out with Darlene.
Oh, no. You tell them this.
I know, right? No. Before you leave, Ms. Hall, I have a question.
You got a question for me? Okay. I'm gonna see what I did. We still on, why we still on live?
I'll shut down.
You wrote all over my computer, guys.
This Mr. Webb, this case.
Why would you take it over?
Snyder's case.
We should print.
So, he was on a judicial hold.
I'm sorry.
It never was resolved.
I'm sorry. Okay, my bad. This is what I do. No, this is my fault.
She's in federal custody.
No, state.
State.
Ordered production. She wanted to come for the court. Want me to email you?
Yeah, please do. I have a procedure tomorrow. I'm nervous block. But I plan on.
I just sent you what you sent me.
All right. Thank you much.
You're welcome.
So really Tuesday, Thursday. One day, 8 and 1 day, hours and 7. Okay, let's talk this. That's why you were like. No, definitely. Yeah. Oh, see you later.
Let's go, Harry.
Well, I appreciate everything. Miss, oh, Miss Nelson. Miss Nelson, what are you doing?